What up, though? Biz Nation, let's stand up real quick. Let's get this party started. Let's get this party started right. She lead first in the building. What up, though? She lead first in the building saying good morning, good morning, good morning, good morning. This is day 105 of the trial, man. This is about to be crazy. This is about to be crazy. All right. We have Young Thug, Rico trial. And today is supposed to be the day where John Melnick, Woody's ex-lawyer, former lawyer, is going to be a part of this entire thing today. As a matter of fact, shout out to Thugger Daily. I'm about to go on his page real quick. And we're going to take a look at this. This is what we saw. She said, look like I'm feeling better. Yeah, I'm feeling good. I'm feeling good. I'm in the building. I'm feeling good. I'm in the building. I'm feeling good. I'm in the building. I'm feeling all right. I'm feeling good. Let's check this out real quick before they get started. It's about to be 4 minutes before they get started. But check out what happened on last week when we had Brian Steele talk about Melnick, man. So let's go ahead and check this out real quick. Recap a little bit.
He said, I really don't want, as I told you, I don't want a mistrial. I just want to make it right. And I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you make a credibility determination. Adrian Love, John Melnick's statement. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege. He's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript. So Mr. Weaver is either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript. And it said,
that is interesting, right? It's not on the transcript. So what Brian Steele is saying is, hey man, this is not what was said. It's not been recorded, and it hasn't been recorded on purpose. You know what I'm saying? So I want to bring in my boy Melnick. Want to bring in my boy Melnick. So that's what is about to happen today. Do you think Fonnie Willis is going to come in today? Wouldn't that be interesting? Wouldn't that be really interesting if Fonnie Willis stepped into court today? Oh man, I would actually want to see something like that. I would actually want to see something like that. We got a couple minutes before we get started with the YSL trial here. Judge Whitaker does start on time. She does start on time. She at least said, hey, Fonnie won't show up. I feel you. I don't think so either. It would be funny though. It would definitely be funny to see this. I know there was a motion that my man Mad Max filed. I believe I have it. Let me see. Put it on Adobe. I think I got it. Let's see here. Oh, it ain't showing up. Here we go. Got a little movement, got a little action. We got a little action. Good morning. Good morning. Again, if you are coming in, please hit the like button. Go ahead and subscribe to the channel. You feel me? We are about to get started in a minute. Your boy got the mauve and the brown. We got the, I'm feeling better. You know what I'm saying? Last week I struggled a little bit. I ain't gonna lie, I was struggling, man. Here we go. Let's go. Let's do this. Let's do this.
All right, I hope everybody had a pleasant, if busy weekend. I'm sure you all worked just like I did. I know we have Mr. Melnick outside and he wants to put some things on the record.
He is here.
And we can
Melnick is
do
in the
that.
building.
First off, is there anything anybody wants to address before that?
Your Honor, after or before Mr. Melnick addresses the court, if the court would be so kind as to just apprise the parties of what it is that we will need to, if anything, address
I mean,
as it relates to what he's putting on the record.
I don't really know. I think that he kind of mainly wants to make a record of what he perceives to have actually occurred. And I don't know that, as I think I mentioned on Friday, I'm not sure that it's particularly going to be relevant to any of the issues in the case, but I'm going to let him make a brief statement or proffer, and we'll go from there. And then the next issue after that I'd like for us to sort out is the representation made by Mr. Steele at the end of the day, Friday, that he has a good faith basis to believe that there may have been an unrecorded conversation at some point that included Ms. Hilton, Ms. Bumpus, and Mr. Copeland that may have resulted in some Brady material. So that'll be next up, and then we'll see after that. All right, so if somebody wants to let Mr. Melnick come on in.
And Your Honor, last thing,
Yeah.
I would just object to Mr. Melnick coming in offering anything that is not relevant to the trial itself,
Okay.
understanding what the court's ruled or
All right.
decided.
Thank you. Yeah, thank you.
Well, I'm nervous. Remember, she's by herself this week. Hilton is out of town. Hilton is out of town. She objected to right. She objected to Melnick saying anything. Really? You don't even know what he's about to say. You have no idea what he's about to say. Excuse me, I was eating my breakfast. I apologize. It's early, man. I gotta have my coffee. Mm-hmm.
Court with 500 screens in
Man, Miss Love is nervous as hell, man. You can tell he a lawyer for sure. He got that big briefcase.
Mr. Melnick, if you want to come on up, and I understand that you want to make a proffer of what occurred, I guess, on June 6th and June 7th. Let me just say that I think it goes without saying that people can perceive the same thing in different ways, depending upon the perspective they're standing at the time. And I am going to permit you to make a brief proffer of what you believe happened. I do not think, based on what I have reviewed, that you were laboring under any conflict of interest. I don't even know that at this point in time, any of that is particularly relevant, but I can understand you wanting to put something on the
I
record.
mean,
I would like for you to stick to the facts to the extent you can, keep emotion out of it. And go ahead.
So Judge, basically what it comes down to is after receiving the transcripts from the two ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the district attorney's office, and then with Ms. Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Shart and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue, because what I would need to produce from a documentary standpoint to rebut these allegations are privileged communications between myself and Mr. Copeland. But my presence, so starting with June the 6th, I sent an email to Ms. Hilton, Ms. Love, Mr. Steele, and Mr. Shart stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th, stating that Mr. Copeland was being given transactional immunity. At no point, and I think what really bothers me is that at no point did anybody from the DA's office before that time, within any relevant time frame, reach out to me and just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
With Mr. Copeland.
with Mr. Copeland that resolved in June of 2023. So I know that
yeah,
as of
let's
that
go.
point, you were representing him.
Yes.
And then following the resolution of that case, he did not have any more pending charges.
He did
correct?
not, that's
Okay.
correct, yeah.
All right, so that was a year ago.
So at a minimum, I feel it was incumbent on the district attorney's office to reach out to me just to ask that question. Now, as far as what communications took place between the DA's office and Mr. Copeland, I don't know exactly. But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity, because it was the state's intended purpose to call him as a witness on June the 7th. And so I was here on June the 7th. I told the court what Mr. Copeland's intentions were. There was a lot of back and forth. Obviously, Mr. Copeland was taken into custody on June the 7th, and then everything that happened on June the 10th. I don't have to go over all that.
Yeah, I've read all of that.
Yes. So my purpose here today is to state on the record that absolutely, nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots or anything along those lines with Mr. Steele or Mr. Shart or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that.
Mhm.
It's not an issue at all to this court.
Okay.
All right, thank you.
All right. That's it.
That's it?
So basically, they knew he was going to invoke the
Okay,
fifth
Mr.
before he went on the
Steele,
stand.
you
Mistrial.
had said to
Come on
us
now.
on Friday
That's a mistrial.
afternoon that you had a good faith basis for believing that there may have been a conversation you believe during the June 10th, ex parte in chambers meeting at some point when Judge Glanville was not in the room, but between Ms. Bumpus, who was acting as counsel for the day for Mr. Copeland and Prosecutor Hilton. So can you give me what your basis is for that? Otherwise, we might just move on.
I also have a couple of questions, if it's okay,
All right.
for Mr. Melvin.
Oh, well, I think may have already walked out. I didn't realize that. I thought this was kind of to let him have a chance to clear the record.
Whitaker, be quiet, man. Dang, let this man do his thing.
What are your questions going to be?
Just about the representations made about an email with a BCC and it was sent inadvertently. I believe that he'll say that that's not accurate. And then we sent your honorable court on Friday all of the emails. If you put them in order.
Yeah,
Does not-
okay. I mean, I've seen it. I think that's fine if you want to ask him that and clarify it. I don't think that Ms. Love made a representation that is in fact what happened. That was her theory because she couldn't figure out why Mr. Melnick was referring to her in the third person. But sure, you can ask him that.
What up, though, Ricky?
Okay,
Appreciate you
a couple more
watching, man.
questions.
Appreciate you watching.
And Your Honor, I'll move the admission of all those emails, and I have copies for them if that makes it easier, and we can mark them as an exhibit if that's what you want. They were already sent to your honorable court.
If you've got them now and can make them an exhibit, and I'm not sure exactly what courts, you would make them
Sure.
a defense exhibit.
Can I just step back for a second?
Sure.
And Your Honor, would the court be admitting those exhibits for any purpose as it relates to this trial?
No, not for the trial, just for whatever these ancillary proceedings are. I'm not sure what to call them, but motions.
Man, let's
So
go
it'll
ahead and get
be,
this mistrial going, man.
I
Y'all
guess,
stop,
an
y'all stop
exhibit
playing with us.
to- We can
Stop
call
playing
this
with
a
us.
motions hearing.
Everybody put mistrial in the chat.
It's today, August 5th, 2024.
Put mistrial in the chat
Proffer by
real quick.
Mr. Melnick.
This is crazy.
So, Mr. Melnick, have you looked at and reviewed all of the emails that you have given and the state has given on this topic?
Not-
Do you want me to be sworn? Do I need to be sworn for this? I don't believe I've been sworn.
Not for me. You're an officer of the court.
Yes, I have.
Hang on. Yes, Ms. Love.
You responded to what I was asking.
Okay.
Miss Love, shut up, man. You need to be sworn in. You the only witness. You was in the
I
ex
reviewed
parte.
them.
You the witness.
I have to mark these.
Uh-huh.
You could-
Oh boy.
Yep.
Miss Love, something else, man. She is a snake. If I ain't seen one before in my life.
You could have to stick- I'm just putting them in
Sure.
date and time order.
Yep, I've reviewed them.
Oh, Officer Brown. Mhm. If you think Whitaker is going to rule a mistrial today, put a 1 in the chat. If you don't think so, put a 0 in the chat. If you don't think so, it's hard to determine with her, man. She's a very, very I'm gonna say she's a very. It's hard to read her, man. Sometimes she's on the prosecution side, sometimes she's on the defense. Well, I guess that's the way she's supposed to be. She is a judge, so it makes sense, you know. But this is very interesting, man. Oh, Ricky said 0. I feel you though. I feel you, Rick. I feel you, man. I would love for it to be a mistrial because it's so much evidence for it to be one. But man, I just doubt she's going to do. I think she wants to really go ahead and do this. I think she really wants to go through with this, man. Chill said, I don't know. Could go either way, to be honest. I feel you. It can. It's toss up.
7 to 11:56, we have that. No, we'll go through once the judge is ready.
I'm ready whenever you are.
Okay, I thought you were not ready. All right, and thank you, Your Honor. Mr. Melnick, thank you for your time.
Sure.
What you said to this honorable court is that you represented Mr. Copeland in an unrelated case. Is that true?
That's correct.
All right. Was there any discussion with the Fulton County District Attorney's Office members that you represented Mr. Copeland for purposes of being a witness in this trial that's before the Honorable Judge Whitaker?
Yes.
Can you explain that to us?
It goes back to 2021. I met with Don Geary, who at the time was, I guess, in charge of the state's handling of this case. And he talked to me extensively about Mr. Copeland's involvement with YSL and the fact that the state wished to use him as a witness in this case.
And did you make it clear from your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker,
Yes.
as a witness or as a potential co-defendant?
Yes.
Okay. And that the Honorable Court knows, I believe, but to your knowledge, who is Don Geary in 2021?
What he introduced himself. I mean, I knew Don for a long time, but what he said, he was special counsel for the Fulton County District Attorney's Office. He was basically hired almost like in an of counsel position, as I understand it.
And was he affiliated on working this case that's before Judge Whitaker
Yes.
on trial?
We talked about this case specifically.
At any time, I'm sorry.
And nothing else.
At any time, did you or any member of the District Attorney's Office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Did you ever have conversations with Ms. Love, who is seated to your left,
Yes.
about representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
And was it clear from your standpoint, from your viewpoint, as the court said, people can observe things differently, but from your standpoint, was it clear that you made it known to the Fulton County District Attorney's Office that you were representing Mr. Copeland as a witness or potential witness in this trial?
Yes, it was.
All right. Did you do anything to separate yourself from that representation?
No.
All right. The Honorable Court stated a little while ago, and you left here so quickly, but that your representation ended of Mr. Copeland, I heard, in 2023 when you entered some sort of disposition. I don't remember what it was, before this Honorable Court. And when I say this Honorable Court, I'm talking about Judge Whitaker.
Sure. That's correct.
Did your representation end of Mr. Copeland as a witness in this case? Did
No.
you ever make that known to anybody?
No, I never did.
Did you actually do the opposite?
I was contacted by another member of the Fulton County District Attorney's Office in June of 2023.
And about
Yes,
what?
I'm sorry, about representing Mr. Copeland in this, as a witness in this case.
Were there any agreements between Mr. Copeland and yourself in the District Attorney's Office? Because you obviously got him not to be charged, or that's a bad way of saying it, but you obviously did or someone did something that he's not charged in this case.
I would honestly say that may not have been due to anything that I did or said necessarily. I think it was an internal decision from the DA's office.
Okay. All right. Now, I'd like to show you what I marked, and I just want this for the record. And I marked it number 1, Mr. Williams. And can you announce it just so the court, and we're going to give all this to the court, what this is, if you recognize it.
Sure.
And then go to number 2, 3. But for people looking on, just announce it by the title, if you don't mind. If you don't recognize it, please say that as well.
No, I recognize this. This is an email I sent to Ms. Love, Ms. Hilton from the DA's office, yourself and Mr. Short, dated June the 6th, 2024 at 4:31 p.m. you want me to read it or?
Sure.
Says, good afternoon. All it has come to my attention that the Fulton County District Attorney's Office has questioned my client Kenneth Copeland without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the
Wait, it's
I
way
am
too
going
fast
fast,
for the
I'm
court
sorry.
reporter to take down.
You're with me, law enforcement, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
Okay. On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use immunity, transactional immunity, any type of agreement?
There was no response from the district attorney's office to this email to me. So I was not aware of any immunity, any offer of immunity.
This is
to
crazy.
Mr. Copeland at that time.
Did you personally know that if Mr. Copeland testified at this trial without some sort of protection, by protection, I mean whatever type of immunity, that he could be making statements that would incriminate himself?
Yes.
No statute of limitations ran, he could be charged?
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm going to overrule that.
I can't say with absolute certainty that I investigated it to the point where I would know whether the statute of limitations would have run or not.
About federal crimes for gun offenses?
No, as far as I know, again, I didn't do extensive research into it, but it's my understanding that it would not have run in terms of the federal statute. And Mr. Copeland, of course, has been charged previously and convicted in U.S. District Court. So once the feds have their eyes on you, they have their eyes on you.
And how about as a co-defendant in this case being indicted later? And is statute of limitations barred to that?
I don't know.
Okay, that's fine.
I don't know with absolute certainty.
Okay. Were you concerned that if he testified, when you wrote this email, the one you just announced as Mr. Williams #1, that he could be facing criminal liability?
I absolutely was.
All right. Is that the reason you wrote that email?
Among other things, but that is one reason why I wrote the email.
Was there anything in your mind at the time of sending it that was suspicious or clandestine or by CCing the Honorable Maxwell Shard or myself on that email?
Not at all. I thought everybody had a right to know.
Okay. And everybody being?
Everybody from the prosecution and the defense team.
Okay. All right. Your Honor, I move for the admission of Mr. Williams #1 for purposes of this hearing.
Admitted.
Can I just get clarification as to which of the emails we don't have the number is Defendant Williams #1?
Can you
Yeah.
clarify?
June 6, 2024, 4:31 p.m. to yourself, Ms. Hilton, Mr. Steele, Mr. Shaw.
Does it have the response at 4:57:05 from Ms. Hilton, or is it the one without response?
I don't remember seeing a response.
Okay.
So is there a response on there
There's not a response
on Williams 1?
There will be, Your Honor.
Okay,
Not on
so
this
that
Williams
has
one.
been, for purposes of the record, the one that does not have the response on it.
Okay.
Love, man. You trying
So
it.
here's
You
the-
trying.
But well,
Is it a part of Williams 1?
No, it's not.
Okay, so I assume Mr. Steele might ask you about the next one. Go ahead.
and that is, I'd like to show you what's in front of you, Mr. Williams, exhibit #2 for purposes of today's hearing, okay?
Mhm. Yes.
Tell us, take your time to look at it. Tell us if you can identify it, if it's true and accurate for what it appears.
I hope this is from Miss, I think exclusively from Miss Hilton to me.
But do you recognize it?
I do, I
Is
recognize
that
it.
accurate?
Yes, it is. Yeah.
Okay. Your Honor, I move for purposes of this hearing, Mr. Williams #2, after you identify it so everyone knows what you're looking for.
June 6, 2024, 4:57 p.m. I hope good as addressed to me. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then it's from Ms. Hilton.
And did you respond to that email? And if yes, is it on Mr. Williams #2? And what does it say in time and date? If you don't-
It is. I did respond. It's dated June 6th at 5:47 PM, again with CCs to everybody in the case. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Miss Love.
Slow down.
I spoke with Miss Love early in the process around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
And the court already admitted number 2. If you could go to number 3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams, number 2.
It's admitted, and that one contains both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat, some withdrawing. Okay. Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it? And if yes, what is it?
It's a,
Your Honor, if we could just have what that is, and you don't have numbers on it, if I could just have what it is that you're even tendering.
I don't know, I don't know how many things you got handed, but Mr. Melnick's about to describe it.
it's dated June 7th, 2024, 11:52 a.m. It's from me to Miss Hilton and Miss Love. The first sentence says, here is a communication between myself and Miss Love, which pertains directly to the YSL case. And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Miss Love, stating, good morning, Miss Rosser. State asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. And I'm sorry, that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case in 2023.
All right, and you're forwarding that in June of 2024 to say, see, you knew at some point I
Yes.
was representing him. Okay.
That's correct, Judge.
Is that document, is defendant Williams a 3-page document or just the one portion of the chain that you just?
So is this is a continuation of
Yes.
3? Okay. There's more to it, Ms. Love.
Is it a 3-page
It
document?
appears to be, I think it appears to be a 3-page document, yes.
Yes, yes. Okay.
We
Do
move,
you need me to, I don't need to read all of this.
No, I don't think so.
we move for the admission of Mr. Williams, number 3, for purpose of today's hearing.
It's admitted.
Why did you, Mr. Malik, why did you send this to the district attorney's office on June 7th, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Miss Love,
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
yes.
All right. Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this?
I do.
What is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Miss Hilton and Miss Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office company that answers my phone for me, where I got a message from Peter Herzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Ms. Hilton and Ms. Love, demonstrating that they should have just communicated with me about Copeland before questioning him.
And go ahead. I'm sorry.
And before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herezog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Herzog is the assistant DA in the Fulton DA's office.
And Mr. Williams, what's marked as number 4 is sent for that message on June 27, 2023, about 3 months after the March 1, 2023
Yes,
correspondence with Ms. Love about Mr. Copeland.
that's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker, by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that what you're
Yes.
asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back to check the
If
date.
y'all have the case number, I can look it up and let you know the disposition date.
I don't have it.
Happy to do that. Nobody has it.
It may be-
It was a 22 SC case, but that's all I know. It's fine. I can probably pull it up some other way. Y'all go ahead.
Okay. And you forward this, you said why? This
To-
message.
To reiterate the fact that the Fulton DA's office knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Herzog was never involved in the case before Judge Whitaker. I'd never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abadi. And the only reason Mr. Abadi was involved with it, that's Adam Abadi from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Ms. Love, because she.
And Ms. Bond, yes, right. And
Same
Ms. Love with
reason.
the bond order, that's correct.
Now, I'd like to show you Mr. Williams, number 5. Oh,
Can
Your
I-
Honor, I
can
move
I-
for the admission of Mr. Williams, number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
Number 4, a one-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams, number 5. Tell us if you remember that, look at it.
I do.
Okay, and is it accurate?
It is.
Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
Stated June the 7th of 2024. It's to Ms. Love and Ms. Hilton from me. And it is in response to an email that I received. I'm sorry.
That's okay. You can look at the documents, multiple.
Yeah, okay. So this is a part of the same chain of documents where I was referencing the fact that Ms. Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March the 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And then so the last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Shart's client. neither of whom I've ever met or have any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Shard do anything?
No.
Did anybody come to you, at you about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville,
Yeah, I would
grant
object
your
to
client.
the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote or what I.
All right, well, I don't know yet what the end of the question's going to be, so I'll hold your objection until I hear the question.
It's in the
Exactly.
record. Already, Your Honor, I could get another copy though. Ms. Love wrote in that motion seeking use immunity under 25-5-507 for Mr. Copeland.
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission, Williams 5?
I do, yes.
All right, that's admitted.
Fact, she is scared out of her mind. You have been found out, lady.
And Williams 5 is what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are
questions.
you asking?
for
Hang on,
you.
hang on, Mr. Steele. What are you asking? What it is?
Which one is it? Yes.
It's
Just
the last
part
one
of
they
what
discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just.
Peppery my ass.
clarification.
He said F
I
yourself.
don't know. 4
That's
pages.
more than pepper, dog.
Mr.
That's
Melnick,
crushed
are there any
red right there.
BCC, you know what a BCC is? Yes. Okay, I apologize. Yes.
Yeah.
Are there any-
We're all old enough to know that that means blind carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC'd don't know.
Yes, I did not blind
Mhm.
copy anybody on that last email. I just sent it to Ms. Hilton as well.
Any
I
out-
told him as well.
I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
All right. I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right, I'll let Mr. Sharp go.
Let's go. This is good, y'all. This is prosecutorial misconduct at its finest. You understand me?
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
As part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland. Yes, sir. Did you also make it known, did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation to your knowledge and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would have happened.
He should have asked that differently.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I will be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes,
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week leading up to June 7th of 2024?
Yes, let me ask in a more precise manner.
Mhm.
Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes,
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called
Could you say it again?
me. You called me.
You being
Yes.
Max Scher?
Yes,
Okay. And I called you on the telephone?
yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question?
Oh, let's go.
In
Burn.
your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's law school 101.
And is that what I did on Thursday, June 6, 2024?
Yes,
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yes.
throughout this entire period, correct?
Mhm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
to my knowledge, no.
Okay, after you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
Remember, we talked about that.
All right. Any
What
other
about derivative
defense
use?
attorney with questions for Mr. Milnick? All right, hearing no other. Go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, I'm just gonna be a little bit brief and I'm gonna clarify some things. Is defendants Williams exhibit? Yes, Mr. Hart.
Or speak just more loudly,
Fair.
or come around and, yeah,
You know what? I'll take the stand.
okay.
Let's
Does somebody have a copy of those exhibits for the court?
Judge,
go,
I'll
dog.
give to the court the ones that he has admitted, and I'll just go ahead and use the ones that I have copies.
Okay, thank you.
Oh, she wearing pants today. She mean business, huh?
Just pull that mic down towards you and make sure. that
I don't think so. I don't think
everything's on.
Melody don't like her, man.
Mr. Malnick, there
Oh.
should be some buttons somewhere.
You see where it is?
Room's green.
I don't actually see it. It sounds to me like it's on.
Yeah, sounds like it's on. All right, go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, and Your Honor, I'm going to use, unless the court instructs me otherwise, I'm going to use the copies that I was given, that I've marked as defendants the way that they've indicated they should be marked exhibits.
Okay.
Okay. Mr. Melnick, I'm showing you what is the copy of Defendant's Exhibit 1
Yes.
that was given to the state and to the court. Is this an exact copy of Defendant's Exhibit 1 that I'm showing you?
I believe so. I mean, I haven't printed them up. I don't know if there was another email that was.
Y'all are welcome to just use these if you want. That doesn't need to be an issue. I mean, they were handed to you, Ms. Love, by Mr. Steele, right?
Yes, Your Honor.
All right, then they ought to be exact copies.
May I refer to them?
Just a second. Mr. Harvey, yes, can you not hear? Oh, me? Okay, sorry. I was just saying, I'm sure that the copies are the same, unless, but if she wants to use the admitted copies, she can. I'll
This-
trade you. How about that?
Yes.
This is ridiculous. Yes, they're the exact copies. I mean, he just gave them to you. What are you talking about? This is just ridiculous. She's the worst lawyer
Just make
ever.
sure
man.
you get the admitted copies to the court reporter when we're finished with this.
Yes.
They're the exact same paper. Stupid.
So showing you what has been admitted as Defendant Williams Exhibit Number 1.
Yes.
Looking at Defendant Williams Exhibit Number 1, is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
Then I'm going to show you Defendant Your Honor, I just may need the portions that I gave to the court because I don't see.
All right, here you go.
Yep. Thank you. All right. All right. Showing you what I will mark as State's Exhibit one, copy of Defendant Williams Exhibit 1, Melvin Crawford. And I was provided this by Mr. Williams, Your Honor.
By Mr. Steele.
Yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a one-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be, there may have been a prior email, but I don't I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as Defendant Williams Exhibit number 2. Let's see if those two match. Give me 1 second, okay? Defendant Williams Exhibit 2. So you'd agree with me that
So
Defendant Williams Exhibit 2 is in fact the top portion of the email that I have labeled and tendered as State's Exhibit, or not yet tendered, but labeled as State's Exhibit 1.
yes, that's correct.
Your Honor, the state tenders State's Exhibit 1 just as evidence.
All right,
All right. Now,
admitted.
thank you, Deb. So looking at Defendant Williams Exhibit 2 and State's Exhibit 1, are you able now to say with any more clarity that Defendant Williams Exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within Defendant Williams 2 and State's Exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up. I wasn't there in his office when he did that or whenever somebody in his office did that. You are correct that what has been marked here as Mr. Williams Exhibit number 2 is part of a chain of communications between myself, yourself, Ms. Hilton, Mr. Steele, and Mr. Shart. Looks like there's a CC to Antonio Long as well. Yeah, so but these emails were sent after the State's Exhibit 1, which is also Mr. Williams Exhibit number 1. These emails dated, so you can see here, Ms. Love, this is dated June 6, 2024, 5:47 p.m. Yeah, this is dated June 6, 2024, 4:31 p.m. Right. So this is crazy. Just part of the same line of communications that we were having, where I said, Mr. Copeland doesn't want to plead, doesn't want to testify, wants to take the fifth. Ms. Hilton responds, and then I respond to her response. And in her response, this is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled Defendant Williams Exhibit 1. Did you ever forward that separately to Mr. Steele or Mr. Sharp?
I think I just forwarded. I mean, I wouldn't have had to because they got the emails. Right. Okay. So they got this email initially.
Y'all, when y'all are saying this email, we have no idea what you mean. Can you refer to the exhibit numbers?
They got Mr. Williams email number 1, exhibit number 1, which is the first email from June 6th at roughly 4:30 p.m. Then there was a response from Ms. Hilton, June 6th, 4:57 p.m.
And that's marked Williams 2.
Williams 2. Thank you. And then I respond to that June 6th, 5:47 p.m.
Okay, so
and that's also on Williams
2,
right?
Yes.
Yeah. Okay.
So as it pertains to my original question, Defendant Williams Exhibit 1 was never a communication that you sent separate from the emails that are contained in Defendant Williams 2 and State's Exhibit 1. Is that wrong or right?
That is wrong.
Okay, so you sent, without forwarding the rest of what is labeled as Defendant Williams 2 and State's Exhibit 1, you sent an email that contained only the document that is labeled Defendant's Exhibit 1 to Mr. Sharp, Mr. Steele, Ms. Hilton, and myself.
I sent it on June the 6th at 4:30.
Right. And do you also see
Jesus.
June 6th
Help her.
4:31 p.m. And when you say 4:30, you do mean 4:31 p.m.?
Yes.
Do you also see June 6th,
Exactly.
2024 at 4:31 p.m. on the email State's Exhibit 1?
Yes.
And in fact, the email State's Exhibit 1 is at the bottom, meaning it came before
Yes.
the emails that were Defendant Williams Exhibit 2.
That is correct.
Okay.
She need a comfort break.
So is given that State's Exhibit 1 looks as it does,
Mhm.
are you saying that the email that is Defendant Williams 1 is the entirety and not a part of any other email chain that you said?
This email was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams' Exhibit number 1. Was the first email sent on June the 6th of 2024.
Okay.
That is the first email. Mr. Williams' Exhibit number 2 is the continuation of that chain of emails in which Ms. Hilton responded to me, and then I responded to everybody else.
Okay.
Yeah, she
including
is. I was just about to say the same thing.
Mhm.
Your Honor, I'm going to give back to the court's copies of the emails.
Okay.
Thank you. And I apologize, they're not. That's fine.
What is wrong with Miss Love, man? What is wrong with her? It
You
doesn't
were
matter.
asked, Mr. Melnick, about,
I'm sorry, y'all. That's their audio.
you were asked by Mr. Sharp, how did you become aware that the state was talking to Mr. Copeland? Do you-
Okay, let's try to figure out where that squelch is coming from.
Might
and
be from
maybe-
me. I may have been too close.
Okay,
to the
where's
microphone.
State's one, Miss Love?
And Your Honor.
Yeah, that audio
was
crazy.
Yeah, you did. It's submitted. Thank you.
Did we clear up the squelch? Is it gone? Okay.
It seems to be.
It might be the judge.
Is it the court's mic?
Man, I wish I was there. I would do audio for them.
Okay.
Jesus.
I'll step away from it so that I'm not echoing. Mr. Melnick, do you remember Mr. Shard asking you, how did you become aware that the state was talking to Mr. Copeland?
Yes,
And did you understand that question to me in 2024?
leading up to June 7th of 2024, yes.
Did you answer how you became aware that the state was talking to Mr. Copeland?
I did,
How did you become aware?
because Mr. Shar told me.
Okay. And when Mr. Sharp called you, was that the first time that you were aware that the state had been talking to Mr. Copeland?
Since, I mean, I was aware of an interview that took place with, I think it was investigator Viverito. I don't remember the date of that interview, but it was during a time when I was representing Mr. Copeland. But other than that particular communication, that was the first time I became aware of any direct communication between the district attorney's office and Mr. Copeland.
And when you speak of the interview by investigator Viverito, was
Mhm.
that while she was with the DA's office or while she was with the Atlanta Police Department?
I do not know.
And was that interview one that you have seen or have knowledge as a part of the discovery in this case, or something different?
I have knowledge of it. I've never seen the interview. I know that it exists.
And was that interview a formal interview while he was in custody at the jail?
Yes, as I recall. I mean, I haven't seen the interview, but I believe he was in custody at the time.
And did you give permission for that interview? I'm gonna turn this off.
Just speak loudly.
Did you give permission for that interview, or did Mr. Copeland reach out to investigator Viverito to talk to her?
I have no idea. I did not give permission for that interview. I do not know if Copeland reached out to her or not.
And had you been paid by Mr. Copeland or retained by Mr. Copeland to represent him on criminal charges at that time?
Yes,
And was that prior to March of 2023 that this interview took place?
yes.
Do you recall at any time representing to any member of the district attorney's office in 2023 that Mr. Copeland had not paid you for your services?
No.
Do you recall telling a member of the district attorney's office that you were not representing Mr. Copeland on his criminal charges because he had not paid you? I'm just asking if you remember. If you don't, that's
I
fine.
don't.
Okay.
No, I represented him in his criminal charges to the end.
We understand.
Whether he got retained or
And
not,
when Mr.
he's
Sharp
been
called
representing them.
you,
Jesus.
What was it? What did he say to you exactly?
He said that Mr. Copeland was being called as a witness the next day, June the 7th of 2024.
So at what point how did he tell you that the state had been talking to you?
During the course of that conversation,
What did he tell you that?
he just said that the state's been speaking to Mr. Copeland.
How many times have you spoken with Kenneth Copeland between the time that Mr. Sharp called you and the time that you resolved his criminal matter before?
How many times did I speak with him between June of 23 and June of 24? I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes,
And during your communication with him, did he always have access to your phone?
always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I
Dang.
don't feel comfortable.
I can stop and pull that question all the way back.
All right.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland?
I'm not going to talk about anything I said to Mr. Copeland, period. I'm not going to talk about anything that I said to Mr. Copeland.
Okay.
You know this, no? Love, you know this. This is, you know that's inappropriate.
Already testified. Is it safe to say Mr. Copeland didn't reach out to you and say to you?
I'm not going to talk about any communication I had with Mr. Copeland.
Look at the judge, dog. Look at the judge.
Do you have any idea why it would be Mr. Sharp who first alerted you that the state was talking to Mr. Copeland?
No.
And are you aware of any communications Mr. Copeland made to the state as it pertains to your representation of him after his criminal case was resolved?
I'm not.
Do you recall, you indicated that you spoke with Mr. Abadi, the district attorney's office, regarding Mr. Copeland as a witness in the case that we are in trial on.
Yes.
Do you recall telling Mr. Abadi that you were not representing Mr. Copeland beyond the criminal case?
No.
Was the time or times that you spoke with Mr. Abadi in the context of resolving or getting a bond for Mr. Copeland's criminal charge?
It was primarily with regard to the bond and the underlying criminal charges. I don't believe Mr. Abadi has much, if any, involvement in this case.
What is your recollection of what it was that you said to Mr. Abadi or anyone else regarding your representation of Kenneth Copeland beyond his criminal charges?
I don't really recall having, other than the fact that, you know, he's talked to me and I've talked to the state, I don't recall having in-depth conversations about it. Y'all were still in the middle of jury selection. It wasn't much of an issue.
Understanding you don't recall having in-depth conversations about it, what is it that you recall telling Mr. Abadi or any other member of the state about your representation of Kenneth Copeland beyond his criminal charges?
I don't really have any independent recollection of anything specific.
How are you then able to say that you spoke with members of the state and told them that you represented Kenneth Copeland in his capacity as a witness in this trial?
Because I had specific conversations with Don Geary about this case and about.
He said that
desire
already.
to use Mr. Copeland as a
That was-
witness.
Am I correct that that was pre-indictment?
Yes,
And am I correct that that was at a time when there was at least a prospect that Mr. Copeland would be a defendant and not only a witness?
that's correct.
So apart from the conversation you had with Don Geary pre-indictment, where there was a prospect that Mr. Copeland would be on the indictment, do you have any recollection of
I know, right?
conversations that you've had with members of the district attorney's office regarding your representation of Kenneth Copeland as a witness in the current case 22 SC 183572?
Ms. Love, we did not have substantive discussions about what his testimony would be, but everybody in your office knew that I was representing Kenneth Copeland.
Period.
I don't mean substantive. I'm asking you simply, do you recall what it was, if anything, you said to either Mr. Abadi or any other member of the district attorney's office regarding your representation of Kenneth Copeland as a witness only in the current case 22 SC 1835?
Just that I'm representing him.
And you recall specifically saying to some member of the DA's office, apart from the criminal charges that you helped resolve.
She's slow.
2023, you recall
The man
saying
was
to a member
retained.
of the district attorney's office,
Oh
I'm
my God.
representing Kenneth Copeland as a witness.
I can't.
only In the YSL trial.
I said that to you, okay?
That is your memory.
Yes.
Where was this? Was it on the phone?
Yes.
Okay.
D-
And
You-
what was it? Was it before or after Mr. Copeland resolved his criminal charge?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did
I
you say?
can't,
about
man.
her?
I said that I was representing him, and if you want to talk to him, talk to me.
And when you said you were representing him, isn't it true that you were talking about this criminal charge?
No, Miss Love, it's not true.
Did
And
you state that you were representing him beyond this criminal charge?
Had you finished your answer?
that's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the
What is wrong with her?
572 case
Yes.
outside of the criminal charges?
Yes.
She is slow. Oh my God.
And did I hear you say
Jesus.
that it was your testimony that you never once indicated that Kenneth Copeland had not paid you and you weren't even representing him in the criminal?
No.
She's
So
so.
is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Copeland
About what?
about his criminal charge?
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
Right.
That wasn't the question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland. Okay.
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client. Okay?
And if you would mind answering whether or not you recall.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway, so let's wrap things up.
Yes.
Wrap it up, baby girl. Wrap it up, boo.
When you spoke about Mr. Herzog and you said he was never involved in the case, do you know what it was that he was talking about?
He was calling me about Mr. Copeland testifying in the YSL trial.
And you spoke with him
Yes,
and he said that?
yes.
And what did you tell him?
I told him that Mr. Copeland didn't want to testify.
Now, that was in March.
That was in June of 2023.
And did Mr. Herzog ever say he was working on that trial?
That was my understanding of the purpose of his call to me.
Did he say he was working on it?
Yes.
You indicated, and Your Honor, I have about 5 more questions.
All right.
You
She got 5
indicated
more questions.
that,
This chick is crazy.
upon questioning by Mr. Steele, that your concern regarding the district attorney's office communication with Mr. Copeland was Mr. Copeland's criminal exposure, and that the DA's office was seeking use immunity. And that you considered it ironic that a motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying?
I do.
that? You never once asked the district attorney's office what protections the immunity afforded to Mr. Copeland.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms.
I'm
Wilson
sorry, dog.
in the presence of an investigator that you had never heard of OCGA 245507?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally.
Most of the time, use
right,
immunity doesn't.
the email that is labeled Defendant Williams Exhibit Number 5. You wrote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client."
Yes.
So what specifically did you intend to, you didn't include in here anything particular that you were worried about with the immunity deal, but you were very specific about Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Now, are you asserting that he is in danger from any member of the state from testifying?
No.
And what specifically did you want, more specifically, in the, because you do understand it's not an immunity deal. We can't use anything he says in any way against him.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he had received that, what much more specific information did you want to see in the meeting?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity?
This is a
for
fact.
Anything he was asked about criminally, whether it was from. the
She is
state or
wasting
the
our
feds?
time.
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him, to prosecute him regarding those acts. You didn't understand
It protects him from from his testimony at trial being used against him, Ms.
that.
Love.
And anything derived from that.
And anything
testimony,
derived
you're
from that
aware of
testimony.
Anything derived from that testimony, are you aware of that?
Yes, ma'am.
So.
Good
given
point.
that, Mr. Copeland
You don't have
could
one.
not
That's right.
be prosecuted for anything he testified about criminally. And the state could not use his testimony to go seek additional information or reasons to prosecute him, what is it that you would have been seeking to get?
So we are getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all in the state?
Yes.
And could you tell us just why it is that you would have felt that that was
I think that's,
something that should have been avoided?
I'm not going to get
even
into
if it
that.
did not?
I'm not going to get into that, Ms. Love. I'm not going to get into that.
This is crazy.
Yeah, I think that's all that I have to think.
All right, is there any further questioning?
Oh, she is outside of her mind, yo.
Okay, Mr.
Did she
Melnick,
walk
at
all
this
the way
time,
around
you
that
can
damn
actually
table?
go.
Thank
Thank you for your time.
We need a break, Judge.
All right, let's move on to the next issue. All right,
No, we need a break.
we're done with this, right?
This chick
Everybody
walked
satisfied?
around that damn table.
Judge, I'll just proffer on the record, and without calling unless the court, finds it necessary, that, the lawyer who was.
Hang on just a second. Yes, sir?
I do not accept any proffer by Ms. Love. I've told the court that before, but that remains.
All right,
I'm rejecting it. She
Your
wants
Honor,
to
I'm not-
testify, then that's fine.
don't talk while somebody else is talking. Let him finish, let me rule, then you can go ahead. I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not, it's for the court to accept or not. Go ahead.
That Mr. Abadi, who was, earlier present in court, was on the call that I think Mr. Melvin referenced that he had regarding, he said he spoke to Mr. Abadi about Mr. Copeland and his representation of Mr. Copeland as a witness in this case.
Mhm.
Mr. Abadi would testify that, Mr. Melvin specifically and explicitly said that he didn't want to have anything to do with his YSL case, that he would not represent him in his capacity as a witness in this case, and that he was.
She is crazy.
That was it. I believe that he made some reference to Ms. Marcelson or something like that. I don't remember exactly, but if necessary, I will bring Mr. Biden back at some point to testify.
All right, well, if I am presented with a motion that makes that testimony relevant, then we'll hear from him at that time. My point in all of this was just so that Mr. Melnick could feel like he'd cleared his name. All right. Okay, so, anybody need a restroom break before we move
Yes.
to our next topic? All right, let's take 12 minutes and be back at 10:30.
Yes.
And Your Honor, there's the omitted parts of the transcript. I just want to let you know before we move on to something else.
Omitted parts of the transcript. Yeah, that's what the next topic's going to be. Yes.
Yes. Actual evidence. Okay. Okay. What the hell just happened, dog? Yo, first of all, I gotta say this, man. Anytime a person walk around the table to get to their seat, when you can just walk right next to yourself, right next to your seat, you have shown us that you disrespectful, you crazy. And that was a low-key way of saying you could kiss my ass. She is so inappropriate, man. She is so inappropriate. Okay, let me get to the comments real quick because I can't right now. Let me collect. Let me collect myself, man. This is absolutely insanity. Insanity, okay? You're trying, first of all, telling a lawyer what use immunity is is so slow, man. You don't think he know what derivative use or use immunity is? It just protects you from your own statements in a case, in a trial. It doesn't do anything else. You know, if you have, it protects your actual testimony. That's all it does. Absolute immunity protects you, period. Like prosecutors, according to the 11th Amendment, have absolute immunity. They have immunity. This is the reason why prosecutors can do whatever they want. That's how they feel. Prosecutors are just like bad cops. A bad cop think he could just do whatever because he got a badge. That's the same way with the DAs, man. They're like, oh, I'm a prosecutor, so I can do whatever I want. And it's bull, it's BS, man. This is BS. All right, let me go up some, everybody. Oh my God, man. Oh my God. Let me get to the comments. Shout out to Chill. Appreciate you coming on in, saying please hit the like button as you come on in if you haven't done so already. Abundance is in the house. I appreciate you, Abundance. Abundance said, oh, don't be talking while other folks is talking, middle of. You know what? The question really got me. The question that really got me so confused, I was scratching my bald head, is when she asked him, did the state talk to you about going to Mr. Copeland about his criminal charges? What? The question was so stupid, I had to write it down. Okay. What? The state don't have to talk to me to tell me about my client's criminal charges. Okay. What is wrong with you? Miss Love is going crazy. She said the judge like, oh child. Oh man. Don't let Melnick leave. We need to discuss Woody and Nut. We just need, that is important, as well as this whole thing about the omission of certain things in the transcript, which is, I'd said to see, this is why people don't understand certain things. But I made a video about we did a reaction video about a few things in the transcript that did not look correct. It looked like it was some stuff omitted. They didn't redact anything, but they edited the transcript. And when I saw the edits, I'm like, wait a minute. Why is the transcript so jumpy? Like it goes from one subject matter to a different one, and they're not in the same alignment. They're not even connected. And I'm like, okay, what is going on with that? And now we see Steele is going to talk about things that are omitted from the transcript. Oh my goodness. Unbelievable. See, this is the reason why I do what I do. I love doing this, by the way. And I thank you all for watching with me. I appreciate you all so much. Y'all cracking up. Said Love is a loose cannon, and I thought Hilton was crazy. No, Hilton is the same one between the two. Hilton is the same one. Miss Love showed us that she has a legit crazy going on. Okay. She walked around that damn table, y'all. She walked around that damn table, okay? She walked around that damn table this way. You understand what I'm saying to you? This case keeps getting worse every day. Absolutely. Felicia Fee, what up, though? She says, good morning, everyone. Morning, everyone. Says that hearing was just a clear representation here. Exactly. That's all it pretty much was. And I mean, it was entertaining. It was definitely entertaining for sure. It just confirmed and on record that Melnick was on record and being his counsel. Absolutely. And see, more important than that, though. I mean, let's go a little bit deeper in that. Not only the fact that he was representing him on the record, which they said he wasn't, but he was. The fact that they knew that Kenneth Copeland, Woody, was going to testify and plead the fifth on the stand. That's why they rushed and granted use immunity to, and she said it out of her own mouth, to compel him to testify. When he already told you that my client plans on pleading the fifth. As a matter of fact, not only did he say it in the email, he said it in person on June 7th that morning, that my client is invoking his Fifth Amendment right. Okay. And what did Woody do on that Friday? He invoked the fifth. They all knew it. That's what makes it even worse. Skip the fact that he had counsel. Let's just take counsel out of it. If a citizen that you're subpoenaed for as a witness. If a citizen says, I'm going to invoke my Fifth Amendment right, and you put me on the stand anyway, and I invoke my Fifth Amendment right in front of the jury, that's your fault. I told you that I was going to invoke my fifth. Immunity or not, I'm going to invoke it in front of the jury. You knew that. So again, that's another more evidence. All we saw is more evidence of why this needs to be a mistrial. That's what we just witnessed. We literally just saw that. We literally just saw this is the reason why it needs to be a mistrial. The fact that this happened on the day where the judge is saying that she's going to rule about the mistrial, makes it even more poetic. If we don't get it, look, we need to get a mistrial on this. This is absolutely this is prosecutorial misconduct. This is at its highest, okay? At its highest. Lee says, Glanville said that he was going to leave out certain parts. That's exactly what he said. In that transcript, he said, you know, I'm going to redact some of the transcript. That's what he used. That's the word he used at first. He said it over the mic. It's on record. And then weeks later, he's like, oh, I'm going to give you the full transcript. No, y'all been working on that transcript all those weeks to get it edited. So that way you can give it you gave a revised version of the ex parte meeting on June 10th. You didn't even tell them about the ex parte meeting on June 7th after court. You didn't let them know what you discussed or what was said. You know what I'm saying? Especially at a critical stage of a case. Lee said she strutted around that table. I mean, she strutted around that table to show you how crazy she is. To show you how crazy she is. This lady is nuts. This lady is nuts. There is a bunch of coercion going on. Hey, he said runway. Ricky said runway. She was on the runway, dog. I love the chat. Yo, the chat, man. I love y'all, man. Let me give y'all some love, man. Let me give y'all some love. Oh, I love the chat, man. Y'all are crazy. He said she went around that boy like a runway, dog. Yeah. This was absolutely entertaining, man. This is entertaining. I don't know what is wrong with Miss Love, man. Something's going on with her, man. So we know that the DA office was fully aware of Woody's representation years ago. Okay. We also know that they knew that he was going to invoke the Fifth Amendment. If you know that a witness is going to invoke the Fifth Amendment in front of a jury, if you have knowledge of that already, and you're not supposed to let that happen. You're not supposed to let that happen. You let that happen anyway because you're crazy. Immunity was given on the 7th. Remember that day? Remember when Woody hit the witness stand, and they slipped him a piece of paper? That was his first time seeing that immunity, and that was our first time seeing that immunity. Okay, that is insane. You go from one day, don't talk to my client. My client is saying, don't talk to me. Don't talk to him without the lawyer. And then you want to say, well, he's being subpoenaed to be a witness anyway, so he needs to be here. Then you're going to give him immunity while he's on the stand. You're going to give him the paperwork right then and there. Really? That's not how that goes. It doesn't go that way. It does not go that way. Okay. You can't give. I am a witness. You can subpoena me, yes, and I'll testify or not, yes. But if I decide not to testify, you can't force use immunity on me. And then Fonnie Willis, the one signed off on it. Fonnie Willis signed off on it, forcing immunity. Again, coercion. What was the word? Coercion. Because now they's like, well, if you don't testify, we're gonna have to put you in jail. Then he like, okay, I'll testify. If you don't testify, we're gonna hold you in willful contempt. Is that what they say? Willful contempt. We're gonna hold you in willful contempt. Okay. And so you're gonna have to testify. He's like, okay, I'll testify. So now he changed his mind. Because you told him you're gonna put him in jail. That would be a reason to testify if you don't want to go to jail. especially when you was just at the crib chilling, minding your business. Okay, I testify. Then the first question you ask, Woody, how old are you? What does that have to do with the case? You didn't ask any other witness their age. Why would you ask this man his age? The question was irrelevant. Okay, what number? I plead the fifth. You knew he was going to do this. You knew he was going to do this. Before the jury came in, the lawyer said, my client is going to invoke his Fifth Amendment right. He's invoking it right now. He said, I'm grown. Look, Woody said, I'm grown. Because it's a stupid question. Just like this was a stupid question. Did the state talk to you about going to Mr. Copeland about his criminal charges? What? Again, it was so stupid I had to write it down. I had to write it down. They knew exactly what was going to happen. Come on now, Felicia. They knew it. This is a mistrial This is a mistrial all which way. Okay. And again, if you didn't see my video about prosecutorial misconduct, we break down the ways that prosecutorial misconduct can cause mistrial or a dismissal of charges. You can have if the prosecution, and this happens all the time. Remember, from 1963 to 2013, in the state of New York, there were 3,625 cases where it showed prosecutorial misconduct. And only 63 lawyers, 63 prosecutors were actually openly disciplined. That's less than 2%. We talked about this yesterday in that video. So prosecutorial misconduct is so common. And it's so common. You have to, you would literally have to prove it to the wire that misconduct is going on. You got to prove it. And a lot of times they will do things like this, talking to people behind their lawyer, but they're telling you that I got a lawyer. Like I have a lawyer. I do not talk without my lawyer present. You can tell them that. I don't talk to anybody. I don't talk to any law enforcement. I don't talk to the courts. I don't talk to anybody without my lawyer present. I don't answer questions without my lawyer present. You have the right to remain silent. You have the right to remain silent. So if a prosecutor says, hey jury, the fact that Mr. So-and-so did not state or state their claim on why they are not guilty should show you that no, you can't say that because that's misconduct. That's inappropriate. But when you have prosecutorial misconduct so bad to the point where they even forcing people to take plea deals, because even if they're innocent, they're like, yo, I haven't even done anything. I haven't done what you're accusing me of. The first thing they do is bring you a plea deal. Prison is a business. We're going to talk about this one day. Prison is a business. The GEO Group, look up the GEO Group, GEO Group. Look up it's a business. And there are multiple companies that invest in prisons. They get money for this. Prison is a cash cow. That's all it is. That's all it is. All those plea deals, all that kind of stuff, all of that stuff, it's money involved, man. It's money. Private prisons, GEO Group. Look them up. We're going to talk about the GEO Group one day. Private prisons, man. Sheely says stupid is and stupid. They use that contempt as a scare tactic. Absolutely. Absolutely. And again, that is prosecutorial misconduct. See, this is the thing. Sometimes if you see a person with the rope, just let them do their own thing. You know what I'm saying? because it's going to catch up to them. And this is what's happening. From the beginning of this case to now, it has taken this long for it to put a light on the fact that the prosecution has been inappropriate like crazy. Inappropriate. Utilizing tactics and certain things to get their way. Having ex parte meetings. And the things that they discussed in these meetings are inappropriate prosecutorial misconduct. Unbelievable. Okay, so I'm not crazy. I work in the prison system and it's definitely a business. 100%. 100%. Again, I encourage everyone to look at the GEO group. We are back. Let's go.
Okay. Mr. Steele, move into our next topic.
I think,
Okay.
I do need to get.
Oh, I guess if Zoom's relevant, I better get on the Zoom also. So give me a second to do that also.
I'm pretty Zoom illiterate, so I might need a little assistance.
How can anybody be Zoom illiterate in this day and age after all of our COVID era Zooming?
I know enough to not turn myself into a cat.
Okay, if you can let me in, and I guess. Are we going to be hearing from somebody over Zoom?
I just have a brief TikTok that I need to play.
Really?
It's very brief.
Okay.
Well, this is part of the proffer, so it's your choice. I can do it or I cannot do it.
I
Your
have
Honor.
no idea what it's going to be.
I can tell you what it will be.
Why don't you tell me first?
This will be a TikTok of Mr. Copeland speaking to Miss Bumpus, where
Okay.
Mr. Copeland acknowledges that what is in the transcript the transcript is not complete from the June the 10th meeting.
Did Mr. Copeland read the transcript?
I don't know what Mr. Copeland has
Okay.
read or not.
So
If you don't want to hear it, then I can just do my proffer, Your Honor.
I mean, if that's what it says, it shows Ms. Bumpus talking to Mr. Copeland.
Believe it or not, yes, Your Honor.
Okay, and Mr. Copeland says, whatever. I mean, I don't care. Play it.
You can take it for what it's worth, Your
Yeah,
Honor.
I'll just.
Let me just, if I can begin with my proffer, then I can play this,
Okay.
Your Honor. It is my understanding, based on my conversations with Ms. Bumpus, that while the transcript may be, let me be more specific, the transcript of the June the 10th, 2024 ex parte meeting, and I'm not going to list everybody that was in the meeting, but that transcript was complete in the sense Bill was in the room
Mhm.
and the court reporter was in the room. I have no basis to believe that that transcript is incomplete for when Judge Glanville was in the room. But there was a portion of that morning, a significant portion of that morning, based on my understanding, where it was Ms. Hilton was in the room, Mr. Copeland was in the room, Ms. Bumpus was in the room.
And how do you how is that your understanding? Because I don't see that from the transcript. And I know I actually said that at some point, but I went back and looked, and let me reference y'all to, let me find it. All right, so the beginning of the transcript, it is just other than, it is, if we all look at page 3, President Chambers were Judge Glanville, ADA Love, Attorney Bumpus, Court Reporter Weaver, and investigators Long and Hamilton. And then they have a conversation that goes through page 22. On page 23, the proceedings stood in recess from 9:34 to 10:03 because just before then, they had decided to get Mr. Copeland in and Miss Hilton in. So when they go back on the record at 10:03, this is reflected on page 23, it's Judge Glanville, ADA Hilton, Attorney Bumpus, Court Reporter Weaver, investigators Long, Hamilton, some deputies, and then at some point, Mr. Copeland expresses that he might want to call his sister, and on page 36, Mr. Copeland says, this is not the sister, can I speak with her for a second, meaning Miss Bumpus? And it shows that Judge Glanville, ADA Hilton, Court Reporter Weaver, and the 2 DA's office investigators leave chambers at 10:17, return at 10:33. Then Mr. Copeland has a question for the court. And then on page 46, a sheriff's office person comes in and tells Judge Glanville, we have a security issue. We need to stop for a minute. And it reflects that Judge Glanville and that officer, Lieutenant Dean, exit chambers at 10:45. Judge Glanville returned to chambers at 10:47. Okay, and then there's something about he might want to talk to his sister, and on page 52, they appear to maybe call his sister, and Ms. Hilton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. And the court says, hold on. And Judge Glanville exits chambers along with Miss Hilton, Investigator Long, Investigator Hamilton, and the court reporter. They all leave from 10:53 to 11:28. When they come back in, and this was where I got confused, the court says, okay, all right, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? And I hadn't looked up to see who left before, so I thought maybe just the judge had left, but it appears that they had all left. So, I mean, I assume he meant, obviously we know Ms. Hilton and Mr. Copeland had been talking prior to this. So I guess that's what he meant. But anyway, that's where I had gotten that. So where do you get your basis that they were in there at some point?
I get my information from Miss Bumpus. So
Okay.
perhaps, and I don't know specifically at what point. I don't know if Miss Hilton came back in the room prior to going back on the record. I don't know. But at some point, Miss Hilton, Mr. Copeland, and Miss Bumpus were in that room discussing things amongst themselves. And my understanding is that Mr. Copeland relayed information regarding the murder of Donovan Thomas and perhaps some other information that Ms.
Mm.
Bumpus indicated would be Brady material. And so I just want to put that on the record that this happened.
Okay, so you can't put that on the record
Well,
that it happened. You can put it on the record that Ms. Bumpus told you it
Well,
happened.
Ms.
Is that
Bumpus-
what you're saying?
Yes, Your Honor.
All right, I want to hear from Ms. Bumpus if that's the case.
Okay. And then would you like to, are you interested in
If you
seeing this
want me
TikTok?
to, that's fine.
Okay.
No, I'm not interested in seeing
But
it,
if-
but if you feel like it's relevant, I'll watch it.
Thank
Your
you.
Honor, may we approach briefly with Mr. Kendrick?
Yes.
Oh my goodness. I know exactly what he's talking about too. She even walked crazy. This chick even walks crazy. I know exactly what he's talking about. As a matter of fact, I did a video about it. He was talking to Kayla on her channel. And somebody asked in her comments or in her chat, they asked, is the transcript complete? And Woody was like, nope, you know it ain't complete. And he started talking about what happened to him the weekend of the weekend after he was in willful contempt and he went to jail. So I know exactly what video he's referring to. This is about to be insane, man. Let me go to the comments real quick. I had to step away for a minute, y'all. See the judge throwing TikTok, not a TikTok. Yes, this is crazy. This is absolutely insane. I don't think I mean, I don't know. Oh, you watched it too? I appreciate it, Sheely. I appreciate it. You be holding it down, man. I'm gonna have to give you a wrench. You be holding it down. Yeah, I'm gonna have to give you a wrench, man. Sheely be holding it down. But look, that video, I mean, is it evidence? Is it, again, he was there. He was there. Did he read the transcript? I'm not sure, but I know for sure Kayla did. Ms. Bumpus definitely read that. Yeah, definitely. So yeah, we know what's going on. We know for a fact that transcript was incomplete. We read the full transcript on this channel, and we also, again, like I said before, previously, we reacted to a video where we saw some inconsistencies with this transcript. And so exactly, he was there and Kayla was there. And so Kayla knows like that transcript is not complete at all. She knows it. She knows it. Now she's there with her lawyer. Hold on. Sheely. Are you watching Miss Sylvia's stream as well? 'Cause Kayla and her attorney is there. Wow. No, Hilton is not there. Remember, Hilton is on vacation this week. Hilton told the courts last week that she won't be here. So everything is on Miss Love this week. Okay, I figured that. Okay, that's good. Smart. Smart. Because Miss Sylvia has a Rule 22. She's actually there to record. She can actually record in the courtroom. So yeah. No, but Miss Hilton is not there. Yeah, Miss Hilton on vacation. Now, ain't that something? Miss Hilton could go on vacation, it's no problem. But if Melnick go on vacation, he went to Alaska, okay? A non-refundable payment of tickets to go to Alaska. And now all of a sudden you're going to question his representation of Mr. Copeland and what's in Mr. Copeland's best interest. Stop it. She said, I got 3 streams going on right now. Laptop, computer, and tab. Jeez, okay, you dedicated to this thing, girl. Okay, I ain't mad at you. I ain't mad at you, Sheely. I ain't mad at you. They did a reverse. Now Hilton gone. Exactly. I personally think, this is what I think about Miss Hilton. I personally think that Miss Hilton does not like, I think she tolerates Miss Love. I don't think that she likes working with her. There are so many times where they go back and forth with each other. And you could tell there's she gets a little bit disgruntled especially when Miss Love is telling her things and putting sticky notes in her face while she's talking, all that kind of stuff. And it's hard to work with somebody like that, man. You know, so you tolerate them a little bit. You know what I'm saying? But at some point, somebody from that prosecution team gonna leave. I don't know if it's gonna be Hilton or my man Atkins right there. I don't know who it's gonna be, but somebody dipping. Somebody's about to dip. She Lee said I only channel here though. That's what's that's what's up. That's what's up. I appreciate that. And Ricky E245 says Teddy Hilton might not come back after vacation. I'm telling you, man. Listen, when you watch Miss Hilton's body language, when you watch her body language and how she works with Miss Love, she looks like she's not happy. She looks like she's not happy to work with her. You know what I'm saying? So, hey, I wouldn't be surprised if she didn't. She said, Sheely says, I used to think that Hilton was against what Love was doing, but Hilton knows better and should do better. Absolutely. You know, absolutely. Because even in the ex parte meeting, when she was telling Woody like ways that he can testify and all that kind of stuff, that's not, he's your witness, but he's not your client though. You see what I'm saying? And that's the problem, man. That's the reason why you should just you have the right to remain silent, dog. Even if you get subpoenaed, if you have a lawyer on retainer, like Woody had Melnick on retainer, that means that Melnick is representing Woody, period, no matter what happens. I put a lawyer on retainer for any issue that I have. Okay. So the fact of if I'm representing Woody in a criminal case, or if I'm representing Woody as a witness in this case, it doesn't matter. I'm on retainer. So I represent my client, period. Miss Love, with her crazy logic, is trying to make it seem like those are separate things. It's the same thing. My client is the common denominator between that criminal case and this witness and being a witness in this case. So I am on retainer. I am going to represent my client, period, under any circumstance. Okay. So the fact that she was trying to say that, were you specifically representing Mr. Copeland in the criminal case, or was you representing him in the witness? In this case, as a witness, ma'am, he's my client. I'm on retainer. I represent him on all things legal. Okay. Just a sample. What up, though? Says Love looks like a crash out waiting to happen. I'm telling you, hey, when she walked around that damn table, dog, I'm telling you, I couldn't hold it, man. I'm like, I know she didn't walk around the table the opposite way. Like, you know, she could have just walked right across here and sat down. She walked all the way around here, tooted her ass in Melnick's face, and came right here and sat down. That's crazy. That's crazy. That's a crazy chick. Okay. You can't break up with her. No, you can't break up with her. You have to leave her. You can't break up with somebody like that. You cannot break up with a woman like that. You got to leave that woman. She crazy. She played reading around the Rosie on her own at her own table. And Atkins, look at this body language. He's like, man, what the F did I get myself into? In his mind right now, he's like, I can't believe I'm working with this bitch. This bitch is crazy. He ain't looking up nothing on his computer. He chilling. He not. He over it. He over it. He is over it. Look at him. He is done. He can't right now. No, you gotta. Yeah, you can't break up with her. No, you gotta look. She says you will have to totally relocate to a different state. Absolutely. She's the type of crazy. She acts like you can say the same thing to her over and over and over again. She's not taking no for an answer. Hold up. Woody was there. Sylvia said that he left. Okay. I wonder why he was there though. Interesting. How we looking on the likes? Real quick, man? Hope everybody's enjoying this. This is crazy, man. This is crazy today. I knew today was gonna be nuts. I just knew today was gonna be nuts. Make sure we get the likes going. They are right now, if you're just joining us, the attorneys are at the bench right now because Miss Love wanted to approach. And so since Miss Love wanted to approach for whatever reason, well, I'm pretty sure because of the reason of the TikTok video. The TikTok video and the information that Ms. Bumpus has. You know what I'm saying? So, this is where they're about to try to prove the Brady material that Mr. Steele said is relevant in the case here.
We've got a resolution,
Here
and
we
that
go.
is that we're going to take 2 minutes or so. Mr. Weinstein is going to go refresh his recollection by watching the TikTok himself. And then he represents that there are really only about 10 seconds that are relevant. It is one question by Ms. Bumpus and one gesture and short answer by Mr. Copeland. He's going to make himself a written record of what that actually says, and he's going to proffer that. So we'll take a quick break and allow him to do that. Then he can come back and put a more detailed, specific proffer on the record, and we'll go from there. All right, so we're in recess again.
Come on, hurry up now. I could actually send it to him if he hey, tell him to hit me up, man. I got the clip. I know what he need. I got the clip. All right, we are in a super brief recess because Mr. Weinstein is going to refresh himself and refresh his memory, on the TikTok video that he's going to use, and he's only going to use about 10 seconds of it. And so he's going to try to get that 10 seconds and present it to the court. She at least said I have a 12 o'clock appointment. They need to come on. I feel you. Abundance said, if I was Hilton, I wouldn't have took vacation and trust love. I feel you. I feel you on that. Yeah, Ricky E today. Well, right now, this is for Doug Weinstein to recollect his memory on the video and also to pull the portion out, the 10 seconds that he need out the video, so that way he can present it to the court. So they're on a brief recess. What is everybody's thoughts when it comes to Miss Love, man, and her line of questioning? I mean, for her to be the deputy chief assistant district attorney, I think that's her title in full. Her line of questioning was very, very just, I don't know, it was a bit weird. She was asking pretty much the same things in different ways over and over again. And then also asking questions that could possibly lead to an attorney talking about what he spoke to his client about. I mean, I'm just kind of, I'm a little bit shocked, to be honest, because again, if you've been doing this for a very long time, you should know what questions not to ask. You don't ask a lawyer what he discussed with his client. That's attorney-client privilege, work product privilege, just a whole bunch of things. So, and it's very, very inappropriate to do that. I just don't understand Miss Love at all. And I mean, she is very, and she got the evil shit on her, man. Seriously. I don't know. Her line of questioning was just really, really weird, man. And the way she was trying to show the documentation as if, okay, because they took a part of this, they took a part of the body of the email and put it on a different sheet. You know, like what? Like it doesn't matter. The information states that you knew that Woody was being represented by Mr. Melnick. It doesn't matter about the rest of the email if it's irrelevant. Take out all the things that's relevant to what we're talking about, and you use those things. I don't understand her line of questioning was very, very, very just. I'm gonna be honest with you, it was amateur for real. I would expect someone like myself or someone like a person that's not a lawyer, a person that doesn't really practice law. I would expect myself to make a few mistakes like that. You know what I'm saying? But the fact that I actually research and study, I wouldn't have asked those things. You know, and so you would expect, and that's one of the things in law school. What I've been told from other people who are lawyers. A friend of mine, his sister is a lawyer, and one of the things that I remember is that in law school they teach you how to ask questions. They teach you how to input evidence and things of that nature, how to use the law to your advantage, especially if you're a defense attorney. But asking questions is something that they teach you like first thing. And so I remember even the lead attorney saying that on his channel that asking questions is what they teach you for the most part. You know, they teach you law and all that kind of stuff too, but it's more about asking questions, how to ask questions, how to get information out, because it's very, very important that you do not, especially if you're a prosecutor, do not delve over into that line of prosecutorial misconduct. I'm telling you, it's a thin line, man. And Miss Love, she jumped all over that line. She jumped all over that line. She Lee said indescribable. Ricky E says nobody understands Miss Love. That's a fact. Nobody understands Miss Love at all. At all. Nobody understands Miss Love. Bunny says I'm here listening, just taking the kids to school. That's what's up. That's what's up. No problem. Yeah, I don't understand Miss Love at all, man. And another thing too, in this case, in this trial, is the fact that, if you are, I wonder what's going to happen when it comes to this this ex parte transcript that is obviously cleared up for sure. Who's going to get in trouble? Is it going to be Miss Weaver? Is it going to be Glanville? Is it going to be, when is Glanville going to take some accountability here? All of this is coming. All of this is because of him too, as well. So allowing things to happen on state side that shows bias and prejudice. So if there's any type of prejudice going on, mistrial, of course, is the thing. You know what I'm saying? But yeah, I'm really curious as to how that's going to play out. Let's say, for instance, that the transcript has been doctored up and it's been proven that it's been doctored up. Okay, who do you go after? Do you go after Weaver? Well, yes, obviously. Do you go after Glanville? Obviously. Do you go after the prosecutors? They were there. They were there. And so this is the reason why I could understand why I couldn't understand why Judge Whitaker did not disqualify Love and Hilton, although they're witnesses of a particular meeting that has elements of coercion in it. Like, they were there to coerce. So, but of course she denied that because of the fact that she don't think that it was that inappropriate. Obviously, this judge goes by the transcript, goes by the law, goes by the letter of it. She's quick to assume certain things, but when it comes to the transcript, you just going off transcript. You can't go off the doctor transcript because it's a lot missing. It's a lot missing. So hopefully, this can be proven today. It's possible that it's possible we can have a mistrial today. You know what I'm saying? It's possible. But I'm not holding my breath just yet on that. Okay, I'm not holding my breath just yet on that. It's a lot going on today. Miss Love crashed out and walked around her own table. Uh, so another thing I noticed too when she was trying to question, or when she was questioning Mr. Melnick, one of the things that I noticed that she was trying to use was email manipulation. She was trying to insinuate that Brian Steele manipulated the emails. But again, the emails, she obviously she don't know how emails work. But the bottom line is that the information in the email states, no matter which page it's on, what sheet of paper it's on, it states that you knew that there was representation for Woody. You knew that. You definitely knew that. Love was punching in the air for sure. Absolutely. Absolutely. Miss Love was reaching, trying to insinuate and imply that Brian Steele somehow was omitting, parts of the email. I mean, it's absolutely crazy. It's absolutely crazy. And trying to negate the fact that you had information prior to June 7th. You knew that this man had a lawyer. You knew that the lawyer was on retainer. You knew this. You tried to escape by saying, "Oh, Brian Steele manipulated the email." Come on now. You don't know how emails work. You actually, you can forward them. You can reply to them. You can CC. You can blind copy. Like, this lady is crazy, man. This lady is crazy. And another thing that Melnick also highlighted in his testimony, he highlighted the fact that immunity was not even a conversation. I know. Did you notice that? Did you notice that immunity was not a conversation like that until the day of the testimony, June 7th? So even in his interactions with the state, they did not they were not forthcoming with the immunity situation. They said something about subpoena. He is subpoenaed to be a witness. Okay, he's subpoenaed to be a witness is what they said in the email. So, but then the immunity happens that day. Well, here's a copy of the immunity. If I would have known that my client was getting immunity, if I would have known that my client was getting immunity, I would not have agreed to use immunity, which is what Melnick is saying. It just protects his testimony in this particular case. That's all it does. It doesn't immune him from all other things. So he would have asked for absolute immunity. You know what I'm saying? So at the end of the day, that was a very, very good thing that he highlighted, is the fact that the immunity was not something that they discussed. Otherwise, he would not have agreed to use. So another prosecutorial misconduct, another piece of evidence showing that this prosecution has been corrupt. Okay, has been corrupt. Right, Abundance. Right. You mean tell me how y'all manipulate the ex parte transcript? So what Brian Steele did a manipulation on the email like he did that, like they did ex parte. Oh man. They need to quit, man. They need to quit. And even when Miss Love was trying to follow with those exhibits, she was having a hard time. She was having a hard time following what's going on in the courtroom. And she was asking questions as if she was about to lay it down. She was asking questions like she was on to something for real. Then next thing you know, boop, nope, nothing. Absolutely nothing. Nothing. Hold on, let me see. Since they on break, let me see what Thugger Daily is talking about. Let me refresh my screen real quick. See what Thugger Daily is on. Let's see. Oh, Judge wants to hear from Ms. Bumpus. They talking about Doug Weinstein proffer that Ms. Bumpus indicated directly to him that conversations between Woody Hilton Bumpus happened off the record, that Woody gave information about the Nut murder, and there was potential Brady material. Okay, shout out to Thugger Daily. Shout out to Thugger. Look at Ricky. He said ex parte on the emails.
Hi, Mr. Weinstein.
Okay.
Thank you for giving me time to refresh my poor memory, Your Honor.
We go.
So there is actually originally a YouTube video that I viewed on TikTok. And it's an interaction between Caleb Bumpus, Mr. Copeland's attorney,
Mhm.
and Mr. Copeland.
Okay.
And there's just is this feedback a problem? Okay.
Not right now, it's not.
Okay. So anyway, I viewed this interaction. I'll go ahead and proffer to the court the exchange that I witnessed. Ms. Bumpus says, Woody, is the transcript complete? Mr. Copeland then vigorously shakes his head back and forth, indicating no. Then Caleb Bumpus says, you say no? And then Woody responds with, you know that. So that's the interaction that takes place. Your Honor, as I think maybe you indicated, and certainly as the state indicated, perhaps the better source of this is Ms. Bumpus herself. She's here. I'd like to call her to the stand and we can hear her testimony about
Let's
what took
go.
place on June the 10th, 2024.
This is good,
So that
y'all.
ex parte that was not recorded in the transcript, not because of anything nefarious, but it would provide, I think, better insights into our position that there was Brady material June the 10th that was not captured in the transcript and not provided to us.
All right, let's hear it. Ms. Bumpus coming up, and Ms. Bumpus is basically, I think, been in court all morning. Is that right? Okay, coming up and take the stand.
Let's go, Kayla.
Sure. Ms. Bumpus, would you please stand and raise your right hand? Do you swear the testimony that you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes,
Okay, please be seated. Would you please state your name for the record?
Kayla Bumpus.
And what is your relationship with respect to Mr. Copeland?
I previously represented him on criminal cases, but for purposes of this case, I was a stand-in attorney
And what was your intent in representing Mr. Copeland?
to make sure that his rights were protected and to make sure that Jonathan Melnick was good to go.
All right, let's focus on the discrete issue that is before the court, okay?
Certainly. You were present in the June 10th, 2024 ex parte meeting, is that correct?
Yes,
Have you read the transcript to the ex parte meeting?
yes,
Um,
I'm not sure if that is already an exhibit in this case, Your Honor.
It is, it's a part of the record as a
Okay.
transcript.
Okay,
It's been filed
All right.
in Odyssey into the case.
Okay.
So I don't think it needs to be an exhibit unless you want to make it exhibit for the purposes of this hearing, but it's in the record.
okay. I'll just be referring to that transcript. So have you read the transcript from the June 10th ex parte meeting?
yes,
And does that reflect everything that occurred the morning of June the 10th during the course of your meeting? I believe that was in chambers, is that correct? That was compound.
That
Was
was
that
a
meeting in-
compound
that was
question.
compound. Was
Let's
that meeting
redo
in
that one.
chambers? Where did that meeting take place?
in chambers.
In chambers. And was the ex parte transcript that you read a complete recording of absolutely everything that took place in chambers that morning?
No,
Could you please tell me generally, when was there a time during the course of that ex parte meeting when y'all went off of the transcript?
Clarify what you mean by that, when y'all went off.
Was
of-
there a break in the proceedings at some point on the morning of June the 10th?
Multiple,
Multiple breaks.
yes.
And during one of those breaks, did you have occasion to speak to Mr. Copeland with someone else, with someone from the states, the state present in the room?
Yes,
And when you had that conversation, that was off the record. That was without the transcript being transcribed.
yes.
Let's clarify who is in the room at
Yes.
this point in time.
Okay. Who is in the room? And again, let me just make clear on this. I only want you to speak about conversations that you had with Mr. Copeland that are not privileged, where, for
Like
example,
and subscribe,
somebody
y'all.
from the
Like
state
and
was in the
subscribe.
room. Do you understand?
For sure.
Okay. When there was a portion of that meeting that was not recorded on transcript, who was in the room?
Myself, Mr. Copeland, and Simone Hilton.
Who else, if
Um,
anyone?
I don't know, all the deputies,
But were there deputies in the room as well?
yes,
Do you remember how many?
4.
Okay. Anyone else other than the deputies and the 3 people you just named?
Investigator Hamilton and maybe another investigator from the state.
Okay. Approximately how long was that?
Hang on a second. Was the court reporter in the room?
I don't know. I don't recall. I can't remember.
And at what point during the meeting did this allegedly occur?
Towards the end,
If you had a copy of the transcript in front of you, could you show me where? Like, if
I
you,
could get close, Judge.
okay. Do you have a copy for her?
I don't have, does anyone have a copy? I do not have a copy
Mine just
printed out.
disappeared. I don't know where mine went.
Max, do you have one?
I mean, they're getting down to the details.
Maybe not. Let's get a
Okay.
clean copy.
Okay.
What had just occurred and then what occurred following it? What had just occurred prior to,
What had just occurred was we had been meeting for a really long time and I needed to go to the bathroom because I was stressed out. And
okay,
when I went outside in the hallway, Simone was outside in the hallway. So I guess she didn't want to be in the room with Mr. Copeland while I stepped out. That's all I can think of. So she was outside. She met me in the hallway. And she said,
okay, hang on before you get into what anybody said. So y'all are in chambers, like paint the picture for me. You're in chambers and then, and what happens for you to then leave chambers to go to the restroom?
I needed a break.
Okay, and so you leave chambers
Yes.
and Miss Hilton leaves chambers.
I don't know when she left because when I left, she was still in there. But when I came from the bathroom, she was in the hallway.
Okay, when you left chambers to go to the restroom, who was in chambers at the time that you left?
Mr. Copeland, the deputies that were with him, about 4. Miss Hilton, the investigators from the DA's office, the judge, and the court reporter.
Okay, so you took a bathroom break.
Yes.
And as far as you know, you left and then you have no idea when or if anybody else left. But when you came back, Ms. Hilton was in the hallway.
Yes.
All right, well then that's not the part we're talking about.
No.
Well,
Well, I think it leads up to the part we're talking about, and that interaction with Ms. Hilton may
Okay.
be relevant to where we're about to go.
All right,
Could you please describe the exchange you had with Ms. Hilton in the hallway?
so she asked me, I think I get what you're saying. I think I get what what you guys are trying to say. And if he's trying to do what I think he's trying to do, then that's not going to work. And I said, well, I don't know what you're referring to, but I guess we can come back in and you could talk to him about it.
Okay, and so when you said you can come back in the room and talk with him about it, was there any further exchange in the hallway?
No,
What happened after that?
We go back in the chambers,
Excuse me, we being you and Miss Hilton.
me and Miss Hilton.
You go back into the chambers, and then would you say again who was in the chambers when you went back in?
Well, Mr. Copeland had then went to the restroom, so it was just me and Miss Hilton in chambers, and then they bring him back in. And
Did
then-
you and excuse me, I don't mean to cut you off if you hadn't finished.
No, then the same other people.
Okay, when you and Miss Hilton were in the chambers prior to Mr. Copeland returning, did you and Miss Hilton have any further conversation in the chambers?
No,
Okay, when Mr. Copeland.
Hang on. So you and Miss Hilton go back into chambers. Do you go back? I mean, chambers is, there's an anteroom where the judicial assistant sits. There's a staff attorney's office. There's the judge's office. Where are y'all? The judge's office?
yes,
Okay, and when you and Miss Hilton go back to the judge's office, there's nobody else there but the two of you?
and probably the investigators from the
You
state.
don't remember?
Well, the deputies had to take Mr. Copeland.
Okay,
yeah.
so Mr. Copeland was gone.
Yeah, he was in.
Was the court reporter there?
Yeah, she was there.
Was the judge there? If you remember.
I don't remember if he was in there.
Okay, so you and Miss Hilton have a private conversation in chambers?
No, we don't talk.
Okay, y'all just walk back in and then what happens?
And then everybody comes back in.
Okay, who is everybody?
The judge, Mr. Copeland, the 4 deputies, the 2 investigators from the state.
Okay, we're just going to take it slowly, step by step, okay?
Okay.
All right. So those individuals return. Does Judge Glanville return to the chambers?
Yes,
Is the court reporter in the chambers?
yes.
Okay. When all of these people are in the chambers, what happens next? A step at a time.
Simone starts talking to Mr. Copeland about what we talked about in the hallway.
What specifically did Miss Hilton tell Mr. Copeland about what happened in the hallway?
I don't remember what she said at the beginning, because then she says, wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hilton.
Okay, ask the judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay,
And so at this point, you're saying that the judge is out, you, Miss Hilton, Mr. Copeland, 4 sheriff's deputies and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
okay. Next step. What happens next?
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay, what specifically did Miss Hilton say about purging himself?
About purging himself once he began to testify that he would purge
Thank
himself
you.
of him being arrested.
Okay, what about perjury did she tell to him? Did Miss Hilton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Miss Hilton tell Mr. Copeland was the one thing he knew, she
All
knew?
right, let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So when you say that, what did Miss Hilton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And when Miss Hilton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was explaining to Mr. Copeland about independent evidence because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So do I understand your testimony to be that Ms. Hilton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the infinity, because I didn't catch all of that. What did Mr. Copeland say about the infinity?
You just say, I know something about the infinity that y'all don't know.
And how did Ms. Hilton respond to that?
No, I don't remember, but basically she just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the infinity?
I think that, I mean, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't gonna go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more, I don't know. At this point, we've been in there for 2 hours. And they gave me a second to talk to Mr. Copeland, and then that was the end.
Okay. Who gave you a second to talk to Mr. Copeland?
I guess Simone.
Did Simone Hilton remain in the room while you spoke to Mr. Copeland?
Yes, but she couldn't hear what we were saying.
And why do you believe she couldn't hear what you were saying?
She couldn't, I know, because we were whispering in we scooted away from her and we just kind of whispered in each other's ear.
Okay. Is there anything else that happened during the course of this meeting where Judge Glanville was not in the room that you haven't told us this morning?
I'm not 100% sure, but I know there's one time where Adrian says something about Judge Closure.
Where, I'm sorry, who?
Adrian Love.
Look at Ms. Love. Look at Ms. Love.
Let's stop just a second, okay? Because I want to make sure we clarify this. I believe your testimony earlier was that Ms. Love was not in the room, at least during this portion of that meeting. Is that correct?
That's correct.
Are you referring to another portion of the meeting that happened that morning?
I don't remember if he stepped out or not. I just remember at one point she said, Judge, close your ears.
I don't remember if who said,
Okay, let's go back.
yeah, that's
Okay,
very
here,
unclear.
we're going to go back and try to clarify.
Kayla, man.
Let me.
Yeah,
All right. So the beginning of the meeting, it is Judge Glanville, Miss Love, and you,
Yes, Judge.
the court reporter, and then whomever the deputies are. Mr. Copeland is not there. Miss Hilton is not there. Is that correct?
No deputies.
Okay.
They don't come until Mr. Copeland comes.
Okay. So then it is just the judge, Miss Hilton, and you, and the court reporter, correct?
And the investigators.
The DA investigators.
Yes,
Okay. And so is it that portion of the transcript that you're moving to now?
Yes.
Okay. All right.
and what did Ms. Love say?
I just remember her saying something about Judge, close your ears. And I can't remember if he steps out then for a second or not, but that would be the only other time I remember him stepping out.
What did Ms. Love say after Ms. Love said, Judge, close your ears?
I don't remember.
Jesus.
Okay.
Oh,
So we've discussed that one portion of the morning where the judge was not in the chambers. Was there another time that morning, other than that one time we've been discussing? Was there another time that morning where the judge was not in the chambers, but there was a conversation among you, Mr. Copeland, and someone from the prosecutor's team?
No,
Okay, that's the only time.
yes.
Okay, I don't have any further questions.
All right. Does any other defense attorney have questions for Ms. Bumpus? And we have a copy of the transcript now if anybody needs it. A clean copy.
Oh my God, you right about it, Ricky, man.
It's sitting right up here.
She looking bad right now. Everybody like, come on, girl. I know, right? Look at Miss Love got the weird, crazy walk, man. Let's go, Steele.
Go ahead, Mr. Steele.
Thank you, Your Honor. Good morning.
Good morning.
Counselor, was there a time in your presence that you heard someone give a direction for the sheriff deputies to shut off their body worn cameras?
Absolutely.
Do you know who gave that direction?
Deputy Brown.
And do you know at what period of time or what point in time that occurred? Were you alone with your client? Was it throughout the whole time? Were you with Miss Hilton? What was going on when you heard that?
That was the first thing he said when the deputies brought Mr. Copeland in.
So as far as you know, I'm not saying the sheriff deputies filed that order, but they were ordered to turn off all body worn cameras as far as you were concerned.
Yes,
And this conversation that you just relayed to us with Ms. Hilton, you and Mr. Copeland, your client, was that a calm conversation? Was it heated? How would you describe?
it was, we had been in there for 2 hours. It was a high level of emotional tension, if that's a thing.
Okay, were people getting louder than we're speaking now?
Yes,
And who was that person or people?
Simone.
Okay. And when you were talking about Mr. Copeland not being permitted to take responsibility for the killing of Mr. Thomas, you know what I'm referring to?
Yes,
Did Mr. Copeland in any way take responsibility for that killing that day to Ms. Hilton?
pretty much. He just said, you don't know what I did or didn't do.
Okay. And that was said to the prosecutor about the killing of Donovan Thomas?
Yes,
Do you know if you saw Ms. Hilton taking any notes or recording the meeting, or any of the people with her recording this meeting or taking notes?
I'm not aware.
It says, and the court just gave a transfer, I don't know where it is, but you can look at it. No one's trying to trick you. It says on page 40, towards the bottom. It's the Honorable
Yes.
Judge.
It's fine.
If you need to look at it, if you don't need to look at it, that's fine. Just let the record reflect. It should be on page 40. If you need it, it's June 10th. It should be 2024 ex parte conference that you were part of. And Judge Glanville says something to the effect, I'm not looking at, this is not a quote, but it appears to be to Mr. Copeland. Do you remember when Mr. Love told you that as long as you don't tell a bold-faced whopper, something like that? Do you see that?
Yes,
Can you just, so the court, unless the court has it in front of her, what
I've got
line
it
that
in
is?
front of me.
Do you know what line that is? Or it begins on?
12,
Okay.
well, 9, but 12 specifically, what you're referencing to.
I couldn't hear the last part.
9 is when he starts talking, but 12 is when he gets into that part.
He being Judge Glanville.
Yes,
Okay. And what information do you have that Ms. Love spoke with Mr. Copeland about the bald face whopper?
what do you mean?
I'm sorry. Can you ask that again? Or
Yeah.
apparently Ms. Bumpus didn't understand it any better than I did.
Yes. Do you have any information to educate us on when Ms. Love spoke with Mr. Copeland about you can't make a bald face, whatever it says, Whopper.
Hang on just a second. Yes, Ms. Love.
My objection is that the question itself assumes a fact that has not been established.
Sustained.
Read what it says if you don't mind. Since it's
Tell me
in
what
there.
page we're on again. Okay. Thank you.
The court, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just the truth as you know it. And let her worry about, I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your First Amendment privilege because you've been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
That part you said about, you remember earlier this morning, Ms. Love telling you about the bold-faced Whopper. That's what I'm focused on. Can you tell us, were you present when Ms. Love spoke with Mr.
Objection,
Copeland
Your
that
Honor.
morning?
What's your basis?
Again, assuming facts that have not been established. The question, I believe, was, were you present when Ms. Love spoke with Mr. Copeland?
Okay, so I think that's based on the fact that what was just read out was read out. So I don't know that Judge Glanville's statement establishes that, but that's why he's asking it. So I'm going to permit him to ask that, and she can, keeping in mind that that doesn't establish that it occurred. Ask it as a more conditional question, I guess.
Do you have any information how that came about, if it occurred at all?
So the meeting was really long and a lot happened. I can't remember if Ms. Love was ever in the room at the same time as Mr. Copeland. So I don't remember them being in the room together. And if they were, they did not have any communication.
All right. Do you remember in that transcript, I have to get you the page if you don't remember, Judge Glanville handing something to you for Mr. Copeland?
Absolutely.
Can you tell this court what that was?
Which time?
Every time. So go one at a time.
So the first time, I believe he handed me a copy of the immunity order.
Okay.
And the second time, he handed me 2 statutes, one on perjury, and I think the other either on impeachment or, yeah, I think that's what it was.
Okay. Any questions, written out questions you remember being handed to you or Mr. Copeland? District Attorney's questions, was that given to Mr. Copeland?
No,
Okay, you remember that discussion?
no.
All right. I don't have any
God.
other questions. Thank you. Thank you,
All
Your
right.
Honor.
She is
Any
the
other
worst.
defense attorney have questions for Ms. Bumpus? Okay.
Good morning, Ms. Bumpus.
Good morning.
Counselor, I want to take you back to that Monday, June 10th, 2024. When you arrived for court that day, you were arriving to represent Mr. Copeland, correct?
Yes,
As a witness.
yes.
Okay. And where did you go when you entered the courthouse?
I came right here.
To this courtroom 1C?
Yes,
Okay. Did you ever request an ex parte meeting with the judge?
no,
To your knowledge, did Mr. Copeland ever request an ex parte meeting with the judge?
no.
Okay. How did this meeting come about?
I was down here And when I got here, the courtroom was closed. There was no one here. And so I contacted Mr. Chamberlain and he came down. He told me to call him when I got in the courthouse. So I called him when I got in the courthouse and I was right here. And he came down and got me, took me upstairs.
Okay, were you ever told why you were going upstairs?
I was never told why I was going upstairs, but once I got upstairs, I thought I was upstairs because that was the only place I could talk to Mr. Copeland.
Okay. At what point did you realize that you were being made part of an ex parte meeting?
When Brian got up there and said it.
When what? I'm sorry, I just,
Brian,
who's Brian?
Attorney Steele,
Okay.
got up, and that was the first time I really realized that anything had happened because I had been sitting there and I did not realize what was happening.
Okay.
Where are you? I thought you had just been brought upstairs to Judge Glanville's chambers.
But it was never a time where they said, oh, we're about to meet. They literally just start talking. So
Mr. Steele's there?
no, the first time I realized what had happened was when Mr. Steele made his motion in court.
Okay, so you were in
Oh,
chambers
all right.
with Judge Glanville and Miss Hilton, and Miss Love, correct?
What I'm saying is,
You answered the question that I am asking you. You were in chambers with Miss Hilton and the judge. I'm sorry. There are two different parts to this ex parte. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
yes,
Okay. And you were aware prior to that morning that this case was being tried, correct?
yes,
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
yes,
And that Judge Glanville was the presiding judge at the time.
yes,
And that there were defense attorneys on the other side of the case, right?
yes.
Okay. And so when you went into the meeting, you could see that there were no defense attorneys present, right?
No, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked you. You could see at that point in time that there were no defense attorneys present in the chambers, correct?
Yes,
Okay, so at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
what I'm saying is,
Ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Okay, so at the point when people started
Oh my
talking,
God.
let's call it a meeting at that point in time. Okay.
Okay,
And so you knew that the defense attorneys weren't there then, right?
yes.
Okay. And so you knew it was an ex parte, if you knew the term ex parte.
Yes, I know.
Okay, go ahead.
You're an attorney.
And in the meeting, who initiated the conversation about the purpose of the meeting? Was it you?
No,
Okay, who was it?
All right, let me ask y'all a question. I can read what's in the transcript. So unless there's, something that we're saying occurred before, the court reporter said, okay, I'm ready whenever y'all are. I don't need an exposition of who said what. I can see it, okay?
Okay. I have no further questions.
All right. Ms. Matthews.
This is crazy.
Ms. Thomas, good morning.
good morning.
Just a few questions for you. At any time during the meeting that took place between the court, the prosecutor, yourself, Mr. Copeland, were you ever told by the court not to disclose any of the contents of the meeting?
All right, we are not going to replow the issue of Mr. Steele being held in contempt. That is moot. So to the extent that this is going to that, move on.
Okay, that's where I was going.
All right.
Thank you. No question.
Anybody else? From the defense team side? Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few.
Of course she does.
Thank you. Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No,
Do you recall telling Mr. Steele or Mr. Shard or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
Can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall
What is wrong
testifying
with her?
that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
And did Judge Glanville give to you a copy of the immunity statute?
And say, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
You don't recall what you just said?
Do
Oh
you
my God.
recall what you were asked do you recall testifying that Judge Glanville gave you both a perjury statute, copy of that, and a copy of the immunity statute?
Yes.
Okay. Do you recall what question you were answering when you made those statements?
The question that I was answering.
Stay
was,
present, Kayla.
Did he give me some, did Judge Glanville give me something to hand me a statute or hand me anything in a meeting?
And you don't recall him asking whether Judge Glanville handed Mr. Copeland anything?
Objection as to the answer.
Yes. Thank you.
I mean, I'm not sure we've got a clear answer on it, but
Right, we have
does
it.
it matter?
If she, there's a reason that
No,
I'm
this is
asking.
work.
All right, well, go ahead. You can ask it again because I don't think anybody's clear on it yet.
Do you recall being asked today whether Judge Glanville ever handed Mr. Copeland anything?
I believe that I just stated that he handed me two things.
Ms. Bumpus, I don't think she's asking you about what happened. I think she's for some reason asking you about the question that was asked to you on direct.
Do you recall being asked if Judge Glanville gave Mr. Copeland anything?
I don't recall.
Okay.
This chick is nuts. Both of them.
At the time that you were called to the meeting, you already knew that Mr. Copeland had been granted immunity, correct?
Incorrect.
Okay. At the time that you assumed representation of Mr. Copeland, you were aware that he had been arrested, though, right? You knew that Mr. Copeland had been arrested.
No.
Okay. At the time that Mr. Melnick spoke with you about standing in his stead on that Monday morning, did you learn during that conversation with Mr. Melnick that Mr. Copeland had been arrested?
No.
At what point did you learn that Mr. Copeland had been arrested?
After he had been arrested?
Was that before or after the Monday morning meeting?
Objection, Your Honor. You asked us to just focus on the content of that meeting. You asked me to not get far from that, and we're far from that.
Your Honor, may I-
Yeah, what does this have to do with whether or not some off the record discussion that Ms. Hilton was privy to occurred?
Your Honor, the reason I was asking about the giving to Ms. Bumpus the statutes is that my understanding is that at the time that she was called to represent Mr. Copeland, she was not familiar with certain statutes.
Okay, well, maybe not, but that's not relevant to what we're trying to
It's
figure
not
out
relevant
here.
to Brady
And
material.
so to the extent that she was asked by the defense whether Judge Glanville gave to Mr. Copeland anything, and she then responded, he gave it to me.
All right, I don't recall. I'm sorry, go ahead. Go ahead.
I was establishing the reason he would have given her that, and I was establishing further the extent of the questions that I had for her dealt with her understanding of her responsibilities. And then finally, I was going to
It has
ask her,
nothing to do with.
she'd already testified to my memory that she doesn't recall this counselor ever being in the room with Mr. Copeland, and if there was no communication.
Okay,
So I was going to.
that part seems relevant. You can ask about that.
Miss Bumpus. Do you have any memory of Miss Hilton and me being in the room while you were in the room with Mr. Copeland?
I have some memory of all of us being in the room for a very brief moment of time.
When you say all of us, who is all of us?
You just asked me, do I have any memory of you, Miss Hilton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No,
And when you say you remember that I came back, where is it that you're remembering that I came back to?
either, I don't remember. Maybe it's when Miss Hilton came back. But at one point, all three of us were in the room.
Who's all three of us
Me, Miss Hilton, and Miss Love
in chambers?
in chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember.
Well, I mean, it's kind of important. We're relying on your memory for certain things. So were there deputies in the room then?
What I'm saying is if Mr. Copeland was ever in the room with Adrian Love, then it wasn't a long, extended amount of time, and I don't think there was any communication. I remember that Simone left, and it was just me, Adrian Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hilton, and you were in chambers?
There was a point in time where Miss Love and Miss Hilton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hilton was doing all of the talking. I honestly believe it was when Miss Hilton left at the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Antechambers, like
It's not
outside
looking
of the
good for the
chambers,
defense.
but inside of the door.
Yes.
Who is all of us?
Simone Hilton, Adrian Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the judicial assistant, sits.
Yes,
At
Judge.
first, okay, we'll call that the ante chambers, ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adrian Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adrian Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
Thank you. Ms. Bumpus, there were investigators present or no? When you, me, judge, the court reporter first went back?
I can't remember.
Do you recall a comment from either the court reporter or the judge just joking about the fact that I'm not allowed to go anywhere without the investigator?
No.
And when you say that
Thank you.
we went into the chambers, you,
Thank you.
me, the court reporter, Judge Glanville, was Judge Glanville's deputy there?
Yes. I guess if he's a deputy, I don't know.
Which person was there for Judge Glanville? Which sheriff's office personnel? Do you remember?
No.
And where was that person situated when you, me, Judge Glanville, the court reporter went into chambers?
I have no idea.
That person was in chambers with the 4 of us, 5 of us?
I don't remember. At some points, I don't remember about when he was walking in and out.
Okay. And by that, by he, you mean a sheriff's office personnel?
If he's a sheriff, I don't know what he is.
Do you remember,
Got you.
do you have any memory of the investigator being present with me while I was in there?
I don't remember. I know there were investigators there. I don't remember if they came in chambers when you came in or after Ms. Hilton came in.
And seeing the transcript, does it do anything to refresh your memory about who all was there?
No.
Okay. And when you testified earlier that at some point after I left the first time, that Simone, me, and you ended up in a room together in chambers. Do you recall testifying that way to the court just earlier today?
Yes, at one point, me, you, and Simone were in chambers together. Like I said, it was a brief moment, and I don't remember you saying anything.
But that was, are you saying that now that was after I left the first time?
I really don't remember.
Okay. So your memory, you know that at some point you, me, and Simone are in chambers together. You cannot recall whether after I left the first time I ever came back.
I cannot recall.
Okay. And when you said, let me ask you just this pointed question. Did Kenneth Copeland ever say, I killed Nut while Simone Hilton, to Simone Hilton while you were in there?
Can you ask the question again?
Did Kenneth Copeland ever say to Simone Hilton, I killed Nut?
No.
Did Kenneth Copeland ever say to Simone Hilton, I killed Donovan Thomas?
No.
Did Kenneth Copeland ever say that he killed anybody to Simone Hilton?
No.
Did he say any of those 3 things in Simone Hilton's presence in hearing, to your knowledge?
Can I answer that with a non-yes or no question, Judge?
With a what?
With an explanation, because he didn't say yes, or he did not say I killed, but he said, you cannot tell me what I did or did not do.
Okay. That's the extent that he said?
Yes.
Okay.
When you spoke about someone asking the sheriff to turn off their body cameras, was that Ms. Hilton? Did you say Ms. Hilton told the sheriffs to turn off their body cameras?
No, she said Deputy Brown.
You heard that absolutely wrong.
Please tell me who it was.
I clearly said Deputy Brown.
Thank you. Thank you for clearing that.
You're welcome.
See, these are 2 women with attitudes.
Do
I
you
can't do
recall
this.
what was being talked about when
Get your attitude together.
Deputy Brown told the sheriff's deputies to turn off their body cameras?
Nothing. That was the first thing that he said when he walked in the room.
And at that point was Ms. Hilton, you, Mr. Copeland, judge, court reporter, and DA's office investigators all present in the room?
I don't remember who was in the room. It may have just been me.
What?
So it may have just been you when Deputy Brown said to the sheriff's deputies, turn off your cameras?
Thank you.
I don't remember exactly who was sitting in the courtroom.
But that's
I mean,
in the chambers, but that's possible?
It is possible.
It's possible it might have been when you and Mr. Copeland were just in there together?
It wasn't.
Well, Mr. Copeland had to have been in there, right? Because you said the deputies didn't show up until Mr. Copeland arrived.
No, what I'm saying, Judge, is that was the order as he walked in.
Right, but what did you say might have just happened when it was just you?
Nothing. I was saying, I may have been the only one sitting there. I can't remember, but there wasn't like, oh, step out. It's as soon as they walked in, this is what was said as Mr. Copeland was walking in.
I would
And
not
was
hire her
there-
as my lawyer.
Was there any, did you request at that point that they brought him in to have a private meeting with your client at the time?
At that moment, I hadn't requested anything.
Is it safe to say you don't know why they were told to turn off the body worn?
That is correct.
Okay. Did you ever hear anyone from the state ask the deputies to have those body worn cameras turned off?
No.
She just said Deputy Brown. Jesus.
You testified earlier that Mr. Copeland said something akin to, I can claim all of this. Did I hear you right?
Yes.
Okay. And who was he talking to? And
Simone.
okay. And did you know, or did he ever make clear what all of this was that he was talking about?
I believe he was referring to everything that,
Wait, that's not the question. It wasn't what do you think he meant? It was, did he ever make clear?
he said everything in this case.
He said the words, everything in this case?
I don't know if those were his words verbatim, but that's what he said.
Was the court reporter there when that happened?
I don't know. This was an off the record conversation.
Okay, so it was off the, so when what about his words? What words did he say that makes you now say that's what he said if you don't remember exactly how he put it?
I said, I don't remember his words verbatim,
Right.
but I was there and he said, I can claim all of this. I can take all of this. I mean, that's what we were talking about. We were talking about this case.
Okay. Is what you just testified to the extent of the words that Mr. Copeland spoke regarding claiming something?
Can you repeat? the
Oh my
question?
God.
Yes, ma'am. It's what you just testified about, the extent of the words Mr. Copeland spoke about claiming something.
I don't want to say that is a complete lead to the extent because he said it over and over. He said it various ways. He changed the way he said it.
Do you recall what specifically was being discussed at each of the points that he said that? Specifically.
Overruled.
Specifically, not generally, not broadly, specifically what was being discussed at each of the points where he said, I can claim all of this.
The whole conversation was about Donovan Thomas's unaliving.
Are you aware, are you familiar with any of the shootings that occurred after Donovan Thomas was killed?
No.
Okay. Are you aware or are you familiar with any allegations about any retaliatory events that occurred that the state considers a part of the Donovan Thomas shooting?
No.
At what point, what was being asked of Mr. Copeland when he made the statement that you testified? It's not just about me knowing that, it's about who was in the infinity. At what was being asked of him when he said something like that?
Nothing was being asked of him.
Okay. Did he just sort of blurt it out on his own?
Yes.
Okay.
And what he said was, I know something about that infinity that y'all don't know. And it got something to do with somebody who's not even on the case.
Okay. Did he ever make clear what it was that he knew?
He-
To Ms. Hilton in your presence?
He wasn't given the opportunity to.
But what do you mean?
She continued to talk about what she was talking about.
Okay. Did she ever tell him, don't talk to me about that?
No.
Did you ever hear him sort of interrupt her at any other time, at any time?
The whole conversation was them interrupting each other.
So did he ever interrupt her to give her more information or to tell her what it was about the affinity that he knew?
No.
When you said, Adrian said, Judge, close your ears. Did you mean to say Adrian said, Judge, close your ears?
You?
Yeah.
Yeah, you.
Okay. At what point are you alleging, are you saying, does your memory tell you that I told the judge to close his ears?
I don't really remember exactly what was saying. I don't know if it was you and Simone in there, but something about, we were having a conversation, me, you, and Miss Hilton were having a conversation about, I don't remember what we were talking about. And you
Yeah,
said
her
it,
memory is jacked because
you
that was actually
said,
Miss
"Judge,
Hilton that
close your
said something
ears."
about that.
And what did I say after I said, Judge, close your ears?
I don't remember.
All right, so then it's now your recollection that there was a point in time when you, Miss Love, Miss Hilton, and the judge were in there and Miss Love was talking.
Judge, I've said that she never talked while Mr. Copeland was in the room.
Okay, and you don't even remember really whether she was in there or not when Mr. Copeland was in the room.
If she was,
She, Miss Love.
it was very brief, but no.
Okay, but you said before, I thought, that there was maybe a 2-minute time when you, Miss Hilton, and Miss Love were in a room together.
Yes, that's what I'm referring to.
Okay, so that was in front of also Judge Glanville? Because you just said it was, so I'm
Well,
trying to get clarity.
Here's the clarity. He wasn't at the table with us as normal. He was turned around on his computer, but still inside of his office.
Okay. So when did this occur during, so we have the beginning of the ex parte being Miss Love, all of y'all are standing outside in the ante room and Miss Love says, Judge, can we talk to you for a minute or something to that effect? And then who all gets up and goes into Judge Glanville's chambers?
Simone has left to go to do something at that point. So it's just me and Adrian Love.
Okay, and who else?
And the court reporter. And she says maybe her investigator, I can't remember.
Okay, and so the three of you talk for some amount of time,
Yes.
the three of you being Miss Bumpus, you, Miss Love, and Judge Glanville?
Yes.
All right, and then tell me when that changes and it becomes more or fewer of you in that room.
The first person to join us is Simone when she comes back from court.
Okay, and is that at the same time that or essentially the same time that Mr. Copeland also joins you?
Maybe within a minute or so. They don't come
Okay.
in like at the exact.
Okay, so they come in essentially together.
Thank you so much
And
for the
where's
super
Miss
chat. I
Love at that
appreciate it,
point?
Ricky. Thank you so much, man.
She leaves when Miss Hilton comes, but she does stay for, like I said, there's a brief conversation with me, Miss Hilton.
So I
and
don't
the
recall.
judge.
Okay.
And the judge?
Well, in the judge's chambers, the judge is
Okay,
not.
with you, Miss Hilton, Miss Love, but it's not a part of the proceedings yet because the judge didn't even pay attention. He's over there working on his computer.
Yes.
What do y'all say at that point in time?
I don't remember what the conversation was.
Anything of substance?
It was about maybe plea deals. I remember she said to me,
She who?
Adrian Love. I remember
Okay.
she says, which I can't forget this, is I don't know who's worse, you or Jacoby.
What?
That was the thing. That was the nature of the conversation.
I say that again.
She said, she tells me she doesn't know who's worse, me or Jacoby.
Me or Jacoby?
Yeah.
Jacoby Hudson?
Yes.
What does it have to do with anything?
I don't know.
It has nothing to do with this case.
No, that's what we're talking about. You asked me what we were talking about.
Okay, so something that had nothing to do with this case.
And then something comes up about, I don't know if it's plea deals. I don't know. It was something about this case where she says, Judge, close your ears.
Okay,
Hmm.
so this is before y'all kind of gone back on the record. The judge isn't paying attention anyway. He's in the room, but he's over at his computer. Y'all are over at his conference table. Is that what your recollection is?
Yes.
Y'all are talking about entirely other things. And then
I wouldn't say entirely other things, but we're not talking about the Mr. Copeland.
or the case. If you're talking about Jacoby Hudson, you're not talking about the
No,
case.
we're talking about the case. She's talking about, I guess she's talking about the reference to me hugging people. I don't know, but we were talking about the case.
Okay, anyway, and then at some point, Miss Love, to your recollection, says, Judge, close your ears because she wants to talk to you about a plea deal.
I don't know exactly I don't remember exactly what she was talking about, but it was something pertaining to the case. And
Okay, but
she
you
doesn't
don't,
want to talk to me about a plea deal because I'm not a defense.
right, that
attorney.
wouldn't have made any sense.
But she was discussing something pertaining to the case. And she says, oops, Judge, close your ears.
And how long does that conversation go on?
Like that's the 2 minutes I'm talking about.
Okay, and then what happens to Miss Love?
She leaves
She leaves. And then when do y'all go back on the record?
immediately.
Okay,
Well, no, I talked to Mr. Copeland for a second.
okay, privately or,
Privately.
okay. And then y'all go back on the record. And then does the record reflect everything the record reflects accurately? Other than whenever this conversation between you, Ms. Hilton, and Mr. Copeland allegedly occurred?
Yes,
Okay, do you have a copy of the transcript in front of you at this point?
yes, sure.
Can you kind of point out where this conversation allegedly occurs?
It's somewhere around page 40.
Okay,
What is going on,
Between
man?
39 and 40.
okay.
Your Honor, could I just get, if it's between 39 and 40, are there any specific lines?
Well, it was like off the record, so I wouldn't know exactly which line it starts back at.
Okay, but you had represented previously that Judge Glanville was not
Thank you again, Ricky,
in
for the super chat.
the
I
room
appreciate
at
it.
that point in time.
Yes, he was asked to leave.
Okay. So him being asked to leave isn't reflected. Is that right?
Let's see.
Okay. Do you remember who asked him to leave?
Miss Hilton.
Okay. And that's not on the record either?
No,
And you can't remember whether the court reporter stayed or left?
I can't remember whether she stayed or left, but she definitely stopped taking down.
Okay. All right. And when did you, sorry, Miss Love, go ahead. You know what? Go ahead. I'll save my questions.
Your Honor, I honestly defer to the court. Please continue. I have no.
All right. So
And then sit down,
after
Ms.
this
Love.
conversation concludes, then what happens? And by this conversation, I mean the conversation you referenced that is not reflected in the record, but that takes place between you, Mr. Copeland, and Ms. Hilton. What happens after that? But if it's not in the record, it's not going to be in the record. So you just tell me from your recollection, what happens after that?
That's probably towards the last 5 minutes of this meeting.
Okay.
And so we go back on the record and
So the conversation finishes. How does everybody get back in the room? And how is it that y'all go back on the record? Give me the details of that.
she just, we just finished the off the record conversation and just Simone just says everybody can come back in. And then
I don't know if she playing or what, but this is ridiculous, dog.
Okay, wait, Judge, I'm sorry.
Mhm.
It's
Yeah,
actually.
you apologize to everybody. Apologize to America.
Donna, does the court mind if I sit?
Go ahead.
I would say that the conversation actually happened around page 46, 45.
45, okay. And is that conversation in fact reflected on the record?
No, but I don't know.
I mean, because, so how are you sorting out, oh, it's around 45 that it occurs?
Because I try to get the conversation on the record.
What did you say? To get the conversation or to try to get the conversation on the record?
I say,
I'd like to hear it from your recollection without reference to the transcript
okay.
first, okay?
I'm trying to make sure. So I just.
So Ms. Hilton says, Judge, can you leave? And at that point, do you say anything? Like, no, Judge, stay, or anything like that?
No, she already told me in the hallway that she was going to ask the judge to leave and have a
Okay.
conversation with him.
Okay. So show me where in the transcript y'all come back from the restroom break.
Well, you want me to, you asked me to.
Now I do want you to look
Okay,
at the
okay.
transcript, yes.
And okay, I'm sorry. You asked when, okay, I think we came back
No,
around.
Yeah, the restroom break, show me the restroom break.
See, that's not in here with me getting up. I don't know how to find that.
Okay, so the restroom break, y'all take, but it isn't reflected.
Yes,
Okay. Is the restroom break after Mr. Copeland's with y'all?
yes,
All right. And it's immediately after this restroom break that you and Ms. Hilton and Mr. Copeland have the private conversation?
yes, sure. And Judge, you asked me a question earlier that I didn't get to answer.
Okay, what's that?
You asked me, can I, without looking at the transcript, tell you how I tried to get it back on the record?
Yes. Can you give me a second before you answer? Because I'm looking for something in particular. All right, so y'all take a restroom break. You see Miss Hilton in the hall, y'all walk back in. Mr. Copeland's gone because he's taking a restroom break at that point. The court reporter is there. Mr. Copeland comes back, the judge comes back. And that's when Miss Hilton says, oh, wait, Judge, go back out.
Yes.
Okay. All right, now what were you gonna answer?
You asked me, how did I get it back on the record?
Yeah.
So after the conversation, I say pretty much, I want to get what she just told him about what he cannot go to jail for.
Okay.
Because the whole point of the off the record conversation is he's trying to figure out, can he go to jail for lying?
Mm-hmm.
And so I'm trying to get back on the record that she says that she's not going to prosecute him for anything other than one thing.
Okay. Okay, and so y'all have had, the three of you have had this conversation. Judge is gone. You can't remember whether court reporter's there or not, but then what happens?
That's what I'm saying. That's on page.
So then you say, I'd like to get this on the record, or,
No, we go back on the record.
okay, so how does that occur?
No, she just says, let's go back on the record. Simone.
So Ms. Hilton says, let's go back on the record.
Yes.
So you don't say, I want to get this on the record.
No, I just do my best to get it on the record when we go back on record. It's in the.
Oh, I see what you mean. You're doing, you say, you don't mean, I'm really trying to get this on record. You mean Miss Hilton says, all right, let's go back on the record. And then you try to like give a rendition of what occurred.
Yes,
Okay. And that is reflected where?
on page 48.
On page 48.
Well, between 47 and 48.
Okay. All right. And does page 47 and 48 reflect the off-the-record conversation that allegedly occurred between you, Miss Hilton, and Mr. Copeland?
There's a part where I say, so he can go to jail for anything but what?
How y'all feeling about
Okay.
this so far? I mean, I'm having a headache almost, man. I ain't gonna lie. This is insane.
And okay, page 51 specifically, I'm asking, I tell him he has to make a decision. And I ask, so if he starts testifying today, is he going home today? And then I say, but if he says he don't recall to everything, he'll be okay.
Okay.
'Cause
Okay. So, at that point, between, whatever you said, 47 and 51, y'all are back on the record, right?
yes, Judge.
Nobody's like declining to take down what you're saying.
No, Judge.
Okay. So anytime during that point in time, do you say, let the record reflect that Miss Hilton, Mr. Copeland, and I had an off-the-record conversation, and I'd like to put on the record what was said during that conversation?
No.
I totally
Okay.
agree.
And also on page 51, I say, I think, are you saying you want to get up there on the stand and say something?
Uh-huh.
And then it's no response because he just looks at me.
Okay. All right. So does 47 through whenever that last page number was, does that accurately reflect whatever was said during the alleged off-the-record conversation?
It doesn't accurately reflect, but it does. I do try to mention what we talked about, but it doesn't accurately reflect everything that we discussed.
All right. So was there something else that you discussed that you should have said, oh, and by the way, this also happened that you didn't say?
I'm confused, Judge. What do you mean that who didn't say? That
You.
Simone didn't say?
No, anybody during the alleged off-the-record conversation, when you're making this record, after y'all go back on the record, you said it still wasn't accurate. And you also said you weren't stopped from saying anything during that part. So what is it that you should have said that you didn't say?
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay, all right. So what is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date, but somewhere.
Sometime in late June?
Yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you are an attorney licensed and barred to practice in Georgia, right?
Yes,
Okay. And as such, you have a duty of candor to the court.
Yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all of that happened, it's been on recess for so long.
So
What?
you've been in court when we've been in session for the last week or two, right?
Yes,
Okay. So I was presiding at that point in time, right?
yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney, I believe that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay. All right. So what is your answer then to my question?
Right.
Can you ask me again? I'm sorry.
No,
Did you
you
ever at any point in
just say
time
no,
bring to
Kayla.
my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay. Why is that?
Well, because of what I kind of just said, I don't
Okay.
believe that it was incomplete per se,
Okay.
minus the off-the-record conversation, but there are a lot of off-the-record conversations that are had that are not included in transcripts, and that's
True.
not unusual to me.
Okay. All right. So you don't actually believe it's inaccurate then?
No, I just think it's missing the off-the-record I'm not
Okay.
missing, I just think that the defense did not have knowledge of the off-the-record conversation.
Okay.
Not that it's missing from the transcript per se.
Okay. Because it was officially off the record. Is that what you mean?
Yes, Judge.
Okay. And did you ever, if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay. So at some point you brought it to the defense attorney's attention? Is that how you decided to deal with it?
I had a conversation with the defense attorney. I don't want to say I brought it to them, but we just had a conversation
Okay.
about what happened.
All right, Ms. Love, do you have other questions for Ms. Bumpus?
And redirect this chick quick.
Did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hilton on June 10th?
That I had with Ms. Hilton and Mr. Copeland? Yes.
When did you tell them?
The
I don't
same
recall.
day.
Did you tell them everything you remember about it?
I told them everything I remembered.
Do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour?
Was court in recess or was court in session when you told them?
Court was in recess.
Between the time that the conversation between you, Ms. Hilton, and Mr. Copeland ended, and the time that you told defense attorneys all of the details you could remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in
She's trying to
session
get her
at the
accused
time
of that she told.
Mm-hmm.
And the time you told defense? What happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had the conversation with defense? Just in that moment, from chambers to conversation with defense,
Oh, no,
court had not resumed.
no.
And when you said earlier,
I mean, because remember, we came straight down here and sat down and immediately started, so I didn't speak to anyone.
and when you were speaking earlier about when after Mr. Copeland came in, you said you weren't sure whether I was in the room.
Mhm.
Did the portion about Judge closed your ears occurred before or after Mr. Copeland came into the room?
For sure before.
Okay. And at that point, was the court reporter taking down anything?
No.
And at that point, did the court give any indication, did the judge give any indication that he was paying attention to it, whatever it was?
I can't answer that.
Did he give any indication? Did you see any indication he was paying attention?
I can't answer that.
Yeah, you can.
I don't know. I wasn't paying attention to him.
So no, as far as you know, he gave no indication. She's asking from your personal observation. Answer it as to that. That's what she's asking you.
I would have to say no, but I would also say I wasn't looking at him at all.
Do you remember Ms. Hilton at some point talking about the judge closing his ears at any time?
I don't remember.
Jeez, oh Pete.
And we're looking at the transcript at all, refresh your memory.
I'm sure.
Okay?
It's on page 26.
Page
I'm looking at it right now.
26, line 5 of the transcript. And since it's a part of the record, read from line 2 to the end of line. Let me just ask you this. Do you see where Ms. Hilton says, Judge, you might want to close your ears?
Yes.
Did you hear that phrase or something like that said more than once in that meeting?
Yeah. Before Simone got there, I know exactly what I'm talking about.
Do you?
So are you in here at this point?
So my only question is, did you hear that phrase more than once in the meeting?
I can't remember if it's that exact phrase, but I heard you say something to that extent, and I heard her say that.
Okay.
Lord have mercy.
Were you the first person, to your knowledge, that brought to defense's attention that there was in fact a meeting in chambers?
No.
Who, do you know, do you have personal knowledge of who that person was?
No.
See, I told
How
you.
did you know that you were not the first person who brought that to their attention?
Because they asked me about the meeting.
Did they give any commentary to you that led you to believe that they knew what was said in the meeting?
Yes.
What did they tell you?
Is it true that
Sure.
She's still trying to figure out who told.
Yes, sustain. Can you be
Yes.
specific?
Who specifically came up to you and asked you about the meeting in chambers?
there were multiple attorneys that specifically talked to me at one time?
Would you please apprise the court of the names of those multiple attorneys?
Excuse me, objection, Your Honor. We're still far afield again of the limited subject matter that you asked me to stick to.
Your Honor, as it pertains to
No, you trying to
Brady or
figure out who
whatever
told.
information, I think it's quite relevant.
No, it's not.
Who knew what and when,
No, it's
as it
not.
relates to what was said during the meeting?
Okay, well, I don't know if it's relevant.
It's
who
not.
Revealed it, who revealed that a meeting occurred. Ms. Bumpus has said that essentially, if I understand you correctly, that at some point during the day, immediately following the meeting, the day of the meeting, you had a conversation with some defense attorney or defense attorneys, and we can sort out who, where you relayed to them everything you knew and everything you recalled about what went on in the meeting, including the off-the-record conversations, right?
Yes.
Okay. You can figure out who that is now.
Thank you. Who was it? Name the attorneys that you
It's
referred to
irrelevant.
just a moment ago.
Just a moment ago with the question she asked me, Judge Whitaker?
With one eye.
I mean, it's the same topic, right?
Okay, ask the question again.
Which attorneys by name first came up to you and asked you about the meeting?
See, Judge, that's two different questions.
Then answer the question Ms. Love asked you.
I don't recall, but
Kayla,
I think
man,
Judge
dang.
Glanville did judicial notice of me on camera. I don't recall.
No, my only question to you is who first came up to you and asked you about the meeting?
I don't recall everybody who was there.
Who do you recall?
Just say Brian Steele, man.
I
You must.
recall Attorney Steele and Attorney Adams
Thank you. Just say it.
and
Max
I
Sharp.
can't remember who was the other person.
Do you remember how many?
How many
Lawyers were there when Mr. Steele and Mr. Adams came up to you an hour after the meeting and asked you about it? How many lawyers were there?
3, I think,
Okay. Do you recall seeing Mr. Sharp? Just throwing out names.
at some point.
So Mr. Sharp, Mr. Steele, and Mr. Adams, within an hour, is that accurate, of the meeting, came to you and talked to you about what happened in the meeting?
I would say yes.
Okay. Other than Mr. Sharp, anybody else you remember?
No,
And when they spoke with you, regardless of how they got it, did they share with you any details from the meeting?
yes.
And what details did they give to you that they already had before you started talking?
Objection, this is not.
Sustained.
Okay.
She want to know who told.
Last couple of questions, Judge. Ms. Bumpus, when you agreed to represent Mr. Copeland, did you, during the course of the meeting that you had in chambers, did you ask questions of the prosecutors or the judge about what the immunity statute meant or anything like that?
Yes, I asked a lot of questions because I didn't realize until the end of the meeting what was actually going on. That information wasn't given to me.
That's all.
All right. So Ms. Bumpus, you knew to show up for court that Monday because Mr. Melnick had asked you to be stand-in counsel for Mr. Copeland, right?
Yes, Judge.
Okay. Are you representing that Mr. Melnick simply said that and nothing else? He didn't give you any background about what you were walking into?
Well, what I'm representing is I was given specific instructions, and those instructions were, I'm standing in for him. If Mr. Copeland chooses to plead the fifth, which I anticipate he will do, then you won't have to do anything else. If he chooses to testify, we have agreed that he's discharging me.
Okay.
And I made that very clear to everybody multiple times that morning that that's what I was here to do.
Okay. But you had no idea that there was an immunity order in place?
No,
Okay. All right. Does anybody from the defense side have follow-up questions for Ms. Bumpus?
Please redirect this chick.
Okay.
Thank you. Redirect this chick now.
In your cross-examination, you said, quote, "She says she is not going to prosecute him for anything other than that one thing," unquote. What is that one thing?
I can't answer that. I can only assume it would be the unaliving of Donovan Thomas, but those are the words that she chose to use.
When you say unaliving of Donovan Thomas, what are you referring to?
I get him being killed.
During cross-examination, Ms. Love asked you about some alleged retaliatory acts. Were those being discussed when Mr. Copeland repeatedly said, "I can claim all of this, I can take all of this"?
Nothing was being discussed.
What do you mean nothing was being discussed when Mr. Copeland said, "I can claim all of this, I can take all of this"?
He said that on his own, and that's kind of how the conversation started.
What was the subject matter being referred to when he said, "I can claim all of this, I can take all of this"?
Donovan Thomas's murder.
Okay. I have no further questions.
Anybody else? While Mr. Steele's making his way up, just so I am clear on this, you're saying that or are you saying that in the off-the-record conversation that you, Mr. Copeland, and Ms. Hilton had, that Ms. Hilton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay, all right.
So I guess more of a highly possible situation.
That would be the one thing that
Yes,
could
Judge.
get him in criminal
Yes, Judge.
perjury type trouble. Okay, thank you. Go ahead, Mr. Steele.
Thank you, Your Honor. I just want to do timing or sequencing you were asked about. When you left Judge Glanville's chambers, after the entire, not bathroom breaks, after Mr. Copeland was removed from the chambers, et cetera, where did you go, if you remember?
I came and sat right there in the courtroom.
At that point, had you spoken with anybody to alert anyone that there was an ex parte meeting?
No,
Where did next time you saw Mr. Copeland was when? When you left the ex parte meeting, came into the courtroom,
up here. He was up here.
testifying where you're sitting?
Yes,
Okay. And then did the jury come in?
yes,
And did Mr. Copeland testify before the jury?
yes.
At any time during that moment when Mr. Copeland's testifying in front of the jury, did you tell anybody about this ex parte meeting that you attended
No,
or the contents?
no,
Okay. Do you remember there being a break at any point for lunch?
yes,
Is that the first time that you were approached
yes,
ex parte meeting?
yes,
True?
yes,
Did anybody, and that's after you were under no restraint, you told the truth?
yes,
And that was to myself and the other people you told?
yes,
True?
yes.
Thank you. Thank you, Your Honor.
All right. Mr. Sharp?
Can I ask one more question?
Sure.
After the lunch break, do you remember when I raised it before Judge Glanville?
Yes,
Did I do it right away after we spoke?
yes,
First time the court reconvened?
yes.
Thank you.
All right, and
Sure did.
Mr. Sharp coming up, and speaking of a lunch break, we're way past time for hours, so let's plan to do lunch right after we wrap up this witness.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes,
Okay, did you hear the Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
no,
Did you hear anyone from the state tell the defense on record that an ex parte meeting had occurred?
no,
Was there any discussion about the substance of said meeting?
no.
Okay, thank you.
Anybody else? All right, thank you, Ms. Bumpus. You are excused. Let's take our lunch break. Let's come back. It's 20 till 1 right now. Let's come back at 2.
All right.
Just for my knowledge,
Uh-oh.
does anybody on the defense team have any other witnesses as to this issue?
Not from Mr. Kinder.
All right. Is the state going to have anybody?
If the court could just, I'm sorry, Karina, to which exact issue is it that we are addressing? I know it's the June 10th, but what exactly are we addressing? So I can.
The Brady
I mean,
material.
The defense maintains that there was an unrecorded portion of this ex parte where Brady information was revealed to Ms. Hilton that Ms. Hilton did not then share. So that's our topic.
It's been the topic the whole time.
Sure.
All right. What just happened? I have so much I wrote down. I can't even. Oh, I think we all need a break. I think we all need one, dog. Oh my goodness. Oh my goodness. Shout out again to you, Ricky, man. I appreciate it for the $2 super chat saying I don't recall Kayla. That's her new nickname. I don't recall, Kayla. Oh man. I don't recall love. Kayla should have prepared for this. Yeah, I think she should have had a lawyer. Let me look at y'all. Let me see what y'all saying in the chat because it was going up for a minute. All right. Okay. Chill said she had to leave. Hope everybody enjoyed the rest of their day. Kayla has no memory now, all of a sudden. Yeah, exactly. She Lee says Woody says something about the Infinity and he knows who killed Nut, which wasn't in the transcript. Excuse me, that's Brady material. That's exactly the truth. That's about the only value we got out of Kayla, to be honest with you. It seems like Love was more concerned about the ex parte meeting, who said what, and who told her about it. Abundance says Kayla is playing the role and she's about to get the prosecution even in more trouble. Woody has more sense than Kayla. She got a lot of excuses for everything. True. See here what else we got in the chat. So this is important too as well. So in the transcript talks about if matter of fact, let's just go to the transcript. How about that? How about we go to the transcript? How about we do that? So let's go to the transcript. Let's go ahead and see here. Let's drop this. Drop this for a second. And let's go ahead and break it down real quick. Because this is page 20. You see here. Here we go. All right, so we're gonna catch you up to speed real quick. Trust me, it was a lot, but not a lot at the same time. It was kind of weird. So this is what Love was so harped on about the close your ears thing, because this is what Kayla was saying, right? Kayla was saying that Adrian Love also said, Judge, you can close your ears, before Miss Hilton said you can close your ears, but it wasn't on the record, right? So it wasn't on the record. So basically, she said something about Jacoby Hudson, which has nothing to do with this particular case. However, I'm guessing that the immunity or the immunity statute was similar to something about Jacoby Hudson. I got a little bit lost myself in that, but this is the ex parte meeting transcript here, okay? And this is the part where it says Miss Hilton is talking, and Miss Hilton is talking about what the conversation is about, what will cause perjury, what will cause prior inconsistent statements and stuff like that. So it says here, line 2, you will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution of any of it. Okay, what is that talked about? She's talking about the immunity agreement that Woody got on the Friday where he was on the stand. that everybody saw. I think that's his first time seeing it too. Okay, because again, we know that Melnick said that he was representing Copeland, and he didn't even see the immunity until that day. So yeah, that was a bit weird. That was a bit weird. But this is what she's talking about, right? And says literally, and says, Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, this is what this order says. And then Glanville says that's on direct or cross examination. This is where it gets weird here, because Glanville is starting to give some type of insight and advice as if he's a prosecutor. So if you are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those things. So basically anything that you have done with these cats, if you admit to it on the stand, then you're not going to be prosecuted for it, or you're not going to be charged with anything and all that kind of stuff. Use immunity only protects your witness or your testimony during a trial. Or during the trial. It's not absolute immunity. So, and they start talking about statute of limitations in here and all that kind of stuff. So what do we already talked about Ms. Love earlier, man. That chick is crazy. All right, so what is the Brady material that was discovered off the record? Off the record is the fact that Woody knows something about the Infinity car, and he knows something about who killed Donovan Thomas. And he said, off the record, according to Caleb Bumpus, he said that the person who did this is not on this case, which would exonerate all of them from the Donovan Thomas murder or killing or unaliving. So he also says, you don't know what I've done, so you can't tell me, right? They were in the judge office, not chambers. I know a lot of people thought, and as did I, that they were in the actual in-camera chambers where they actually have open, kind of like open private court or whatever. It's open, but it's like private. But they were in his actual office. Okay. The office that we saw when we did the interview, when I showed y'all the interview about Glanville, that office. All right. So let's talk about that for a second, about this particular Brady material, because if a person is telling you that you have the wrong people on a case, and this whole RICO conspiracy case that the state is trying to present revolves around what happened with Woody and how Donovan Thomas got involved and how that whole situation happened. Okay, we looked at the opening statement of Brian Steele, and he said this is about this young man who said, hey, they found this particular thing that you lost, and my boys want to give it back to you. Then all of a sudden there was a fight that happened, and all of a sudden days later after that, or some time after that, they say, hey, we're going to have to take care of some business, street business, whatever the case may be. Then the drive-by shooting happened against Donovan Thomas at a barbershop. And a lot of people on the witness stand in the beginning of this case, earlier in this trial, was saying that it was not an Infinity, it was a Bonneville. Okay, it was a Bonneville, not an Infinity. So let me see something real quick. Let's see what Thurgood Daly's talking about too. We'll do that too in a minute. But I want to pull up 2015 Bonneville. This is absolutely ridiculous. Okay, so okay, this is a Bonneville right here. Right? Okay, that is a Bonneville. Okay. Now let's look at now this is a 2000 Bonneville. Let's I want to do a 2015. Hold on. 2015. 2014, okay. 2014 Bonneville. Do some images here. What the? See, even in that though. See, even in that. The Bonneville is this is what they're saying. Remember this? I don't know if y'all can see. Y'all can see this, right? Here we go. See, this is the actual front bumper that they said that they said that it looked like it had front end because it was a split right here. Everybody know what a Pontiac grill looked like. So this right here is what the eyewitnesses said that they saw. The 2014 Infinity and the 20 and they saw, but they said it was a Bonneville, right? They said it was a Bonneville, okay, which is I mean, you can't. Everybody can tell that this is not an Infinity. So when Woody says something about the fact that, okay, well, I know something about that Infinity that y'all don't know, and I know who unalived Mr. Thomas, but the eyewitnesses are saying they saw a Bonneville. You see what I'm saying? So what is it exactly? You know, and so that's the whole thing, is that it's hard to tell. It's hard to tell what's going on because and another reason why this need to be a mistrial is because you can't tell if somebody is telling the truth or not, for real. Okay. But yeah, so her saying that is actually good information for us to know, because we don't really we know that was never even mentioned even on the witness stand from Woody, that he knows something about the Infinity that the state don't know about. You know what I'm saying? So that is interesting to me. But that was about all the interest that I could get get into. Like, I don't, everything else, I just don't get what she couldn't recall nothing. She couldn't remember anything. And as a lawyer, it's your job to remember stuff. Okay.
And said
Hold on, let's
that
see.
Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, sure.
Okay, and that she
This is what from
Jill's
30
making
days.
his way up, just so I am clear on this. You're saying that are you saying that in the off the record conversation that you, Mr. Copeland, and Ms. Hilton had, that Ms. Hilton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay, all right.
So I guess more of a highly possible situation.
That would be the one thing that
Yes,
could
Judge.
get him in criminal
Yes, Judge.
perjury type trouble. Okay, thank you. Go ahead, Mr. Stu.
Wow. So that would get him in some perjury type trouble. So that's what she was talking about for perjury. But see, that's what I'm saying. That's what I'm saying. Use immunity does not immune you in total. And that's the reason why Melnick said I would not have even advised him to take that. Seriously. Let's revisit. Let's revisit real quick. Okay, still telling the court. So exactly. So any other lies would have it wouldn't have made if he lied about anything else, like, oh, we don't worry about that. But don't lie about killing Donovan Thomas or murdering or unaliving him. What? But you can lie, you can say I don't recall. Ain't that what she told him? That's what she said. You can say I don't recall. Hold on, let's find it real quick. Let's see. Right here in the transcript. Right here in the transcript. I hope y'all can see that. Y'all can see that. Mr. Copeland, you told me before you went to the judge, whatever the thing called, you went with him too. You told me that I can't. When I'm asked a question, I can say I don't recall or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? But another time she said, look, right here, Miss Hilton. There it is, right there. Look at that. Line 17, 18. Okay, so you can say I don't recall. That is how that works. I don't recall. Look at that. Miss Hilton, I would hope that is not the truth, because I think there are some things you do recall and there's some things that you don't. But the things you don't recall, you don't recall. Yeah, okay. Yeah, okay, sure. But if I do recall unaliving a person, and I tell you that the person that I recall unaliving is a part of this RICO trial, you don't want me to recall that. You don't want me to recall that, but you want me, but all the other stuff you want me to recall. But if I tell you that I did something, you don't want me to admit to doing that. Unbelievable, man. Unbelievable. I'm just trying to see what else is going on with Thugger Daily. Let's see. Let's refresh the screen real quick. See what he got. Sheely, what did the judge say in the end? How do you think she's feeling about all of this? Well, the way it seems like the judge is over it. Can you all? You said I was cutting out. Does everybody hear me now? Sorry about that, guys. It seems like the judge is over it. And again, I keep saying the same things. Like the judge is in over her head. It is too much. It is too much to distinctively extract as the truth or a lie, because it's the waters are too muddy. Okay. And so in the end, the judge was basically asking questions to try to figure out the details of what could be Brady. Again, at the tail end, look, watch this. At the tail end of the let's see. Let me go back a little bit here. Let me go back just a little bit here with Love asking questions to Miss Bumpus, right? Right here. I'm gonna go to here because this is too much for her. Yeah, exactly, right here. This is too much for her to come in mid-trial. Exactly. So I'm thinking, this is what I think. I think that the judge is in over her head. I think Bruce Harvey is right that it's impossible for you to catch up to what's going on in this case. It's too much going on. The ex parte meeting, all this kind of stuff, off the record stuff. And the only thing that Kayla said that had some value to it, to me, was the fact that Woody knows something about the Infinity and it has nothing to do with the 6 people that's in this trial. That's about the only thing that I saw that's valuable. Shout out to I've been given a clean slate. Says too much, too messy, too dirty to be played with. Absolutely. 1,000% true. 1,000% true. What was also interesting, just another thing that was also interesting, is that Deputy Brown said, hey, turn off your body cam footage. Okay. And that's very interesting. And I think that's interesting because at no point should an officer of the law turn it off. You're supposed to have it on at all times. I mean, you're in the court. You got to have it on at all times. Another thing that was interesting, just to a little bit to a degree, is the fact that there is a proclivity that this meeting was ambushed on Kayla Bumpus, and that's one reason why he's having a hard time with a lot of things. We're calling a lot of things too. I do want to put that out there because it was ambushed. It really was. The meeting was ambushed for sure. But you are an attorney. You're supposed to remember stuff. You're supposed to remember things. And not being able to remember something that recently happened, this is all you had. Was this case? Was this this stand-in case that you did? You only had to work on this. An ex parte meeting. You didn't even know it was a meeting, right? Again, this is what even heard the fact that she don't even know what it, but if you can recognize the room, you're in the judge office. You're with the prosecution. There is no defense there. You got a court reporter there. You don't think that this has become an ex parte meeting? You still stuck? You still going to stick to? I didn't know it was a meeting. What do you think you have in the judge's office? a potluck? What do you think is going on? Obviously, this is an ex parte meeting happening. Okay, so to say that you did not know this was a meeting is disingenuous, because if you are being escorted to the chambers or escorted to the judge's office, you know this is a meeting. This is an ex parte meeting. You're an attorney. As a matter of fact, Kayla Bumpus used to work for the DA under Paul Howard. She was a prosecutor for the DA's office under Paul Howard. So you know what ex partes are. You know what they look like. So you're coming off disingenuous to me a little bit, Kayla. you Abundance said not a potluck. A potluck. She thought she was going to a potluck, huh? She thought like, you know what this is. As you're walking, if a deputy comes and get you to bring you into an office of the court of the chief judge, you know that you're walking into an ex parte meeting if one of the other parties are excluded. So don't come at me like, oh, I didn't know this was a meeting. You knew this was a meeting. Even if it wasn't scheduled and even if you didn't know about it ahead of time, you knew as you continued on that this was a meeting. So her inability to recall things, her inability to play dumb, her playing dumb at some points, and a lot of that wasn't her playing. A lot of that wasn't her playing, man. She came off real, molasses like in the brain. All right, real slow to me. You know what this is, and so there is nowhere in the world that you cannot recall what just happened in June. This is the only thing that has happened to this magnitude to you all year long. This is the most important meeting. You have your client in chains. He has handcuffs. He's chained around his waist. He's chained around his waist and around his ankles. You don't want to remember this? You don't think your antennas should be boom. You should put your antennas on right off rip and be like, hey, I need to pay attention, man. What's going on? I have no idea what y'all doing. I didn't even know we had an ex parte meeting scheduled. What's going on? So question is, would they have done this ex parte meeting if he did not have counsel? Let's say, for instance, Woody did not have counsel. Let's say he couldn't afford an attorney. One could be appointed to you. And we already know that the backlogs for the public defenders are crazy. I just did the video yesterday about the prosecutorial misconduct and how public defenders have 500-600 cases apiece. You mean to tell me y'all probably would have still had that meeting? They would have still had that meeting. There's no doubt in my mind they would have still had that meeting. And I know they would have still had the meeting because they didn't even tell anybody about the meeting. So this is how you know that this is the time for you to put your antennas up, Kayla. You're walking into an ambush. You need to pay attention to what's going on at all times. And you need to remember this stuff. Why are you not remembering what's going on? And this is another thing too. I've been giving a clean slate. I like the way you're thinking right here. She tried to get her lip back on love. Kayla is making it personal. That's it right there. I was just about to talk about it. Somebody mentioned in the chat earlier about cattiness. You're trying to make this. You're trying to get a lick back. You're being catty instead of paying attention to the question, to what's being asked. Okay. You're making this too personal. All this past the smell test, you made it personal when you try to do a rule 22 for whatever. If I was Caleb Bumpers, man, and when I had to get my attorney because Glanville was trying to have a meeting with me or trying to have a hearing with me about, who told or whatever the case may be, and it got dismissed, I would have never tried to come back to Georgia for anything. You're in too heavy. You're in too heavy. Even from the social media standpoint, now your TikTok or your YouTube is now a part of this case and how it insinuates some off the record stuff or incomplete transcript. And now this is your time to shine a light on what's going on in the transcript that was off the record. And now you can't recall nothing. You're trying to do everything to get back at Lawyer Love instead of actually trying to shed light on the truth of what happened and all the parts of the transcript that was missing. But now you're coming up there saying, well, as far as transcripts go, it looks pretty complete. Well, you the one said that it wasn't complete, and you the one confirmed it with Woody on your YouTube. Now you coming up there, and now you can't recall nothing, you can't remember anything. You don't know if the transcript is complete or not. Then you like, well, it is kind of complete as far as transcript, but it got some stuff that's off the record. Which one is it, Kayla? The only thing that she did valuable was say something about the Infinity and that Woody knew something about the Infinity that had nothing to do with Thug or none of those defendants. So that's the only thing that I got some value from her. Other than that, everything was catty. I can't remember. I think I was there. I mean, it was there. It was me. I was there. I think Miss Love was there. I think Miss Hilton was there. Somebody said something about closing your ears. Now, you can't say you heard somebody say close your ears. You say it's Lawyer Love, and then you say the transcript is complete, and it never shows Lawyer Love saying anything about closing nobody's ears. Now you looking goofy. Now you looking goofy. So I don't understand. I didn't get Kayla for real. Kayla playing both sides. That's true. She Lee says maybe she's just stick to YouTube and not be an attorney. I'm just saying, for real, I would not hire her as my attorney, man. Heck no. But see, she went from being a prosecutor to being a injury attorney, like when you get injured and all that kind of stuff. But I don't know, man. She don't look good, man. And she got clients in Houston. She practiced law in Houston too. Nah, man, ain't no way in the world. I would not hire her as my lawyer. Not after seeing this performance. Mm-mm. This was Trump Biden debate all over again. I'm gonna read some more of these chats, man. I'm gonna play back a little bit of their of Bumpus's witness testimony. Hold on. Specifically with Love and her going back at it. Okay. Hold on. Going to read some more chats here. She didn't feel the need to ask questions. I'm not going anywhere without asking questions. Yeah. I mean, why if a deputy is telling me, hey, I need you to follow me. Okay, follow you for what? What's going on? I'm supposed to be having court with my client in a minute. What's going on? Well, I just follow me. Nah, man, why? You got to answer that, dog. I'm not just about to follow you, cuz. You know what I'm saying? She Lee says, would they have done the ex parte if Melnick wasn't going on vacation? I don't think so. And that's another thing. That Friday, when they talked about when he said that he's going to invoke the fifth, that Friday, when he said I'm gonna be out of town and I'm gonna have somebody in my stead or whatever, that was the green light to be like, you know what, you could do whatever. You know what I'm saying? We could do whatever, Judge. You know, because the ex parte meeting in the June 7th ex parte meeting transcript that we saw in the motion for mistrial, the supplement motion with Weinstein, we discovered that there was a prejudice. We discovered that there was a bias from Glanville the entire time because they were talking to each other, in the words of Weinstein, like yentas. And so this is basically a green light to be like, okay, we could just go ahead and just do whatever we want to do. We gonna get this. They gonna have a lawyer come out of nowhere, and they don't really know what's going on. So we can have an ex parte meeting. You know, nah, that's not how that's supposed to go. You know what I'm saying? That's not how that's supposed to go. Everybody's supposed to get a fair trial. Fair. We talked about it. Prosecutorial misconduct. We talked about it in my video yesterday. Fair trial is what you're supposed to get. All right. Kayla should go and hide under a rock after that. Absolutely. Abundance says she should have stayed off social media and away from speaking on this case. 1,000%. 1,000%. Stay away from social media. Stay away from this case completely. But you know what happened? See, look, this is one of the reasons why I can't really look at a Kayla live for a long time, is because she goes all over the place. She's like super heavy in the chat. And I mean, even while she has a guest, I've seen her have guests on her show or her channel, and the whole time she's looking at the chat. And it's like, McFly, You know, Back to the Future. McFly, pay attention. You feel me? You're not paying attention, baby. You're not paying attention. Shout out to D Peel. Not only as a moderator, but she's also a member of the channel. Go ahead and say good afternoon. Everybody put a D Peel in the chat real quick. Put a D Peel in the chat real quick, man. Let's say I'm so happy to see you today. D Peel in the chat. Shout out D Peel, man. I appreciate it. She said good afternoon to everyone. Ricky said Trump and Biden. Hey, this was Trump Biden, man. This was Trump Biden, man, for real. Kayla's live explaining herself. Y'all want to see that? Put a D Pill in the chat. Y'all want to see Kayla live right now? Hold on. Let's see if we can all right, let's see. Let's take a look at it. Let's take a look at Kayla live. Hold on. Let me grab it real quick, y'all. Let me grab it real quick. All right, let's look at it real quick.
Okay, thank you guys. Thank you so much. No, I wasn't nervous. A lot of you guys don't know that courtroom is freezing. It is freezing in there. So I was cold. And another thing, I want you guys to understand, please don't hold me accountable for what any attorney said. I'm not a defense attorney on this case. So if another attorney took what I said and chose to make their own theme or punchline, I can't, you can't hold me accountable for what another attorney said.
What? What is she talking about?
Like I said, guys, I literally was sitting in the courtroom. They called me. I had no idea. I had no time to prepare. I have been in court all morning for my clients. I've been from courtroom to courtroom to courtroom. I came in here as I do every day to sit, and my whole point of even sitting in here is because of the injustices that I have seen occurring in this courtroom. And I feel like they have done everything to try to bully me and keep me out of this courtroom, which is a public courtroom. And that's the only reason why I continue to come in here day after day after day to prove that I'm going to stand up for what's right, and I'm going to continue to get on YouTube. And I don't care what anybody has to say on here, but if I'm going to get on here and talk to you guys, I'm going to talk about everything. You guys talk about Adrian, you guys talk about this, you're talking about me, so I'm going to address me. And like I said, let's be clear. I'm sitting in a courtroom. No, that is virtually unheard of for someone to be sitting in a courtroom and told they have 2 minutes to go use the restroom, come back, and be ready to get on the stand. I had no idea the line of questioning. I just knew the task was to explain what happened in that meeting and was the transcript complete. I have gone on YouTube over and over and over and over to say, I believe that as an attorney, the transcript was complete minus off the record conversations. And today, the only task that I was given was to discuss that off the record conversation. Everything else was not relevant, and I don't understand. And you guys heard Doug object multiple times to Judge Whitaker making him stay in this scope for the off the record conversation, and Adrian was able to ask all of these other questions.
What?
And also, you know, Yes, I didn't correct him because at that point I didn't know where everybody keeps talking about. Mr. Copeland was on this says on my thing that I didn't correct him because that wasn't the time to correct him. But we did have a phone conversation where I said, hey, I don't think you should say that the transcript is not complete as much as there's an off the record conversation that happened.
What?
And I don't regret that conversation. And if anything, I would pull clips from YouTube, from TikTok, from everything to say that I have always maintained that I believe the transcript is complete minus an off the record conversation. I have said that over and over and over. And transcripts are not supposed to include off the record conversation.
What?
Also, I wanted to say, Melnick had time to prepare. He had multiple days to prepare for what was going to happen. I didn't.
This is not an excuse. Thank you, thank you, moderators.
Only thing, and I'm gonna clear this up, and this is the only thing that I did not recall was who was in the room at every point in time, and that's because how you doing? Hey. Yes, I'm on live. No, you look good. I said, hey, Miss Anita. Oh, okay. Sorry, y'all. I'm sitting on the courthouse there. But pretty much. Thank you. How you doing? Doing good. Oh yeah, I know. Okay, sorry, y'all. I'm sitting on the courtroom step. But
what is her deal? I'm
I
starting to wonder.
I think that it's not. I do think that I helped the defense because the only part that I was supposed to get out was, and at this point, it's about integrity. It's not about anything other than that. So you got to understand. Like I said, I was sitting in the courtroom. I had no idea that I was about to testify until I'm sitting in the courtroom. Nobody talked to me prior to Judge Whitaker saying the only person I'll take that from is Miss Bumpus. The only thing I was supposed to say was that there was an off the record conversation and that there was Brady information disclosed in that off the record conversation. That was my burden, and that's what I did.
This is crazy, man.
Thank you guys. Thank you guys.
Bunny said this is where she
I
should
don't know if I was
transcripts.
sitting in the courtroom.
Exactly.
I do think they would have called me. I think they still would have called me. No, I didn't have any time to prepare over the weekend. The first time that I ever knew of me ever being called as a witness was sitting in the courtroom 5 minutes before I had to testify. And all I was told that I would be testifying about is the off the record conversation. I did not know we would be going from the top of the transcript to the bottom of the transcript.
It doesn't matter. You should know. You were there. You should recall everything that happened. That's the most important meeting of this case. It's ex parte for one. It has your client in there for one in handcuffs, and you should know.
I at first I was like, nobody knows what it feels like to be in my position. At the end of the day, throughout this whole situation, why would I risk my career, my reputation? I've been saying from the beginning that I don't want to have beef with nobody in the DA's office. So I want to let you guys know it took a lot for me to get up there and do that. There's no reason for me to lie. I told the truth. I was not nervous. The courtroom is like -0 degrees. So I was freezing. I was freezing cold. And all I did was got up there and I spoke the truth. And it's the same things. It's so confusing to me because it's the exact same things that I have been saying on my live. I was not the first one to tell about the meeting. I've said that over and over and over again. I was not the first person to tell about the meeting. I've said over and over again. the transcript is complete minus the off the record conversation. I've said that. I said that I
Ah.
did have a conversation with members of the defense, and I told them everything that happened from the beginning to the end procedurally. I said that.
No, they didn't. The TikTok video did not get played because the judge wanted the Kayla to testify, so and come from her mouth. So that's what it was. So we didn't
But
get that TikTok.
at the end of the day, members of the defense told me I did a great job. Everybody, members from the family told me I did a great job. So a lot of times I feel like another thing is, okay, here's a good question. So
Jeez, oh Pete, man, this is crazy.
Somebody said, am I going to get in trouble for not telling Judge Whitaker about the converse? No, I'm not, because that wasn't my duty. My duty was I told the defense about it. And as you guys got up, I heard Ryan still get up and say that he gets up and he says, let me do a timeline. On this timeline, he says, when did you tell me this? When did you tell me this? And when did I stand up in court and make the objection to the meeting or whatever? And the point of that is, in that same day, I made the defense aware, which then made the court aware of what happened. So that's the timeline. Also, I had no duty to tell the court that the transcript was incomplete, because I still stand that the transcript was not incomplete, but there were off the record conversations. Off the record conversations do not have to be.
Hold on, let's stop for a second. I really, really appreciate this, Sheely. Sheely says, I wish that I could join. My daughter messed up my account and YouTube won't allow me to join, but I will send a Cash App monthly. I definitely appreciate it. And thank you so much for being so generous and so kind. And I really appreciate that. It means a whole lot to me. Thank you so much. Thank you so much. Wow, that means a lot to me. I appreciate it. Okay. Just wanted to acknowledge. Everybody put Sheely in the chat real quick for me, please. Put Sheely in the chat for me real quick. All right, let's go. Let's continue real quick.
Transcribed. I said from the beginning, and I guess you can ask any defense attorney, I never said to any defense attorney that Mr. Copeland admitted to unaliving anyone. I never said that. Everything that I have ever said is what I said on the stand today. I cannot control what someone takes from that and uses as a defense, and that should not be held against me.
What? Her low license is worth $1 right now. Clean slate in the building. Listen, man. I don't know what's happening right now, but she's a crash course waiting to happen.
I don't care if people think I'm looking bad or any negative comments, because I did what I was supposed to do. I did everything that I could have done.
It's okay. Listen, she tripping. The problem is that you are a lawyer. You are an attorney. You represented this gentleman before. You represented him before Melnick did. Okay? So you know who this young man is, and you've been a lawyer for how long? You was a prosecutor under Paul Howard for how long? You mean to tell me you don't know, you can't sense when an ex parte meeting is about to happen? And you mean to tell me that you will not even force yourself or put on your antennas or put on your discernment and say, hey, this is an ex parte meeting. Was this supposed to happen? Why wasn't this scheduled? Why you just going in there like, okay, like a deer in headlights? And then when we ask you about something that just happened a couple months ago, which is the only thing that you came here for, you can't recall any of it. That's the problem. What you said was cool, but the problem is that you don't recall anything. Oh, shout out to Chevelle Letters with the super chat. Lee, I appreciate you. I'm sorry, with the Cash App, $20 Cash App. I appreciate it. Lee, thank you so much for this. I really appreciate it. Really appreciate it. Thank you so much. So I can't. It's the fact that you can't recall anything, is the problem. We don't have a problem with the fact that what you said, you gave some valuable information, but the details are just terrible. The details are terrible. So that's the problem. Again, thank you, Sheely, for the $20 super chat. I appreciate it. Thank you so much. Let's keep listening real quick.
I was not, it was cold. I don't know why you guys think I was nervous. I was freezing. It was cold. It's freezing in the courtroom. Thank you guys. Thank you guys. Thank you so much.
Her chat must be lying to her too.
No, wouldn't you have to disclose anything that's Brady off the record or not? That's the whole point. The point is that the prosecution did not disclose Brady information. That's the whole point of this motion. The whole point of calling me as a witness was to say that Ms. Hilton heard Mr. Copeland say he knew something about this infinity, that we have 5 witnesses. So we have 5 witnesses that's testified about the infinity. Mr. Copeland is here saying he knows something about the infinity, and she did not turn that over to the state. Also, the main part of the Brady was that he said that he was a liar and that he would confess to all of the crimes. All of the crimes.
Boy, oh boy. She is really. I wouldn't have went live after. I'm sorry, y'all. I don't know. I'm a little different, man. I'm a little different. I wouldn't have went live after this. You know, even if I'm an aspiring YouTuber, like it seems like that's what Kayla is, man, for sure. Like this is like what she want to do on the side. But I wouldn't have went live after this. After and I'm on the steps of the court. As a lawyer, I just would not do this right now. You know what I'm saying? I would wait. I would do something tomorrow, or whatever. I would do something later. But this is not a bright idea. I don't think, to do this. I mean, I'm not a lawyer or nothing like that. I could be wrong. You know what I'm saying? But I'm just using my discernment and my discretion. If I mean, people don't, a lot of you all don't know me personally, but people who do know me personally, they know I'm a very discreet gentleman. You know what I'm saying? And I'm not about to do anything to, like, right here, like clout chase. Exactly. I'm not about to clout chase you, right? And I'm not about to clout chase for anybody. I mean, if you're in court and you went up there, okay, yes, you gave us the Brady material. What was the Brady material? I wrote it all down. The infinity. Woody know about the infinity. He knows about who killed Donovan Thomas, and none of those people that are the people that are accused of unaliving, Mr. Thomas, is not in this case. So the prosecution is basing their whole RICO around that. They don't have contraband or any type of guns or whatever, so you got to put it around something. And what else is it? Violence. Okay. RICO needs fraud, it needs racketeering, it needs violence, it needs conspiracy, it needs knowledge of conspiracy, it needs these things. So I'm not trying to if that's all I'm supposed to be doing, then that's what I'm supposed to do. But if they're asking me about what happened within the meeting, I should know this. But to go live after that, I just wouldn't do it. Says me too, Tab, moving solid. That's what I'm saying, Ricky. Like, I'm just not about to be loud with it. You feel me? Like, it's no point of being loud with it, man. Just do your thing, guy. And this chick right here, man. I'm sorry, Ms. Bumpus. I'm sorry, I don't mean to say chick, but I mean she's showing that she's clout chasing a little bit. And on top of that, it's like, why did you want to come back? You live in Houston, Texas, boo. Why you want to come back to Georgia to do what? Stay away from this case as far as possible. That's what I would do. Once my motion got dismissed, where it got denied, that so for me to appear in front of Glanville, I would have skedaddled and stayed skedaddled. I wouldn't have came back and tried to get rude 22 and do all. I ain't doing none of that junk. I don't care what they say about me in transcripts. I don't care. I'm not coming back. That's my thing, man. So, and I could talk about the injustices from Houston. I don't have to go to Atlanta to do that. Hey, so yeah, this is a bit much, man. All right, I'm gonna keep playing real quick. See what else she says.
Thank you so much. And I was confused as to what we were talking about because at a certain point,
Hold on.
and some of the parts, somebody said I look confused because at a certain point I was confused. I was confused as to what we were talking about because Adrian was able to talk about things that had nothing to do with the subject matter of was there an off the record meeting. And that's fine. I don't have a problem with it, but it was confusing. Her questions were confusing. There were multiple times where even the judge said at one point, I'm just as confused as to you about a question someone asked me.
I'm sorry, I just can't. I don't know what's going on right now, dog. Sorry. Oh
Thank
my
you,
God,
guys.
man. There is no way. There is no way, dog. I can't, man. This is crazy. This is crazy.
Thank you, guys.
It.
I know they on Law and Crime, but they can talk about me or whatever. Thank y'all so much. I'll talk to you guys later. I just want to get on here and say that. Just remember that I was just called from the courtroom as a witness. That's literally unheard of. That someone would be sitting in a courtroom and just automatically calls as a witness just because they're present. I was not under subpoena. I had no knowledge of how that was gonna go. But I felt like I was willing to take that risk because I knew all I was doing was telling the truth. So I got up there and I told the truth.
Oh my God, that is not. You wasn't even some. You are an attorney. Oh my God, you are an attorney. You know that you have the right to remain silent. You have the right to remain silent. You don't. You could have actually pled the fifth. You went up there trying to be a hero. You could have pled the fifth. When the judge said, I will refer to hearing Caleb Bumpus speak, if I'm Caleb Bumpus, I'm an attorney, I would like, Your Honor, respectfully, I am not subpoenaed to testify and be a witness in this case. I am not on the witness list at all. If you would like for me to be a witness, I would like to be subpoenaed first, or whatever the case may be, or I would like to invoke my Fifth Amendment right to testify about anything in this case. You have the right to do that. You can remain silent, Kayla. Dang.
No, I did not expect to testify. I was given 5 minutes to prepare.
Jesus. Oh God. I wrote all this down for nothing.
Thank you. Thank you guys. Thank you guys so much. All right.
Oh my goodness. Oh my goodness. Oh my goodness. What? Oh my goodness, dog. Oh man. What did we just see, man? Clout chasing at its fine. This, you can't not tell me that wasn't a clout chase, man. Now that she got on the live, this makes it even more of a clout chase. You tried to be a hero. You're trying to be a hero. You're trying to talk about the injustices that's going on in this case. Let the gentlemen who are representing the defense, let them handle that. You can't do this. No. This is not good. This is not good, man. Oh man, you know they watching live. Sheely, you know they watching it. I bet Miss Love, they all watching YouTube. They all watching YouTube. Thank y'all for putting the D pill in the chat. I appreciate it. she leaves in the chat. I appreciate y'all representing in the chat, man. Y'all so kind, man. I appreciate y'all. Sheely said she was looking dumb. Why did you even go up there? Exactly. Why did you go up there if you have not the way that looked? Let me know if I'm off. Maybe I'm off. Okay. But the way that looked, it looked like she was a prepared witness for this particular hearing because of the ex parte meeting that has the Brady material. It looked like she was, you would think that she was, already prepped. And the interesting part is, even if you was called 5 minutes before you got up there, yo, man, why you not ready? Be ready so you don't have to get ready. Be ready so you don't have to get ready. Like, for real though. Like, you cannot be my lawyer and you talking about you was caught off guard. Nothing about court, nothing about the judicial system should catch you off guard if you my lawyer. Straight up. Now, I know she was doing a solid for Melnick. Again, did she get ambushed into the ex parte meeting? Absolutely. 1,000% she did. Yes. Yes, I will give you that. But you should have known as you were walking with the deputy that there was going to be some type of meeting. And it was going to be a secret meeting because the defense counsel was not present. So I don't, no, I don't. I don't want to hear none of that. D Pill says this case is a total hot mess. You dang Skippy, it is. Abundance says throw the entire case away for sure. What did Abundance say? Abundance said, remember when she was live with Woody and she said people kept making comments about her? But oh yeah, she did say that. Woody said, come on, Kayla, you like that. Yeah. She liked the attention. She likes the attention for sure. Absolutely. She definitely likes the attention. Yeah, she likes the attention. And I'm telling you, man, I mean, I appreciate, because I know Cat Not Williams have helped her and everything like that too. And Cat Not Williams is so dope. If y'all not subscribed to Cat Not Williams, go. I know a lot of people are that's from here because we are she supported me on her channel. I really, really appreciate it. As a matter of fact, she shared my video that I did yesterday, dropped. She shared it on her in her community tab on her page. I mean, and Cat always showing love, you know what I'm saying? So and Kat will help anybody that's really about this, you know what I'm saying? And so she has helped, Kayla throughout her YouTube journey, I guess, or whatever. And but when it comes to, Kat is so dope. When it comes to like going live like that was crazy, man. Like that was not a good look at all. I'm gonna replay a little bit of the testimony between Lawyer Love and Miss Bumpus, because it's interesting how this whole thing played out, man. You know what I'm saying? Yes, support her to the max. You know what I'm saying? Cat is how I find it. Oh, that's what's up, K Dub. I appreciate that. Okay, see, Cat, man, I got some people from Cat Not Williams in the building, man. Cat is dope. Absolutely. Okay, we got about 13, maybe about 13 minutes left before they start, and I'm gonna go ahead and play real quick and play this part of the the back and forth, the cattiness between Love and Bumpers, and it was pretty crazy. All right, here we go. I'm gonna play just a little bit of it real quick. Here we go.
Read what's in the transcript. So unless there's, something ready whenever, okay?
Okay. The court
Nope.
neither
go into that, move on.
Okay, that's where I was going.
All right.
Thank you. No question.
Anybody else
Oh, shout out to the lead attorney, man.
from the defense team side?
Appreciate that, Ricky E.
Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few. Thank
I'll be
you.
right back, guys.
Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No,
Did you, do you recall telling Mr. Steele or Mr. Shard or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall testifying that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
And did Judge Glanville give to you a copy of the immunity statute?
And say, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
Okay. Do you recall what you were asked do you recall testifying that Judge Glanville gave you both a perjury statute, copy of that, and a copy of the immunity statute?
Yes.
Okay. Do you recall what question you were answering when you made those statements?
The question that I was answering was, did Judge Glanville give me something to hand me a statute or hand me anything in a meeting?
And you don't recall him asking whether Judge Glanville handed Mr. Copeland anything?
Objection, ask the answer.
Yes. Thank you.
I mean, I'm not sure we've got a clear answer on it, but does it matter?
If she, there's a reason that I'm asking the
All
question.
right, well, go ahead. You can ask it again because I don't think anybody's clear on it yet.
Do you recall being asked today whether Judge Glanville ever handed Mr. Copeland anything?
I believe that I just stated that he handed me two things.
Ms. Bumpus, I don't think she's asking you about what happened. I think she's for some reason asking you about the question that was asked to you on direct.
Do you recall being asked if Judge Glanville gave Mr. Copeland anything?
I don't recall.
Okay. At the time that you were called to the meeting, you already knew that Mr. Copeland had been granted immunity, correct?
Incorrect.
Okay. At the time that you assumed representation of Mr. Copeland, you were aware that he had been arrested though, right? You knew that Mr. Copeland had been arrested?
No.
Okay. At the time that Mr. Melnick spoke with you about standing in his stead on that Monday morning, did you learn during that conversation with Mr. Melnick that Mr. Copeland had been arrested?
No.
At what point did you learn that Mr. Copeland had been arrested?
After he had been arrested?
Was that before or after the Monday morning meeting?
Objection, Your Honor. You asked us to just focus on the content of that meeting. You asked me to not get far from that, and we're far from that.
Your Honor, may I-
Yeah, what does this have to do with whether or not some off the record discussion that Ms. Hilton was privy to occurred?
Your Honor, the reason I was asking about the giving to Ms. Bumpus the statutes is that my understanding is that at the time that she was called to represent Mr. Copeland, she was not familiar with certain statutes.
Okay, well, maybe, maybe not, but that's not relevant to what we're trying to figure out here.
And so to the extent that she was asked by the defense whether Judge Glanville gave to Mr. Copeland anything, and she then responded, he gave it to me.
All right, I don't recall, I'm sorry, go ahead. Go ahead.
I was establishing the reason he would have given her that, and I was establishing further the extent of the questions that I had for her dealt with her understanding of her responsibilities. And then finally, I was going to ask her, she'd already testified to my memory that she doesn't recall this counselor ever being in the room with Mr. Copeland, and if there was no communication.
Okay,
So I was going to.
that part seems relevant. You can ask about that.
Miss Bumpus. Do you have any memory of Miss Hilton and me being in the room while you were in the room with Mr. Copeland?
I have some memory of all of us being in the room for a very brief moment of time.
When you say all of us, who is all of us?
You just asked me, do I have any memory of you, Miss Hilton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No,
And when you say you remember that I came back, where is it that you're remembering that I came back to?
either, I don't remember. Maybe it's when Miss Hilton came back. But at one point, all three of us were in the room.
Who's all three of us?
Me, Miss Hilton, and Miss Love.
In chambers.
In chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember.
Well, I mean, it's kind of important. We're relying on your memory for certain things, so. Were there deputies in the room then?
What I'm saying is if Mr. Copeland was ever in the room with Adrian Love, then it wasn't a long extended amount of time. And I don't think there was any communication. I remember that Simone left and it was just me, Adrian Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hilton, and you were in chambers?
There was a point in time where Miss Love and Miss Hilton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hilton was doing all of the talking. I honestly believe it was when Miss Hilton left at the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Antechambers, like outside of
Yes.
chambers, but inside of the door.
Yes.
Who is all of us?
Simone Hilton, Adrian Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the judicial assistant, sits.
Yes,
At
Judge.
first, okay, we'll call that the antechambers, ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adrian Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adrian Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
Thank you. Ms. Bumpus, there were investigators present or no? When you, me, Judge the court reporter first went back?
I can't remember.
Do you recall a comment from either the court reporter or the judge just joking about the fact that I'm not allowed to go anywhere without the investigator?
No.
And when you say that we went into the chambers, you, me, the court reporter, Judge Glanville, was Judge Glanville's deputy there?
Yes. I guess if he's a deputy, I don't know.
All right.
Which person was there?
Hold on. We're gonna stop for a second. Let me go ahead and speed this up because I don't want to miss anything. Okay, they are not back yet. K-Dub, thank you so much for the $10 super chat. I really appreciate it. Thank you so much for being so kind and so generous. I definitely want to appreciate this. I see that I'm looking at the chat now. I see that you were asking about it. So again, K-Dub, thank you so much for the super chat. I was racing back to the YouTube, man, to the channel right quick to see. I didn't want us to be too late before the judge comes back. That's kind of like how it was the whole time between Love and Bumpus. They were talking past each other, over each other, and being catty with each other at the same time. Seems like we may have some action. Is it a bit of few motions? Oh yeah, for sure. We definitely. Matter of fact, I'm going to go ahead and I'm going to check out Thugger Daily's channel account real quick and see what's going on here. Pretty sure some motions are going to come into play at some point. Excuse me. Made myself a little sandwich. Hope y'all got something to eat. All right. I don't see anything so far. What about my man Joseph Papp? No motions there either. Even on X, Joseph Papp, I think he's a writer for, I want to say the AJC. I think he writes for them, or he's a part of that part of the AJC, the Atlantic Journal Council, something like that. But yeah, so if some motions do get, because remember the motion that we do have a motion from my boy Mad Max, and it got filed on the 2nd of August, and I was trying to find it. All right, here we go. right, Ricky. Might not be back till next year with this case, man. Look, I'm telling you, this case is a mess, man. This is longer than the actual first ever RICO case. Insane.
One thing we can do that is not anything of substance that is important is I want everybody to speak into your mic and let's make sure each of them works, all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of one that does. So can we start with the state?
Yes, Sean.
All right. And I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User
to you.
error, I think, on my part.
User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great.
He put-
Mr. Sharp,
Brian still put on the sexy voice.
Testing, Your Honor.
great.
Is that okay,
And
baby
then who
girl?
else is left? Misty Williams.
Good afternoon, Your Honor.
All right, wonderful.
Oh, Brian still said, "What's up, baby girl?"
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross check Mike's off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the Infinity and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes,
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. Yeah, I do believe that there was more that she said that was disclosed other than just the Infinity.
Okay, what else?
Specifically, when she said that the state would not prosecute Mr. Copeland for lying, except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. With that,
Yeah.
that actually came through more clearly than I think anything else, Your Honor.
Okay,
Your
so,
Honor, may I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer. I
Okay, it
apologize.
happened.
I
Oh, your
silenced it.
computer? Okay.
I silenced it.
All right, thank you. So, Ms. Love,
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton
These
in that
microphones are
regard
terrible.
does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information. My understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they have, obviously, they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may.
She's
Also, the testimony of Mr. I'm sorry, in the off the record meeting where Mr. Copeland,
the alleged off the record meeting.
the alleged
Mhm.
off the record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again. And the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this, would also be Brady material.
And Your Honor, again,
Hmm.
given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too, but a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification,
Yeah.
you said I had set parameters as to what is and isn't Brady, and
No.
I
Yeah.
haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about this hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor, can I make a statement before or while
There you go.
Investigator Long is taking the
Yes.
witness stand? I am specifically objecting to the proffer of Ms. Love always. But in addition, Ms. Love
He
said
said always.
that me and other people who represent people, God forbid, accused of these acts knew already about the ex parte meeting and what occurred and the contents therein. And that is just false. That is just false. That was not testified to by Ms. Bumpkus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well? And that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpkus, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that?
Still said put some spec on my name. You say
So
my
you
name.
said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Spoke Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been
All right.
been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was
Investigator
that's not
Hamilton.
even relevant until
There you go.
such
Yep.
point as there might be
Yep.
some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Man, this is crazy today, yo. What's going on today?
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So we don't need to go through all of his background. All right.
Just, good afternoon, Deputy Chief
Only
Long.
Monday.
Tell the court for the record where it is that you work,
I work for the Fulton County District Attorney's Office,
in what capacity.
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right, are you over the unit that is prosecuting this case that we're here in?
She on
trial?
vacation this
I
week.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? as the
Yes.
investigator? And was that person one of the lieutenants with the DA's office?
That is correct.
While, as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies. And with Kenna Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
That's because she was with him before that. She's so whack, dog. Miss
Were you
Hilton was
present in
with
the
Copeland before
courtroom
that.
Today, when Ms. Bumpus testified,
I was.
did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland.
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request? That is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No,
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
the conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room
Okay,
except for Mr. Copeland and the deputies.
okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No,
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, "I can claim all of this"?
no,
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Didn't Kayla say she was whispering?
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No,
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed? That not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
the topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
That's not true because it's in the transcript. This dude is lying,
Have you
dude.
had an opportunity to read the entire transcript of the?
He has not.
I have not.
I should be a lawyer.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton?
All right, hey, back up. So
Yes, back up,
is
please.
it your testimony that there was one brief off the record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone used the restroom.
Okay,
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
so Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to
No, she
get
was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in.
Okay.
And then Ms. Hilton did ask, she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas.
Oh my God,
case,
this dude is slow
and that
too.
if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have
That's
a
not true.
recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or we or I'm going to prosecute you for perjury?
During the course of the conversation,
It's in the transcript. That's not an off the record
Mr.
conversation.
Copeland's concern appeared to be his statements or inconsistent statements.
Uh-huh. I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have
Yes.
no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay, so do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
All right, so the extent of the off the record before the court got back in their conversation was her essentially just saying,
Real talk. Get this
What?
dude off.
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
all right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that
Doing this off the record or just in general?
in general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton says yes. And Ms. Hilton in line 24 of page 50 says, it's not what you're saying, what you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection, lady.
Sustained.
Yeah. It
Sustained. Ask a different question.
Yes, Your Honor.
Right.
During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember.
Okay, that's it.
If
You don't
that
remember.
was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments, any comments that were the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, lady.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't gonna take credit or say he did something he didn't do.
Do you recall that those words you just spoke were in response to a question about the murder of Donovan?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand.
Oh, this is such a
Taking credit for
bull.
something
This is
he
such
didn't do.
bull crap, dog. The whole thing
Robert,
is
do you
about Donovan
recall Ms.
Thomas.
Hilton, making comments about Donovan Thomas that Mr. Copeland didn't made any comments about?
Other than
I'm
if
sorry,
he got
y'all.
on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made, and that he said he wasn't going to get on the stand to do that.
Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Miss Simone, Miss Hilton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to want to know
No.
if you ever endeavored to find out what he may have said to her privately.
No.
I appreciate it. Thank you. Y'all acting like this whole thing is not in reference to this.
Go ahead.
It's
Go
all
ahead.
in reference.
Would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about
It's all them
the murder of
lies
Donovan
caught in their
Thomas,
throat.
then we would initiate investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the infinity, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right. Thank you.
Scratch that.
Anybody from the defense side have questions for Investigator Wong?
She back on the runway, Ricky.
Miss Love, do you need a cough drop? Because I actually have some if you need one.
No, Judge, it's those lies caught in her throat. She got a lot of lies in her throat. That's what's happening. They're getting all bunched together.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off the record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
First of all, the off the record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay, and that was before what we're deeming the off the record
That's correct.
conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right,
Yeah.
thank you.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean? What she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yeah. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this me paraphrasing, something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would seek perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hilton's mouth.
Yes.
Okay, so Ms. Hilton specifically during the off the record portion referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Miss Hilton, did Miss Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Miss Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Miss Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Miss Hilton brought up Donovan Thomas murder.
Right.
Did Miss Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
So no one talked about it for real, even though that's the whole point of this case.
And
Sure.
how was it determined when Miss Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
we said, I don't recall if it was Miss Hilton, but Miss Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
Put a one in the chat if he lied.
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I ask you a couple of questions?
Oh
Yes.
boy.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Sustained.
At what point were you initially told that you're going to this ex parte meeting? I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you then?
Miss Hilton, I believe. Yeah, because of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to this? Say one more time.
Miss Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Thank you. Thank you.
Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
All right, sit down.
No. If I understand you correctly, they didn't want to tell me not to say anything.
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews.
Let's
While
go,
Mr.
Steele.
Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near the
Okay.
end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualify?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything before we charge. But she did mention the fact of I can only speculate, I would use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mhm.
Thank you.
Anything else from the defense? All right, is the transcript before the witness at this point? I don't know where it went to.
Yes, Your Honor.
Okay, can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41? Let me know when you're done.
Okay. I'm done, Your Honor.
All right, is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay, and does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Just say I don't know,
Just a
man.
second. Let me look a little past just to make sure.
Sure.
Just say I don't remember, bro. This guy here, man. He's not gonna find the hint he's looking for. Exactly, Sheely. He's looking for a cue. He's looking for a hint. Just say I don't recall, sir. Thank you, Ricky. And keep it pushing. I don't recall, man. Because you're not going to recall off the script.
Okay.
Oh, he just threw something in the air. That's what they do. They just throw something in the wall, hope it stick.
If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I will take a look.
And I mean, you may or may not be able to, but if you can, let me know. If you can't, let me know that as well.
Yeah. I don't think he believes himself either. Exactly. That's a fact. When Brian still asked him about other ex parte meetings, he should have told the truth. He knows more. And he's been to most of them. He's the deputy chief investigator. It's your job.
Page 52.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Clopen, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, because
So it's right before that the off-the-record
Yes.
conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Chief,
Oh my God.
Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love. Did you ever hear those types of comments made by Ms. Hilton?
Yeah, Ms. Hilton, yeah.
Was there any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right, investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not
Okay.
at this time.
All right, any rebuttal evidence from anybody on the defense side of the room? All right. Anything y'all want to suggest that this actually means?
Yeah, some of this is not now starting to just be a bunch of word salad.
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get the site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that Your Honor in the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct, or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
Is there prosecutorial misconduct? For sure. Is there Brady evidence? Is there Brady evidence? That's the key question, guys.
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case,
Yo, man.
from my perspective, we've had with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judges' chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a third discussion, which may have strictly involved the grant of immunity.
All right, well,
Right.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So,
Right.
I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte, but these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits.
There you go.
Provided that, so we don't believe that it falls under an exception to begin with. Provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it. And then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule, Professional Responsibility Rule 4.2, regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
I would prefer that since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent
I understand.
anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? I've got it somewhere.
Okay, yeah, I've got it right here, Your Honor, from Ms. Persfield's email to us.
I've got it. If you, I mean, if you've got it at hand, go ahead, but if you don't, I've got it now.
Okay, I'm trying to find out exactly, try to figure out where it was. Okay, paragraph 11,
ahead.
I'm sorry.
Paragraph 11.
Yes. And it says Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth,
Prosecutorial
and
misconduct.
again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, but and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both asserting, both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But
There you go,
also,
Sheely.
I believe that the facts are there under the Wilson case, as well as the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a
Correct.
couple of days ago.
About goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right,
that deals.
can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would
Okay.
be an appropriate argument, but let's
Okay, well, that
pause
you
it for
asked,
now. I have it.
you asked where we are right now, and that's from my perspective, that's where we are right now.
And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, John.
All right.
Thank you.
Okay, and if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate.
Thank
I
you.
don't, and I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
They should go after prosecutorial misconduct, like I was stated in my video yesterday.
Your Honor,
Yeah,
I
Brady-
would just
Brady
like the
evidence,
court
too.
to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's coworker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3, 745 Southeast 2D299, 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court, and
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify
Appreciate you, Ricky.
attorneys for
The
violations
honorable
of
tape. Yes, that's
disciplinary
hilarious.
rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And
Good call,
we
Sheely.
inherited a case that has a lot of
Mendacity.
history and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement, I don't know if you
Yeah,
read it, so.
I read your motion and I looked at the portions that you were talking about.
Hurtful, it's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with emotion
My bad.
by Miss Love. That was the fourth time the same thing's argued. Talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well,
Ooh.
the favors have to end.
Ooh.
I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm actually disqualified because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and it's not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously.
Yes,
And, I mean,
you ought to.
everybody ought to, prosecutors ought to. And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want
No.
to go ahead and
Let's
present some
go.
testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out. Thank
Yes,
you.
thank you.
Appreciate it.
Yo. Oh man. Oh man. Okay. So yeah, my man investigator Long was lying out his ass, out his behind. Okay, so Brady material here. What is it? And so we it's been mentioned in the chat amongst a lot of us here. Thank you for first of all, thank you all for rocking with me for what 6.5 hours right now. I mean, seriously, man, I appreciate y'all for this. I really do. Okay, so I think up here, was it Sheely? Yeah, Sheely said it. Even mentioning the affinity and knowing who unalive nut is Brady. It's Brady material. It's Tom Brady. Okay. It's Tom Brady, man. If you know what is the key thing for material to be Brady? It has to be exculpatory. And you got to have exculpatory evidence that the defense or a defendant may not be the person or persons who did such crime. And if you have a witness who's a sworn in witness, by the way, that you had this ex parte meeting with that was inappropriate, and they mention to you off the record in a very casual way too. We know how conversations go. You know what I'm saying? A lot of times people have conversations and they just start like casually talking, and people may mention things or something may slip out their mouth and they may say something. You know what I'm saying? And they didn't mean to say it, but they like, oh, I said that. You know, if a person is telling you, is saying to you, hey, I know something about the Infinity and who unalive Donovan Thomas, I know more than what y'all know about it. Then, and the people that you all have in the courtroom are not the ones that did it. If you say that, that's exculpatory for the defense. And the thing is it enough to dismiss the case? Because Brady violation, as we saw with Alec Baldwin, which is a recent case, and I think the Alec Baldwin case It's going to be another thing like Brady material. It's going to be another Brady Giglio. It's going to be one of those things. The Baldwin versus, or the state, or the people versus Baldwin. It's going to be whatever case number is going to be. It's going to be a case law about, and the reason why is because the truth is that during the time where he was on set of the movie that he was making, he did in fact pull the trigger. So the thing is, okay, who had the knowledge of what type of bullets were on set? He hired a prop company to do this. They had mixed bullets from a prior set and mixed it with this set, and unbeknownst to him, and that's how it happened. And what they tried to do is hide those bullets. There was body cam footage of the officer bringing exculpatory evidence to the police. And I covered that part. I covered the I mean, it was only a 3-day trial. You know, I didn't have to cover all of it, the whole thing. But day 3 was a beast because that's when the case was dismissed. And so Prosecutor Morrissey put that exculpatory evidence under a different case number. And when they brought that exculpatory evidence to the court, the only person that handled it was the judge. Now, that's actual physical evidence. Okay, also, if you know that a witness is saying to you, hey, I got some information, and the people you charging are not the people you should be charging for this particular trial. Okay, now you have to prove that. And see, that's the whole thing, is that it's close to Brady, but not exactly Brady, because him saying, a person who claims that they lie all the time, him saying, I know more about the Infinity situation than y'all do, and I know who unalive Nut, and it's not the person in the courtroom. It's not the people in the court. Okay, so now they have to try to prove that. And so instead of the prosecution giving that information over to defendants, they kept it to themselves, and it's off the record. Okay, now you're going to have to actually prove it. This is the reason why I think prosecutorial misconduct would be a way better avenue to get this case either mistrial with no retrial or even dismissed. Because according to it, when I did my video yesterday, and shout out to hold on real quick, shout out to Liz Swan. I appreciate you. She actually shared the video and commented on it just now, that there are cases where it can be dismissed completely. And so you can prove prosecutorial misconduct. You can prove that. But can you prove what, even after even if the fact that they didn't release that information is prosecutorial misconduct more so than it is Brady material to me? Because Brady is actual evidence that is exculpatory. So him saying that, them not releasing that information is prosecutorial misconduct all day. But you have to prove what he said to be true, though, to make that Brady material in particular. And if the prosecution has knowledge or they have actual exculpatory evidence that they haven't released, and then the defense discover that, then that's one thing. But there's more evidence of prosecutorial misconduct in this case opposed to it being Brady, because withholding information is prosecutorial misconduct. Just withholding information is not is prosecutorial misconduct. Withholding information is not Brady material. So let's say, for instance, he actually said somebody's name, and they investigated this situation, and then they found out that through their investigation that this person is the actual person who unalived Donovan Thomas, then that is exculpatory evidence, and so they automatically are released. You know, I think that Woody saying that was like, oh, okay, this might be exculpatory, but can you prove it? Can you prove it from a person that has a known history of lying and claims that they lie all the time? You know what I'm saying? Like that's the thing that's like, is it Brady? Is it precisely Brady? It's kind of hard. You know what I'm saying? And are they going to allow an actual investigation take place? I mean, when we talking about something that happened in 2015, you see what I'm saying? So it's like, dog, this is absolutely insane to have to go back that far to investigate would be the thing. My take, what up, though? My take said, didn't know you was live, man. No, it's all good. It's all good, baby. We still got some more time. We've been going for 6 hours and 40 something minutes, 40 minutes and some change. I appreciate you coming through, though. Everybody getting their claps in. I appreciate it. Shout out to everybody for sure. What do you all think? I mean, don't leave me hanging here. What y'all think about this? You know, is it? I mean, is that Brady? I mean, mention, you know, is that Brady? Man, it's possible, but man, it's gonna be hard to prove that what he mentioned is true. In this instance, especially now since this case is going on right now. So I would call the fact that he mentioned it and the fact that they didn't release it, I would call that prosecutorial misconduct for sure, and just pile on that, and then let the judge decide if it's going to be Brady. She did say that Brady material, they take it very seriously. So I'm pretty sure that she's going to dig deeper into it. But if there is actual evidence of what he said to be true, man, that'd be crazy. Still said it was Brady because he said it and they didn't tell the defense. Okay. Yeah, exactly. Yeah, because see, you got to tell, because it has the potential, or it is exculpatory, you know. But then again, too, also the fact that Woody was doing a lot of lying, though. You know, man. But yeah, they're supposed to tell that you any evidence that the prosecution has when it's their time to prosecute, they're supposed to release that information. Period. So that's facts. So it becomes Brady when you have some material that could be exculpatory and you don't release it, you withheld it. That is actually Brady material. So yeah, you know what? Let's go ahead and call it Brady. Let's go ahead, put one in the chat if it's Brady. I'm gonna go ahead and put my one in the chat, okay? I'm gonna go put my one in there, okay? I'm gonna put a one in the chat. I'm gonna start it off. Yeah, I'm gonna put a one in the chat and say it is Brady material. You have some material that has exculpatory value to it, and you withheld it, and so because of that, it technically is Brady, and also prosecutorial misconduct. So it's actually both. It's actually both. Abundance says, even though Woody has openly admitted to being a liar, they should have looked into the infinity and asked who did it. That's a fact. That's a definite fact. You know, and again, too, also the fact that the witnesses kept saying, "Oh, this is a Bonneville. This is a Pontiac Bonneville," and it was a, and they said it was a white Bonneville. They didn't say nothing about a silver vehicle at all. Okay, so I mean, this is crazy. So we got some ones in the chat that says Brady material. Brady, number one, Brady. Okay, everybody think it's Brady. All right. Brady, is Hilton getting fired on her day off? She might. She might be. I mean, how do you get fired, Craig, on your day off? Oh man. Yeah, it's both. I think it's Brady and prosecutorial misconduct. They should be dismissed. They should be dismissed off rip. See, the judge is backtracking. If you can see, if you can see her energy, she's now backtracking because she's finding out that the DA's office is mad nasty over there. They got some nasty work going on. And she's finding this out too. Okay. And let me tell you something. One of the things judges do not like, they don't like to be made a fool of. I'm telling you, don't try to make a fool out of no judge. I'm telling you, they don't like that. So with her order to deny the motion that Brian Steele had about removing them from the case, she jumped the gun. Again, this is why you got to slow down. I had this conversation. What was it, last night or the night before? And I had the conversation and I was talking about people who try to work fast and conflate that idea of working fast with being efficient. If you work speedily and you're efficient at the same time, then you're a superstar. You are a superstar. But if you work fast but you're not efficient, then all you're doing is causing more issues. I was working with someone. I'm in IT, so I was working with someone, and this young lady was like moving fast, just like closing tickets quick, fast. You know what I'm saying? I'm like, okay. And then I started seeing the same people come back more than once. You know, they'll come and say, hey, I need my computer set up. I need my Wi-Fi set up or whatever like that. And she had set it up and all that kind of stuff. And then she just goes in and say, yeah, you good to go, and then leave. And then they come right back with the same issue. And then they're like, oh, I don't know what happened. Let me check it again. Oh, okay. Yeah. Okay. I'll fix it. Then they come back again with the same issue, you know? And then there are times where it's like, you know, I would talk to them. I said, listen, you know, make sure that you do all your testing. Make sure you do all that kind of stuff before you give the computer back to the client, because you're rushing to fix the issue or you're rushing to set up stuff, but you're not being efficient. So yeah, you have your time, your SLA or service level agreement time, your resolution time. It doesn't matter. It doesn't matter because you're not efficient. Yeah, you fix something in 5 minutes, but then as they leave, the situation occurs again. That's not you're still fixing it again. That's because you're not doing it efficiently. You're not looking at what's going on. You're cutting people off when they say what the problem is. You jumping the gun. You're not really paying attention. That's the kind of stuff that you can't do when you're trying to be efficient. And so I think that the judge is starting to put on her efficiency hat and really look at this, because at the end of the day, there is, again, too many details that you have missed in the last 19 months, 20 months now, almost 2 years of this going on. So yeah. My take says judge just can't believe they were that dirty. I think so. I think she's kind of caught by surprise too, a little bit. I'm glad the cameraman zoomed in on her as well, because when you zoom in on her, you can see when she looked at Lawyer Love and said, do you have anybody else you want to bring in, whatever the case may be? Like, yo, her eyes was like on fire about that. So I totally agree. I think that she can't believe that it was this bad. Abundance. I think Weinstein wants to put it on Woody, and that's the wrong direction to go in. Too many people have said he didn't do it, but knows who did it and mentioned that infinity. Exactly. I think, yeah, Weinstein kind of reached a little bit with his with his explanation for Brady. I think the fact that the infinity was mentioned, and that it was mentioned that he knew who actually unalived Mr. Thomas is the way to go, not what he was talking about. That was a little bit of a reach. I mean, but you know, look, the state letting everything stick to the wall. I guess he said I would follow suit here. She Lee says judge has two choices. I think she will dismiss them or try to continue the trial, but how? Yeah, I don't think she need to continue this trial. I I think it should be a mistrial with no retrial. I mean, they have been locked up for a long time, and especially the Marquavius Huey. Man, he should not be in jail at all for real, because they're trying to bring a charge that he did a long time ago and included in RICO. Like, that is crazy. I'm not sure if you all remember the Silver Fox opening statement, but the way he broke down the case, the way he broke down the indictment towards Mr. Huey, is that he had a situation about a gun, and he was charged with that already, all that kind of stuff. He already took care of that charge. Now, what they're doing is saying that that same charge had something to do with a RICO conspiracy, which is this trial. And now they're including that charge in this trial, saying that it was actually a part of RICO. Well, what? What? And when you look at the Silver Fox opening statement, you like, dude, what is going on?
Witnesses
Oh.
for the state.
Here we go.
Ready? All right, let's get that person on the stand.
United States House, Adam Abadi.
All right. I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining, we're not used to being the witness. And the direct finish, and I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But oh well, maybe Mr. Abate won't do that. We'll see.
The judge trying to be light with it, man, but this is too serious of a case, man. I'm sick of her laughing all the time about stuff. It ain't funny, man.
You're
This
coming
is
up to
not
the
funny
witness
at all.
stand.
Like Mr. Melnick, I'm an officer of the court. He won't swear himself in, but whatever.
All right, let's.
Like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the Chief Deputy of the Major Crimes Division.
All right, and February the.
It's ABBATE. And I said Chief Deputy of the Major Crimes Division.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on the Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134. It was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case
I'll take
already
judicial
filed.
notice of it, but I'm also just gonna print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22
Yeah,
SC case.
Yeah, 22 SC 182134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom. And it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker and the conditions that would be included in it.
Was there any part of that conversation that referenced
What was
Mr.
crazy?
Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing as a representative pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134. And the charges were possession of a firearm by a convicted felon and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly.
Thank you, my take. I appreciate you, man.
The correct word as it relates
Thank
to
you
Mr.
so much.
Melnick's
Thank you so much.
reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with
Did she just stop herself in her mid question? Once again, my take, I really appreciate it, man. It says thanks for the further content. I appreciate it so much, man. Thank you
any
again.
other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
Uh-oh. Uh-oh. Uh-oh.
And showing what our market states is that Your Honor, I don't know if the court had already.
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of
Oh,
the
no.
bond order. Is that the bond order that you spoke with Mr. Melvin about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is, this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. I was right. So this would have been the product of that conversation.
Okay, thank you.
And we doing 7 hours, guys. That's what's up. Let's go.
This witness, Your Honor, for right now.
All right. Any questions by any of the defense attorneys?
I know
for
the
this
defense
witness?
better say something. I know they're about to ask some questions. This dude is way too spicy
Nope,
not to
nope.
ask no questions.
Ms. Weinstein, Mr. Matthews, Mr. Harvey, who I
They ain't got
can
no
already
questions
see over
for him?
there in the corner. See even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time.
Wow,
Please
no
step-
questions.
All right, call your next witness.
State calls Attorney Peter.
I guess they didn't see no value in it.
Okay.
And you know what? I can't argue. I can't be mad about the defense on that because it's no need. Exactly. I was just about to say the same thing. Me and you be on the same page. But there's no need for the questions really on him because what does that mean? It means nothing. Again, Brady material has been disclosed. Y'all know that Woody knows something about the Infinity and who actually unalived Donovan Thomas, and you didn't tell the defense. So that right there is anything else you're trying to do. It means nothing. It's irrelevant.
It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I have him sworn.
All right, yes, please swear him.
About he disputed Ms. Hilton, Ms. Love before? He-
Peter, Peter, Herzog, Hertzog. TZOG.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
Anti-corruption, my ass.
Since I started
Sorry.
in office about a year, I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder, March 20th?
Yeah, I think it was March. I've been here about a year and a half.
Okay. Have you ever worked in any unit besides the anti-corruption?
I did a short stint where I screen cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
Right,
As
right.
an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Cole?
Yes, I believe so.
Here we go with this
At
crazy
any
man
time
case.
during those conversations, did you ever in any way seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No,
What is it? Doesn't matter.
Ever in any of those conversations have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
no.
Dude, she is crazy. This is the type of woman you cannot break up with, man. You got to just leave this chick.
Reference either myself or Deputy District Attorney Simone Hilton.
No, not to my recollection. No,
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
no, absolutely not.
Is this the longest you and I have ever been talking?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we've had much contact.
Right, got to lead us.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about,
For real,
a
man.
case that was in your unit?
Yes, ma'am.
Can't break up with her. You got to just walk off.
Were you ever asked by anybody within the DA's office to have any communication with Mr. Melnick regarding his representation?
The judge is not even listening to her, dog.
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2020?
March of 2023.
Change your identity.
I don't
Hey, Ricky. Bet not had no kids with this type of woman. Heck no.
Exactly where the evidence.
I'm sure it's somewhere with the court reporter.
Do you have anything to say about the Brady or potential Brady violation that you just did that we now know you withheld? Oh.
Admitted as defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4. And ask you if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating as part of anti-corruption. We were investigating.
Without getting into the details of any anti-corruption
Okay.
at all.
There was
Dang, she is such a
an
forceful little thing.
allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was when you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Mellon, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Holt?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing, I wrote a check mark, and I'm gonna have to get that off the board.
Okay, probably have some white on it. That would work. Is that okay with everybody if on states 4, Ms. Love wipes out the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence because I'm constantly taking notes and then I end up writing on the evidence.
And it's defendant's, Williams exhibit.
Is that okay? All right. Thank you.
It doesn't even matter, honestly.
With the court's permission, I'll do that after Mr. Sharp has had an opportunity.
Go ahead, Mr. Sharp.
Come on, Mad Max.
So from what I understand, March 2023, you are working for the DA's office in the anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
He's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witness Mr. Rhodes.
Sustained.
What kind of case was this?
Objection as to the.
Well, can we just leave that it's an anti-corruption type case?
Was, I ask, was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's
Your Honor,
Yes. Do we need a bench conference? Okay.
What is going on here, man? Yep. Even the last guy, even the investigator Long, he looked at Love too, to get them signals to see if whatever he's saying is right or not. But this is a waste of time. Miss Love doesn't have anything, man. Are you able to prove that the violation that you just did, which is Brady violation that you just did, and prosecutorial misconduct, can you prove that you have been on the up and up? I mean, it is what it is. I just don't understand why we have to endure these witnesses that's not given any type of defense or any type of, they're not doing anything to prove or disprove the defense's allegations here on them. Prosecutorial misconduct is definitely happening. You know what I'm saying? It really is. And it's evidence of that. And also is evidence of the fact that off the record, Kenneth Copeland said something about, hey, I know who actually did this crime. And the person is not in the courtroom. That's what he said. So anything other than that, if you're not going against that, then not doing anything. You know, y'all having a bench conference for what? Miss Love is crazy, man. I'm telling you. She acts. Was my man named Abati? Who came up there? He came up there real spicy. He doesn't like Melnick at all, I don't think. Well, Melnick didn't get sworn in, so I don't. so I'm on the bar too. You know what I'm saying? Yes. Is that how you pronounce his name? Is it Abati? Sheely? Because Sheely, you're from Atlanta, right? You from the ATL? You say you see him in court all the time. You're from the ATL, right? And is it Abati or is it Abat? Is it Abat? Or Abbott or Abati? I'm not sure. I don't want to mispronounce his name. what do you all think so far with this? Where you all think Ms. Love is going with this? Okay, she's trying to disprove the fact that Melnick. Oh, you said no. Oh, okay, DC, but currently in New York. Okay, got you. Okay, cool. Okay, cool.
Earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry, we're having technical difficulties. Apparently you need to put these things on their charger pretty
Okay,
frequently
gotcha.
in order for
Okay.
them to work. So I'll know that for the next time. One of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams? Okay. Who else do we have? Mr. Stillwell, you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all can't even get it.
All right. So is the volume good on the mic? Hope the volume is good on the mic. So yeah, they are going to gather around and discuss whatever Ms. Love is bringing to their attention. Yeah. So do you think that you think the judge is done with this? Do you think that how y'all feel about a mistrial now? That now that exculpatory or potential exculpatory evidence has been presented to the court, how you feel about a mistrial now? It seems like she's leaning on the seriousness more so of this particular trial now. I'm not too sure. I'm not too sure if she will order a mistrial with no retrial. I'm not sure if she will do that. But it seems like she's not happy with the prosecution right now. I can tell you that much. The way this judge has been grilling Ms. Love today, even throughout, even when she talked about conduct, how to conduct yourself in court, especially in front of a jury, and the constant back and forth and arguing that she did with Glanville. I mean, one day her and Glanville went toe to toe about trying to present things late, and she thought, well, I'm gonna just go ahead and just present this evidence whenever I want. And even that, Judge Whitaker is like, look, you can't play around with me on that. So everybody conduct themselves in a professional manner. So even in that, I don't think the judge is too pleasant with Ms. Love. Yeah, Ms. Love is playing real fake with the judge. But she did do a runway walk around that damn desk though. You think she might decide mistrial? Okay, that's actually not far-fetched at all. That's not far-fetched at all. So let's get back to court, y'all. See what we got. Hope y'all enjoying this live stream. Those that are watching that can't chat, those that are in the chat, I appreciate everybody for watching this live stream. We've been going 7 hours and going towards 19 minutes and some change. It's still ticking. So I definitely appreciate everybody who has given through Cash App. Those that have given to the super chats, I appreciate the super chats here. We had Ricky give $2 super chat. Said I don't recall Kayla. That's when Kayla's on the Kayla Bumble was on the fan, and also my
And
take.
do
Again, I
any of the
appreciate
defendants
everybody.
have
Thank you
any
so much.
questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
Right, she
No,
did.
it's not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail. Mr.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel
Okay,
on any case or was recently represented by counsel.
okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that. Yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation and the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
Mhm.
I have no further questions. Thank you.
Why keep
All right,
looking
does
at love,
anybody else
man?
have questions for Mr. Herzog? All right. No?
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is, maybe I shouldn't know about it. With the court, Mr. Williams has no objection. And if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal, or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but that's valid. Let's find that out.
Yeah, let's find that out. Still, let's go.
You
Still,
can ask that question.
let's go. Still, let's
You
go,
don't have any
man.
objection to that question, do you, from the state? Okay.
Yeah, I bet you don't.
Mr. Still.
How are you?
Good. How are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Look at it. Look at looking at
Just the
love.
question whether I feel comfortable?
Yeah, do you understand Brady and its progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all, just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland, was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay, and I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay, all right, thank you, Your Honor.
Okay.
All right,
All right.
anybody else?
All right.
Mr. Williams? Okay, anybody? All right. Any redirect by the state? No, Your Honor. All right, thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
Can the court allow Mr. Atkins to go outside and check?
Sure.
Is it me or is the whole DA office just spicy, man? Like everybody has some type of attitude problem. Sarcastic attitude or
While we're waiting
like,
on
geez, oh,
finding that
man.
out, y'all were, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting. Nothing. Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would
Not
ask
too
that
much.
the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 183-134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that.
Mm-hmm. So that lawyer that that was on the witness stand has no knowledge of Woody being either a CI or inside person for anything or none of that kind of stuff.
All right, what do we know,
anything.
Mr. Atkins?
He didn't know much anything. So
Tyler is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay,
sorry, he said 40 minutes, he corrected.
okay.
And so, rather than have the court wait on that,
We're gonna do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other, thing that I was looking at was I'm obtaining a certificate of service.
very true.
For Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him, since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the, on June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't, is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
And Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I'd ask for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay.
Because it was filed on.
All right. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on. Okay, that's what we're getting today.
Okay. It's, and that's in which case? This
22.
YSL case?
Yes.
Okay.
There's an odor of
So I
mendacity.
actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed
That's good.
filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay.
Without the exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she gonna be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Okay.
I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm gonna.
All right, would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Meldick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right.
Okay.
And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to
those jail calls.
Okay, wasn't that your task?
Your Honor, I will speak with Mr. Shard.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday before we had all of our more explosive motions put before the court that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe 2 items that you thought you could work out everything, and there were 2 items that were still kind of in dispute.
That may have been Ms. Hilton.
It might have been, I don't know.
Just to get him.
I was in and out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter.
To line up Ms. Potter and to speak with another member of our office.
Okay, so we will take another break and be back whenever you let a deputy know that you're ready. Okay, which hopefully won't be more than 10 minutes. All right.
Well, another break for Attorney Love to get herself together. She has to call Fadi. Yes, please subscribe and join the channel. We are here. This is Biz Nation, man. Everybody put a Biz Nation in the chat real quick. Put a Biz Nation in the chat real quick. We are covering this whole thing today. It's been fun and real. All right. We also saw Liz live after she testified. That was very interesting, right? Very, very interesting. And yeah, she did everybody was grilling her about her testimony. And so, but she did mention one very valuable key piece that was off the record. The valuable key piece was this. Kenneth Copeland said, I have information about the Infinity and about who unalived Big Nut. And let me tell you something. The person who unalived him is not in this courtroom. They're not on the case. So that means somebody knows something, which is, and they knew that. They knew that. And they did not disclose that to the defense. That is withholding exculpatory evidence. Brady. I appreciate the Biz Nations, man. I appreciate it. I appreciate it. Chill in the building. Y'all been on it today. Y'all been on it today. Biz Nation 100. Biz Nation, baby. Let's go. She's calling these people because she need help telling the truth. She doesn't have an actual a rebuttal on anything, especially when it comes to the Brady material. If you notice, even with her witnesses, all of them, the only person she asked Brady material about was Investigator Long. The Investigator Long didn't know much of nothing either. You feel me? So she's trying to call people to say like, hey, you know, Mr. Melnick was representing Woody on a criminal case, which was before this actual judge for a bond, but at the same time, he was not representing him on a being a witness in this case. But Mr. Melnick said earlier this morning that he was a retained lawyer for Lil Woody. And if you are retained, it doesn't matter what case you're on. It doesn't matter if it doesn't matter about anything. You have a lawyer for whatever you need him for or her for. You know what I'm saying? So that's already been established. I'm like, so, you know, Biz Nation is still out here. Look at this. Look at the love. Look at the love. Look at the love. Yeah, look. What, phone a friend, ask the audience. What was the other one? And the two two of the wrong answers, the 50-50, yeah, them lifelines is gone. Investigator Long took a long time to explain everything exactly, and again, even he tripped up a little bit because all he did was repeat a similar conversation that was already on the transcript, which is about saying, "Hey, Booty, this is the difference between perjury. This is the difference between impeachment and prior inconsistent statements, and this is the only reason why I would, I would try to perjure you. If you admit to saying that you unalived Mr. Thomas, then I will definitely go after you for impeachment. I will impeach you, or I will, go after you for perjury on the stand. If you testify to something that you did not do. And all the crime and all the other stuff you could testify to, and we ain't gonna do nothing. But if you say that you did this and we know you didn't, then I'm gonna perjure you on that. However, she also coerced him on how, not coerced, but told him how to testify, which is what you're not supposed to do. You're not supposed to tell your witness what to say after you ask them a question. You're supposed to prepare them for what will be asked of them. Okay. You're not supposed to tell them what the answer is to the questions that you're asking. You're supposed to go through that line of questioning. That's what you're supposed to do. But you can't tell your witness what their answer is supposed to be for the question that you're asking them. That's called leading the witness. You know what I'm saying? So you're not supposed to do that. Oh, but they were leading all day in that ex parte. Okay. They was leading all day in the ex parte and telling him, you can say I don't recall, you can say I don't remember, blah, 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 whatever. Just don't admit to this. You know what I'm saying? And I remember back when Woody was on the stand and they talked about, I think on the lead attorney's channel, they talked about, well, how come Woody won't just say that he unalived Nut, and then this case will be over with? Well, they already told him if you do that in the ex parte, so nobody knew about the ex parte yet. But if you do that, then hey, we're going to purge you. So again, you're impeaching your own witnesses. This is crazy. Why would you? Oh my God, this is so crazy that you have witnesses on your list that do not want to rock with you. They don't want to cooperate with you at all because you are so corrupt and you are damning, very damning in your approach to, your witnesses, which is mad crazy. Once again, I want to shout out KW and I want to shout out Katrina Lee, KW and She Lee for the cash apps today. I really, really appreciate y'all love. I appreciate y'all support. Y'all been rocking with me for 7 hours and 40 some odd minutes, and I'm telling you, I'm truly shocked, and I'm very grateful, very, very grateful that you all are part of this. And I love our chat. We have a very family structured chat, and I appreciate you correcting people earlier about their profanity and things of that nature. This is something that we don't want to tolerate in our chat room, being disrespectful to each other. We don't tolerate that. We don't have this, and this is not an ex parte conversation I'm having. This is open. This is out in the open. All right. This is out in the open. We are not about to do this. Okay. So yeah, profanity is not allowed. If you're going to try to use some curse or try to use some type of language, and you can spell it and you can misspell it, that would be the safest bet. But under review, we don't want any type of blatant profanity in the chat. So I appreciate the mods and on handling that situation. Thank you so much for doing that earlier. Can't remember who it was in particular, but thank you. Yeah, so there is another witness. Again, I think they was like 30 minutes away. And I think they didn't want the court to have to wait. So I think that's going to be tomorrow. So I guess, and I'm really like, this is almost a guarantee. We're not going to get a ruling today about these motions for mistrial. I mean, she is really the motion that she's sitting on the most is this Kendrick motion. Yeah, Gotti's motion, the supplement motion, the motion that had the word yentas on the inside of it. she is really not. She is not for the games when it comes to that at all. You know what I'm saying? And so she's sitting on that. And you welcome, K Dub, anytime. I appreciate you. I mean, anytime. I appreciate. I'm gonna shout y'all out anytime, man. We all family around here, man. And thank you again. But yeah, she's sitting on that motion, and very interesting that she's sitting on that motion, and she's also considering the new motion that your boy Max Sharp has. Oh man, let me see. I think I got it. Still well remedies after second ex parte. I can open it up. I think. Mm-hmm. That that our boy Max got. This is the motion right here, and it's I know y'all not gonna be able to see it. I'm not gonna blow it up right now because we still on break from court. Because Miss Love don't know how to get her stuff together. But I may go over this expert. I may go over this particular motion like on a video, or something like that. I'm not gonna do it today. Again, this motion was filed on the 2nd, which was Friday, I believe, right during lunch break, I believe. When he filed a motion. So yeah, exactly. She leave the motion that she said she would have in over the weekend. That motion has not been addressed. Okay. And I'm pretty sure if another witness is coming in and she's talking about jail calls and stuff like that that they need to do, then it sounds like mistrial motion won't be ordered today. That's what it seems like. So, I was hoping for at least we can get through a motion, at least one. She took care of them bond hearings fast. You know what I'm saying? She denied all those. You know what I'm saying? So we just got the Kendrick motion out there, but now we have this and also Bruce Harvey, I think she denied his, right, in court, orally, I believe. She denied his where, he was asking for a mistrial because of the new changes, because of a new judge in the middle of a trial. I think that's another one that she said, hey, I'm very well capable to do this. So that motion is going to be denied. So she's been on a denying spree when it comes to a lot of these motions. But those particular mistrial motions with Yak Gotti and with and also with Stillwell a motion that Mad Max did, those motions are still up in the air. You know what I'm saying? Especially the Yak Gotti one. And I believe they're all interconnected anyway. So if one is a mistrial, they pretty much once a mistrial is all of them is probably gonna be mistrial for sure. You know what I'm saying? So they're all a part of the same indictment. So it is what it is. But yeah, definitely this is a very, very this has been a very, very interesting day. Seriously. Very interesting day. There's a lot to recap too. Because Melnick came with the heat, you know what I'm saying? And he did not answer any type of questions that he spoke about with his client. He did not mention any of those things. He kept true to his integrity on that. You know what I'm saying? Even though he doesn't represent Mr. Copeland anymore, he still is not going to disclose what he said to his client, which is what he's doing exactly what he's supposed to do. Caleb Bumpus was oh, man, that was hard to watch, y'all. That was hard to watch. I ain't gonna lie. That was hard to watch because with her not being able to remember something that happened in her presence, and especially with that much intensity on it, that meeting was very intense. And to not remember that is just, I don't understand. And you're a lawyer. And as a lawyer, one of your jobs is to retain information. You got to have that skill set to retain information. And if you can't retain information, I don't know, you can't be my lawyer, man. I mean, I can remember things when I was a young man, and like intricate things that happen. That's a very intricate moment in your career, in your life, of having an ex parte meeting with a chief judge of the Fulton County, a district, and having all that intensity around you. Like that's something that you would think would be unforgettable, but apparently that's not the case. So, and what was the most interesting thing to you all today? What was the most interesting part of the day for you all? Um, what kind of what was interesting? I think uh, um, the way your girl Love went around that table, man. I'm telling you, I cannot let that down. Oh my goodness, she walked around that table like she ran runway with it, and tooted her hind parts in front of Mr. Melnick like kiss it, and I'm like, yo, this is crazy, man, crazy. But I think the most interesting thing is that Brady information. That Brady information was very interesting. It's crazy she can't remember when it only happened 2 months ago. Exactly. I mean, 2 months ago, like, especially with all this intensity that you're referring to, it was a very emotional, intense. She said a high emotional intensity was in the room. Okay, well, if that's the case, I would be paying more attention, actually. And so that's one of the things that I noticed, and I think all of us have noticed this about Miss Bumpus. There's no shade to her, is the fact that she gets easily distracted. And that right there, I can't I can't rock with that. You know what I'm saying? I can't rock with you, my lawyer. You're easily distracted. No, I need you on point. I need you on point, especially if I'm retaining you. I need you on point. Abundance says seeing Kayla on the stand was interesting for me. It was for me too. I think that was the most interesting part. Um, Mr. Melnick just came to clear his name up, you know what I'm saying, and stuff like that, which is cool. And he spoke the truth, and he did what he's supposed to do. But Kayla had the information that we all were trying to figure out. You know what I'm saying? But this is something that that material, that information that you knew, even though it was off the record, you knew that this actually took place in that same meeting, and you did not, and you withheld that information from the defense. That is, and it's exculpatory. On top of that, that is the textbook definition of Brady violation. So yeah. So seeing her understand that information was I think was the key to this day. All right, for us to open up the door to all of this that we're looking at now. And yeah, but I need her to start remembering stuff. Chill. I've been in and out of live, but the fact that she cannot recall things was ridiculous. I totally agree. Totally agree.
All right.
We are back. Let's go.
Mrs. Potter?
So Judge, my request is that the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
Oh.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on. I should have looked. There are some empty chairs.
I mean, what just happened, man? Come on now. Yeah, but just going back to that, I don't think that as a lawyer, you not being able to recall things, that's not a good look. So I agree with you on that, Chill. That it was kind of ridiculous. Everybody was like, "Yo, you can't remember, what just happened? Like a couple months ago, like Ricky E just said. Like, come on now, it just happened a couple months ago." She Lee says pretty much she didn't reach the lady and wants to try again in the morning. Yep, that's exactly what we just witnessed. Yes, indeed. Yes, indeed. Yep. She said she wanted to get the lady to testify, but she could try to get her in the morning. I guess she's still far away. And then something else happened where some people wasn't ready in the court. So I'm not sure what's really going on right now, but they have shut the audio down, and so they don't want the public to know certain things right now, which is, hey, it is what it is. But yeah, another interesting fact is the actual interesting thing about the investigator Long testimony is the fact that he didn't really, the first witness, he really didn't add any type of value to the off the record portion. Yeah, he didn't really add any value to the off the record thing. So
That's everybody all right?
all right, here we go.
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument, and to allow us, if we decide the need to call 88 Potter. The main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the three names.
Oh, okay. So you may not need her after all, then
You know?
that's fine. Yeah, if that's all you needed her for, it's in the court record.
Wow.
And I
Okay.
have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not.
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it, sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that you keep copies, so I can get one of those too.
Man, Miss Love be getting all kind of grace, man. She gets so much grace. I'm telling you, I don't know what this lady does, but she gets all the grace in the world from the courts. I'm telling you, this is ridiculous.
that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and
Yeah,
I'll
true.
let you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24-5-507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean. And if so, we can make a copy of it and you can do whatever you want with it from there.
Yeah, you're right about that, my take. Taylor said more on her live than she did on the stand. So there you go. That's how you know where her mind is at.
Is that it?
It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think then in the record.
Yes, yes.
All right. And so what's their argument you wanted to make about that? Or just,
Just that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
all right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
It's directly in the way that he did on that
Okay.
day, yes.
Okay. All right. But we need to make some progress into I mean, I am still considering and working through Mr. Shard's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done, that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, you know, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, you know, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And Your Honor, we did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Sharp, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proper of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us to address those, so and I believe that Mr. Sharp, he can again, correct me if I'm wrong, said that he could go through that was from the August 2017 interview, a proffer from Mr. Zachary. And there's an earlier one that I think he said he's gonna go through and. Okay, he said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So, Your Honor, just now, Your Honor referenced if Mr. Copeland chooses to do something different than what he chose to do last time. Testify, I'm assuming the court means we will do it again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean.
That's what I understand.
Okay. All right, well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now.
Somebody please say something.
Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse.
I'm not challenging anything before that. But-
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on
Okay.
the 10th,
All right.
11th, or part of the.
All right, which is why I need y'all to get together on it and let's tackle that tomorrow. The nitty gritty of it, okay? All right, so that means y'all have to do that tonight if you haven't already done it. All right, anything else before we break for the evening? One more thing.
I'm so lost right now. I mean, this
All right,
is
so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly.
why are you going forward like this case is going to continue when you still don't know if you're going to do a mistrial?
All right,
or not?
anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
You see what I'm saying?
I don't know, because
This chick is wild.
we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right.
What?
All right. We're adjourned for the day.
I'm sorry, man. I'm sorry. I'm confused. Oh, I'm so confused. This is so stupid. Okay. So we're going to continue as if this trial is actually going on. However, I'm not sure if I want to do a mistrial or not because I take Brady evidence very seriously. So I'm not sure if the jurors are going to come back Wednesday. Ask me this tomorrow when I think about what I should have been thinking about over the weekend. Ask me this tomorrow. And tomorrow we'll do today. Why are we even? I don't care. Oh, my head. Why are we even continuing as if this is continuing? I don't understand. Why won't you just? Is it me? Am I off? What, Chad? Am I off? Right. Okay. I appreciate it. Like, dude, like abundance. But I'm telling you. He said, I tell you, you did tell me that. You did tell me that. Immunity order stands after you put immunity on someone to compel them to be a witness. Like that. That's no way that could be legal, man. Again, I'm telling you, prosecutors have so much power, dude. She is still trying to push this case. I mean, this is insane. This is crazy. I don't understand. Like, I don't understand either. I'm telling you guys, I am so irritated. This is so wrong. Why wouldn't you just say, you know what? I haven't made a decision now after today. Now, after all this that happened today, you find out that there was an off the record conversation that had Brady evidence in it that was withheld from the defense. And you say you take Brady violations very seriously. And then on top of that, you have witnesses who don't add any value to saying if it was not Brady. You're not going to put that into consideration. Why wouldn't you just say, you know what? I need time to think about these motions for mistrial, about these the prejudice that's going on. Prosecutorial misconduct is something that Mad Max mentioned, which I've been talking about for the last few days now. You know what I'm saying? And so it's like, why wouldn't you say, you know what, y'all, like hey y'all, y'all, I need about a couple days. Instead of Wednesday, the jurors coming in. Wednesday, I'm going to determine whether or not this is going to be a mistrial or not. And then we'll go from there. I would rather you do that than to have these people working and working with each other as if this trial is going to continue when you honestly don't know as a judge if you're going to continue the trial or not. I would just put everything on pause for right now. I would just pause everything for a minute. I would pause it, and that way I would give myself time to look over all of the evidence and all of the stuff that has happened. It is so much evidence of prosecutorial misconduct. It's not even funny. Okay. It's not even a joke. And then you have this potential Brady situation that you need to look into. That's why the judge that did Alec Baldwin's case is like a superstar. They presented Brady violation in front of her courtroom that day. She dismissed the jurors. She dismissed them for the day. And they had a hearing right then and there about this Brady evidence that was withheld against Alec Baldwin, against the defense. And she made a decision right then and there. It doesn't take it's not rocket science, man. It that's what it looks like. It definitely looks like that. Oh, my bad. KW said y'all have a good evening. You have a good evening as well, KW. I'm telling you, I don't know. I don't know, man. You know, I don't know if I'm gonna do this, if I'm gonna stream it tomorrow. I mean, we gonna have to. We gonna have to do this tomorrow because I'm telling you, we need to see this. I need to know what's going on here. This is crazy, man. This is absolutely crazy that this is not a mistrial. It's ridiculous. I'm so irritated with this lady. You got these people working as if you know the trial is going to continue, but you haven't made any order. You haven't ordered anything on those motions. So why are we playing why are we playing house? You know what I'm saying? Why are we playing house, man? Make your decision first before you got me doing all this kind of stuff. You already know Brian Steele don't like talking to Ms. Love, and Ms. Love don't like Brian Steele. They got a personal beef with each other too, especially because she don't uphold the law properly, and Brian Steele ain't with that. So why not just go ahead, make your decision first, and say, okay, I'm gonna grant a mistrial. I'm gonna do this. I'm gonna do that. I'm gonna also order this, and then that way we know where we stand. But if you telling me that if you think for 1 minute it's going to be a fair trial, knowing that you had two prosecutors who have been doing misconduct, they have been doing misconduct. You got two of them, and you're going to continue to let them on the case after they've shown you that they've been doing misconduct this whole time. That means you're gonna have to disqualify them. So who you got left? Atkins and another DA person. How you gonna continue this trial? Like, come on, man. This is crazy. Fonnie is the president of Atlanta. That, basically in a corrupt president at that. Yo, but man, we've been rocking out 8 hours and 19 minutes, y'all. I appreciate y'all so much. Atkins and Brown. I mean, yeah, but Atkins is the only one that have knowledge of this case moving forward. But you cannot let them continue, and you got to present them to the bar committee for the things they have done and what they've said behind closed doors and ex parte meetings. You just requested ex parte meetings like it's nothing. You can't do that. The rule says you have to prohibit ex parte meetings unless it has something to do with an administrative issue like scheduling or something of the nature of an emergency, a true emergency. You can't just have an ex parte meeting because you got stuff on your mind. You better go to your therapist about that junk. I mean, seriously, if you don't go to the judge and be like, hey, judge, I think I'm seeing some stuff that ain't right out there. What you see? Yeah, I saw some stuff too in the back there. They got some outside agitators back there. Yeah, they got this going on. Like, you can't do that, man, in no case like this. It shows bias, man. Glanville, Love, and Hilton, all of them are biased, man. And it shows. When the transcript came out, it shows. So this is absolutely ridiculous. I don't think this lady needs to do nothing but make her decision. She needs to think about her ruling. That's all she needs to do. All this extra stuff she's doing is just for show. It's formalities. Especially today. Today was a very interesting day. Okay. It really was a very interesting day. And there were some things that was presented before the court that had Brady, I would say Brady elements to it. All right. Because she's going to have to determine whether or not it's Brady or not. But anytime you withhold information that has exculpatory evidence, and this is your key witness, this is your star witness. Okay. And that person is saying, hey, y'all got the wrong people in the courtroom about this situation. Because I really know who did it. And I know about the infinity. I know about that infinity, and I know about who really did it. So I don't understand why you continuing with this thing, knowing that that you haven't made a decision on these motions. Not only did the motion for mistrial, was there a motion for mistrial from Weinstein, he did a supplemental motion. He added some more to it. And hey, judge, and another reason why it should be a mistrial. Because of there's a new ex parte meeting, this, that, the other, blah, 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 blah. Like, you have exculpatory reasons why you need to be out of here. And she's like taking her sweet time as if that's not the most important thing. All the bond hearings, you hurry up and skedaddle those right out of there. Yeah, let's go ahead and get rid of these bond hearings. Nope, denied. Denied. I don't even know why Markevius Huey is even sitting in there. The charge that he got is a recharge. It's a charge that they implemented in a RICO. But the indictment from then had nothing to do with RICO. The same thing they do with Boosie. They re-indicting this man. They are re-indicting this man on something that was already dismissed. How can you do this? How are you allowed to do this? Again, prosecutorial misconduct, man. I'm telling you, it impacts the lives of so many people. And I really recommend y'all watching that video that I dropped, man, yesterday. It's fantastic. I'm getting a lot of good responses about it. And it's so much more to uncover and unpack too. But yeah, this is absolutely insane. I don't get it. Those of you that are, I know a lot of people are not gonna watch this whole thing, but if you want to leave a comment afterwards, that's cool. But we're gonna go ahead and call it an evening. I'm going to I will probably go ahead and stream this tomorrow as well. I'm very interested in what she's going to be thinking and what she's going to be doing tomorrow. This witness that Miss Love is going to bring in, all that kind of stuff. I want to know what's going on with that as well. So until next time, Biz Nation, I appreciate you all. I appreciate everybody for stopping in and things like it's more emotions coming out. Oh, for sure. I'm about to go into it now and see what's popping, because I'm pretty sure it's gonna be some motions tonight. Okay, tonight for sure. It's gonna be some mistrial motions tonight. All right. So once again, I appreciate everyone. I appreciate you all watching. It's your boy Tay Biz TV. We about to go ahead and get up out of here, man. In the meantime, in between time, stay good. Stay. Hey, keep love in your heart, love for your people. And I'm gonna holler at y'all soon. All right. We see y'all tomorrow, man. Tomorrow we're gonna stream this tomorrow. We're gonna see what's going on with the YSL trial, man. Day 106, and see what pops off. All right. Peace out.
No stress, no biggie. Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my baby. Know how I'm coming. And they know what we hate. Around through that left side, low end. All of mine need more wins. If you got beef, don't come out. My young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With the boy, I'm so sane. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that in fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that bleedly before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair. Boy,